there is severe interference.
But you
Interfering.
have to do it before the GM roaster, madam. How you can file before this roast?
This is
Find out.
KLR.
Correct. How you can seek police protection in these proceedings? It's pending matter or fresh
Yes,
matter?
my lord, it is pending matter.
Give it, give it.
Appeal is decreed in our favor.
Give it, let us. No date good.
Kindly have this for tomorrow, my
Let
lord.
us see. We'll give a short date.
Petition has rendered infructuous.
Huh?
Interim order was not granted, that was challenged before the Senate report. Main petition itself is disposed of. Therefore,
Good.
okay. Preliminary
My lord's writ of mandamus.
Sister.
My lord's writ of mandamus, my lords. Mandamus, the respondent had given an undertaking to do the Podi Durasti work within 2 weeks, my lords. Undertaking was given in February, my lords. No
The
action. was
matter in
taken.
preliminary hearing list. Told it.
Your Lord's kind leave, my lord. My Lord's kind leave, my lord. Matters of the year 2023, my lord.
Give it.
Emergent notice was ordered, my lord. Last week I had moved a memo. Date is given in January, my lord. Reason is I'll have to take fresh steps, my lord. For orders which may be posted, my lord.
My lord,
Orders.
no, November 20th I moved, my lord. Today it is date as given, but not listed, my lord.
Today.
Please, for tomorrow.
Pending matter.
Yes, ma'am. For under order 1 rule 10, my lord.
Good. Orders list. Orders
Tomorrow.
Agencies, my lordship. Tashildar has issued the notice under section 104. There is a threat of the demolition. School building is there, my lordship.
Good. When was the notice issued?
A notice issued on 15 days before, my lordship.
ನಾಳೆ
There is a threat of demolition, my lordship.
ಆಯ್ತು ನೀವು ಇಷ್ಟ 15 ದಿನ ಆದ್ಮೇಲೆ
We have filed already detailed objection, but every day they are coming to school premises nearby and there is a
30 give an extra copy to the government now itself.
already served, my lordship.
ನೀವು 2:30 ಅಂದ್ರೆ ಇನ್ನೊಂದು ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಗವರ್ಮೆಂಟ್
I will serve. I will give.
ಯು ಮಸ್ಟ್ ಆಸ್ಕ್ them to get
I
instruction.
will serve.
My lord, 2016 matter, my lord. 2016 matter, my lord. It has came
ನಮ್ಮ ಮುಂದೆ
for
ಬರುತ್ತೆ 21 onwards madam. Check it, there's another code.
My lord, one matter for 4th of this month, my lord, the similar order, same order has been challenged by other petitioners.
Fresh matter.
It has been posted on 20, a connected matter has been
Good,
posted
good.
on 4th.
Fourth.
This matter may also be clubbed along with that I posted.
Yes.
4th of February, my
My
lord.
lord.
4th of December.
4th of February 26.
December.
Huh?
4th of December.
Yes.
2023 matter. KLR respond.
Give it. Note for date.
Hearing an IM and filing impeding application.
Give it. Give it.
One matter.
One matter for pending matter.
Kodi.
There are 3 matters are pending, my lord. One matter dismissed, my lord. Other 2 matters, my lord, same matter. Same ground, my lord, SASA matter. In the 2 matters, my lord, interim matters granted, they are given, my lord, trouble. But already, my lord, dismissed the one matter, my lord, same similar ground, my lord.
Kodi. Next week.
This one, this week, my lord.
My lord.
Next week.
Next week.
Tashildar issued a notice on 24/11/2024-55. Sumoto within 7 days enclose the property of belongs to some other. My lord, a layout has been formed. So by conversion order, as per this one, formed a layout. Now we want to sell the property. At the time, suddenly they issued a notice without conducting an inquiry. 230.
My lord, fresh matter, my lord.
Government ge extra copy.
ಕೊಡ್ತೀನಿ sir.
My lord, Special Deputy Commissioner cancelled the grant arbitrarily, my lord. There is a threat of changing the revenue entries and
Tomorrow.
dispossessing.
Tomorrow.
Urgent.
Tomorrow.
Refer, sir.
One
Rating.
matter was vacating, my lord. The my lord, school is running, my lord.
Kodi.
They tomorrow, tomorrow.
Pending matter, my lord. Pending the vacating stay application.
Kodi. Vacating stay reach agat kasta kodi. Yes.
This one sale 1 to 5, 6 to 15.
One. Suit number 2.
Lord, I appeal for the petitioner, my lord.
Serial
number 1, your lordship.
Wait, adjournment.
Sale number 16 to 25. Sale number 46 and 47. Sale number 48 to 51. Sale number 52 to 55. 56 to 60.
My lord, serial number 31, my lord.
Just wait. I've already called out. You wait to mention the end.
It's 56 minutes.
Yes.
Will be taken up on Monday minutes today.
We list on Monday.
Please, oblige.
Inform the other side.
Please, minutes.
Sale number 61 to 64. Sale number 65 and 66. Serial number 67, serial number 68 to 70, serial number 71 to 76, serial number 77 to 81, serial number 82 to 84. List of serial number 1 to 5.
10 days time granted for compliance of office objection. Office objections are complied. List the matter before the court forthwith. Next.
My lordship, list to serial number
five, my
4.
lord.
Huh?
List to serial number 4.
Yes.
There is some urgency, my lordship. I have complied all the office objections. One office objection.
When do you want? When do you want?
Tomorrow, my lordship.
List the matter and fresh matters list along with office objections tomorrow.
Serial number
Please.
5, my lords.
Yes.
Tomorrow, my lords. There is an urgency.
Uh,
One
but-
the objection.
Office objection.
Of
List,
2:30.
list along with office objections in fresh matters list tomorrow. Yes.
Serial number 6.
Let's see.
Serial number 1.
Weeks time granted. Same order.
Fourth time, serial number 7 and 8.
Weeks time granted. Same order.
Fifth time, serial number 9 and 10.
Fine. Weeks
Serial
time
number
granted,
9.
fine. Yes.
Serial number 9, my
Serial
lord. 1 week time may be granted, my lord.
Yes. Yes.
Please, ma'am.
Next.
Serial number 11.
Serial number 11, my lord, I have completed the office objection, my lord. They have asked for age proof of petition number 2. I'm not claiming seniority, my lord.
So when
I
do you
have
want?
complied, my lord.
When do
Today
you
itself,
want?
my lord. Today, if it's possible.
Not today. We'll have
Tomorrow.
list the matter and fresh matters list tomorrow. Yes.
Great.
7th time, serial number 12, Karnataka State.
7th, 8th, 9th, 10th, 7th, 8th, 9th, and 11th. Passover.
14 to 16.
Hmm. Yes.
History, serial number 1.
Full one day list, no? Huh? Full one day list.
Serial number 2 and 3. Serial number 4 to 7. Serial number 8 to 12.
My lord, serial number 8, my lord,
Yes.
for the petitioner. Maybe had next week, my lord.
Inform the other side.
I'll inform.
And then report to
JCCB
the,
is there.
inform the other side and report to the court officer.
Yes, sir.
List week after next.
Serial number 13 to 17. 18 to 21. 22 to 26. List one, serial number 1. Government advocate.
Lordship, since matter,
Yes.
Lordship, since matter has been listed today in the apex court, and through VC I'm appearing, I seek Lordship's pardon me, Lordship, it may be taken up on 10th, your Lordship, that,
The SLP is rejected, is it?
no, in another SLP matter I'm appearing today, so I was not able to appear physically, your Lordship. So maybe taken
At
up on
request,
10th,
at request, relist the matter on 10th.
10th, your Lordship. Much obliged.
Yes.
My lord, I'm for the petition, my lord. I have challenged the annexure A, my lord, at page number 19, my lord, dated 21st February
In
2000.
earlier occasion,
Please,
your application by you was rejected.
please,
Then how do you file once again?
my lord, not before this honorable court, my lord.
No, before the deputy commissioner,
Yes, ma'am.
it was rejected. Paras 8 and 9 of the order at page 22 and 23, there's a reference. You read para
Not by
9.
me, my lord.
Maybe, but your family.
It is with the family, but
then
the
there ends the
reasoning, my
matter.
lord, the reasoning mentioned is not
That may not
in
be,
accordance with law. my
that is not of any relevance. Once you file, res judicata operates. Even with respect to,
My lord, that
positive
order
change.
was being challenged, that earlier order was being not challenged, not
Eh?
on the merits, my lord.
no, there ends the matter. You can't come afresh.
My lord, kindly come to
Ground
at
six.
page number
Ground
6, my lord, at page number 12, my lord.
Correct, madam. How do you get over that order? DC para 9, page
Lord,
23.
kindly come at page number 11, my lord.
Page 23, para 9, you read.
Annexure H, my lord.
Page 23, para 9, you read.
Further, the pursuit on the order that 22/9/2012, SEST 125/2009 and 10 passed by the precursors in the office of the court, and it shows that the said Kuttaya, son of so and so, had preferred the said appeal against the order of first respondent, authority in SESC number so and so. And it is further showed that during the pendency of the said appeal, the legal hires of the said Kuttaya, including the appellant herein, have been brought on the record. Millard, the earlier order was being challenged not by me, Millard. The earlier order was being challenged the other legal hires, and
that is binding. That is binding, madam. Now the grant was made in favor of
Kuttaya, Millard, in 1946, Millard. In the year 1946.
Kuttaya only had filed the appeal.
No.
Present appeal is not
Not
by
present.
Kuttaya.
Not present.
First petition was.
First petition by me, Millard.
Wife.
Madam, SCST 132 of 2005.
That was being challenged by the Kuttaya.
There ends the matter.
Millard,
The father files.
Millard, kindly come to Annexure H, Millard. There is a clarification, Millard. I'll
Page.
just take
Page.
K, Annexure.
Annexure K, page number 53, Millard.
This is dismissed. This is the appeal preferred by the client.
Millard, the relevant portion I will read, Millard. Page number 56, Millard.
57.
57 onwards is the relevant, Millard. May I permit you to read?
Yes.
The second paragraph, Millard. At this stage, would be to relevant that the point out of has observed by the AC, Bangalore South Division, Bangalore, he is the order of dated 6/1/2009, impugned order herein earlier occasion. During the year 1995 and 96, Srimati Nanjamma, wife of late Kuttaya, had put forth his claim for a restoration of the land in question of alleging that the land in question was granted in favor of her husband, late Kuttaya, and that said land is alienated in violation of the land granted in a condition of the provision of section 4 and 5 of the Act. Then the Assistant Commissioner have been initiated the proceeding in case of so and so, held the inquiry into the matter, and by its order dated 24/1/1999 had rejected, and the claim of the said Srimati Nanjamma, wife of late Kuttaya, for the reason set forth therein. The said order dated 24/11/1999 of the previous Assistant Commissioner has not been challenged either by the Nanjamma or wife of late Kuttaya or anybody else. Page number 58. But now Sri Kuttaya, son of Konnaya, has again preferred the petition before the Assistant Commissioner.
Now you come to the fourth paragraph.
Please.
However,
it is clear from the record that the said Srimati Nanjamma, wife of Kuttaya, had put forth her claim of the restoration of the said land in question as long back as in the year 1995 and 96 itself. Her claim was rejected by the order of 24/11/1999 of then the Assistant Commissioner, Bangalore, South Subdivision, Bangalore. It is being decided principle of law and the rules that when once of very same subject was being decided by the authority cannot be entertained. My lord, this was being dismissed.
This particular order has been assigned in this.
This, my lord, the present writ petition. This order was being in the year 1999. Thereafter, I preferred before the DC in the year 2012, my lord, and which was being dismissed in the year 2020-22. And the same order I have been challenged, my lord. In this writ petition.
No, what about Nanjamma's case earlier? 24/11/99 order.
This is the only order I have challenged, my lord. This order was being challenged before the DC, my lord. That is Annexure A, my lord, at page number 21. At page number 19, it starts, my lord. On the
proceedings was filed by Puttaya at Annexure H. Annexure H is the order. Annexure H is petitioner is Puttaya.
That was a later.
No, just wait. Huh?
That was a later file, my lord. I am the one who filed of 1999, my lord.
My lord, with the belief, my lord. First petition was filed before the Assistant Commissioner by the Nanjamma. who is the wife of the Putaya.
Where is that order?
Annexure H, my lord.
No. Annexure
Annexure
B.
B, miss.
B, my lord.
Annexure?
B. Page 25.
Now that was rejected.
This was rejected, your lordship.
Against this, what happened?
What has happened thereafter, your lordship? One more petition was filed by the Putaya, which is annexure H, my lord.
No, this Nanjamma's order.
No, I'm taking it sequence, my lord. First, this annexure B came into existence, my lord. Approach the assistant commissioner, which is at annexure H, my lord. Page 49, my lord. I'm taking it the events, my lord, sequence. First petition was by the Nanjamma, who is the petitioner before this honorable court. That is annexure B. Subsequent to that, my lord, annexure H, which this proceeding was initiated by the late Putaya, my lord. Annexure H.
Correct. I am saying only one point. Once Nanjamma is filed, there ends the matter.
No. I'll take it. Thereafter, what has happened, your lordship? Annexure B is the first order passed by the assistant commissioner, which has been assigned in the annexure A, my lord, which is the impugn order in this writ petition.
Nanjamma's case.
Yes, my lord. First, annexure B was passed. That order has been assigned in annexure A, my lord, which is the impugn order before in this present writ petition.
What happened to Putaya's case?
Putaya case, your lordship, is annexure H, my lord, which is rejected on the ground this because Nanjamma has already preferred a petition that was decided, so another petition can't be entertained, my lord. That was the sole ground for dismissal of that.
AG accepts notice for the respondents. Emergent notice.
Interim order maybe.
AG accepts notice for respondent 1 and 2. Emergent notice to 3 to 8.
Interim order, my lord.
No. That is. Yes.
I praise for a 2 weeks adjournment.
Where is your list of dates, madam?
My lords, I will produce, my lords.
How did the scrutiny pass this file?
No, my lords, that now passed, my lords. There are office objections, my lords. I have to comply.
So when do you want it?
A week's time may be granted, my lords.
But you must comply and then say put it in fresh matters.
No, my lords, I have not.
Huh?
I have not prayed for the fresh matter list.
List the matter next week. Office objections to be complied with forthwith. Yes.
Obliged.
Grant is of the year 1986, my lord.
Where is the grant?
86.
Where is the grant certificate?
No, that is what we are seeking for, my lord. In the meantime, my lord, they issue notice saying that.
Where is the grant certificate?
Form 1, my lord. Is, annexure A, my lord, page 21. Lord, I have the typed copies, my lord. Pass.
The authority says that there is no grant certificate.
My lord.
By the petitioner. The list along with WP 7533 of 2025 on when do you want it?
But
Monday.
Not, could it be on Tuesday, 9th?
Tuesday.
Yes, Madhu.
You are the purchaser.
I am the purchaser, my lord. I have
First
purchased
sale,
in the year 2003, my lord.
Restoration 2022. 19.
2019, my lords, after the lapse of 16 years, my lord.
The AC, DC both.
AC has dismissed the application filed by the granting my lords. DC has reversed the order passed by the
In light of the contention, the first sale was in the year 2003 and proceedings for restoration initiated after undue delay in 2019. There would be stay of the order of the Deputy Commissioner at Annexure E.
Please.
Huh?
Annexure.
Annexure E.
Sorry, my lords. Annexure H, my lords.
Annexure H and proceedings pursuant thereto. AG accepts notice for the respondents 1 and 2, emergent notice 3 to 7.
Great.
6, P. Natarajan. P. Natarajan.
Now you must file a civil suit, sir. Now, no doubt, you have said that there is impersonation, charge sheet is filed, complaint is filed. But unless you set aside that sale deed, how can you expect them to do it? I'll issue notice, but I'm saying you better challenge the sale deeds on impersonation separately.
Notice maker.
Yes, AGA accepts notice for respondents 1 to 3, emergent notice to the private respondent.
7, Lingappa.
Yes.
That since 1983, I'm in possession of the property.
No, correct, but here
There are two grounds.
Hmm.
I'm two grounds and challenging Annexure G. Number one, the distance will have to be taken into consideration as in the date of the application. The distance was fixed later. Second one is Tahsildar is only a receiving authority. There are two judgments of this court. He cannot decide the application on its merits. He has to place before the committee and then the committee will decide the application. So when the distance is concerned, this on the court has taken the.
No, correct, but just 1 minute.
Yes, ma'am.
You go to
Yes.
Annexure G.
Yes, ma'am.
Page 113.
Yes, ma'am.
Third paragraph.
Yes, ma'am. E kacheriಯಲ್ಲಿ.
No, there is a reference. The committee has rejected it. No, just read.
Yes. ಈ ಕಚೇರಿ ಲಭ್ಯ ಇರುವ ಬಗರ್ಗುಂ ಸಾಗುವಳಿಯ ಸಕ್ರಮೀಕರಣ ಸಮಿತಿಯ ನಡವಳಿಯಂತೆ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ಅಕ್ರಮ ಸಕ್ರಮ ಕೋರಿ ಬಂದಿರುವ ನಮೂನೆ ಅರ್ಜಿ ಬಗ್ಗೆ ಸಮಿತಿ ಬೇಗೂರು ಹೋಬಳಿ ಗ್ರಾಮಗಳೆಲ್ಲವೂ ಮಹಾನಗರ ಪಾಲಿಕೆ 18 ಕಿಲೋಮೀಟರ್ ಒಳಗೆ ಬರುವುದರಿಂದ ಸಕ್ರಮ ಕೋರಿ ಸರಹದ್ದಿನಿಂದ 18 ಕಿಲೋಮೀಟರ್ ಬರುವುದರಿಂದ ಸಕ್ರಮ ಕೋರಿ ಬಂದಿರುವ 1 ರಿಂದ 15ರವರೆಗೆ ಗ್ರಾಮಗಳ ವಿವಿಧ ಸರ್ವೆ ನಂಬರ್ಗಳ ಅರ್ಜಿದಾರಗಳ ಅರ್ಜಿಗಳನ್ನು 94A ಪ್ರಕಾರ ಮಂಜೂರಾತಿಗೆ ಅವಕಾಶ ಇಲ್ಲ ಕಾರಣ ವಜಾಕರಿಸಲು but similar applications filed by other persons, not my application. ಎಂದು ನಮೂದಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ.
ತೀರ್ಮಾನಿಸಿತು.
That is in respect of other what they are saying is similar application. There are several applications in respect of this property. Matters are pending before this court for adjudication.
So that will find out.
Yes, my application is not rejected on this ground.
That you have to find out.
That is because the writ petition was decided only recently.
No, that is correct. That's on merits. What I'm saying, it appears on 113, the third paragraph appears to indicate that in the same village, many applications were there and they were rejected on 13/10/2003. Whether the petitioner's application is also rejected or not. 1. 2, the Tahsildar.
In respect of, sorry, I'm sorry.
It's the DC who has to take. In terms of the amended, DC will have to take. So check 1 whether there is the regularization committee has rejected. If not, then DC may have to. This may be at the most treated to be a report. DC will have to take a final call.
But just to clarify, in respect of my application, mandamus was issued on 22nd February 2024, page 55. Recently. Thereafter, the merger was prepared and they found that all these persons are in possession of the properties in 1983. Thereafter, this endorsement issued saying that this is a covered matter, kind of a thing. Saying the similar applications are dismissed, though your application is also rejected.
Let us see.
Yes, ma'am. Yes, ma'am.
In similar matters, what we have said is the Tahsildar has no jurisdiction.
Yes.
It is the DC, but under 108 CCC, the Tahsildar can forward a report to the DC in case it's ineligible. If it's eligible, it goes before the committee.
Yes.
So that procedure, let us list. AG accepts notice for the respondents list the matter in the same stage. That you point, you find out. AG accepts notice for the response. List the matter in the same stage on Monday.
Petition is challenging the Annexure A order passed by the Karnataka Appellate Tribunal.
Correct. It's only an order of remand, isn't it?
In similar matters, connected with the Supreme Court already stated.
Same order of the KAT.
My lord, I am not aware of that particular order is concerned, but my lord, if your lordship would peruse the operative portion, it is an order of remand. I am the owner of the property.
No, correct. Just 1 minute. Let us see. We'll consider.
May I?
Just 1 minute. Now, same order of KAT.
Same survey number. They are also one of the purchasers.
Fix a date. Get ready.
Yes, my lord, no doubt, please, my lord, insofar as the interim order is concerned, no doubt there was a batch of matters, my lord, pending before the disposed by the tribunal is concerned. But my submission would be, my lord, as on the date of application, filing of an application for conversion is concerned, my lord, he was not the owner of the property. My lord, it was purely based on a suppression of facts, my lord, he approached. May I point out this particular?
Correct. That we'll see. Now,
my lord, the only point, my lord, for consideration of the, my lord, the petitioner would urge is that the deputy commissioner has no jurisdiction is concerned. For a moment, please, my lord, kindly appreciate section 95.
No, I can't pass a separate order. So we'll club it. On that day you appear, I'll hear you.
But my lord, as far as interim order, please, my lord, still, my lord, the deputy commissioner has not taken any action pursuant to the order of remand is concerned. Now let the, my lord, the deputy commissioner takes his stand. Let him pass order subject to the, my lord, the order.
State it in the other matters.
All 4 matters already stated.
My lord, I am not aware. But the thing is, please, my lord, the deputy commissioner has jurisdiction. Why? Because in the event
that we'll see, you appear where after the clubbing, you file an application. We'll hear you. Let us.
But the thing is,
petitioners, no thing, sir.
Allah, the connected, where a connected matter. I was not.
No, but it's a common order.
Common order, please, my lord. I don't know. There were batch of matters.
So let us see. You put in appearance, and then you file your application. We'll
or, my lord, may I request in this way, my lord, since my lord, the deputy commissioner has not taken, not proceeded pursuant to the order of remand, the lordship may have it after 2 weeks. My lord, I'll file my statement of objections, and your lordship may consider the interim order at that relevant point of time.
No, it's already stayed. No, we can't have.
But my lord, with all fairness, my lord, I am submitting.
You file your objection.
My lord, with all fairness, I am submitting. My lord, my sincere apologies. My lord, that pursuant to the order of remand by the tribunal is concerned, please, my lord, there's not even a single date of, my lord, hearing by the deputy commissioner. My lord, a 2 week surgeon, my lord, let the matter may be disposed of in the same state itself.
No, we'll see. The petitioner submits that the order of KT challenge hearing is also subject matter of challenge in WP 33024 of 2025 and other matters in which interim order is passed. In WP 32991 of 2025. Interim order passed in the said petition reads as hereunder. Accordingly, in light of the submission that the present petition stands on parity, there would be an interim order on same grounds. Accordingly, the order at Annexure A is stayed list along with the WP 32991 of 2025. Learned Counsel appearing for the caveat, Sri Puneet submits that matter does not deserve grant of interim order. Liberty is reserved to the caveat to seek for modification of the interim order after filing statement of objections. AGA accepts notice for respondent number 1. List the matters in the week commencing from. Yes.
My lord, may I request in preliminary hearing, my lord, why? Because it's a matter of.
Not done. Yes, next.
Please.
For the petition. In the annexure E and Q.
Take out notice. AG accepts notice for response 1 to 4, emergent notice to 5 to 7.
In the meantime, there is apprehension of dispossession from the property.
For the caveat in this matter.
There would be an order of maintenance of status quo as on date till the next date. The respondents are at liberty. AG accepts notice for respondents 1 to 4. You appear for?
Caveat respond number 5.
So and so appears has entered caveat for 5. Emergent notice to 6 and 7. It's only against interim order. Let us to take out notice.
No, I will take
You have
notice.
not challenged the sale deed.
Yes, ma'am.
You have not challenged the sale deed.
No, what has happened is.
No, that sale deed you have to challenge before the civil court.
Then what has happened is, admittedly, a criminal, Deibunism, that the original owner of the property, she died in 1996. I produced the death certificate. In spite of it, in 2016, the mutation is effective in her name for 23 guntas, even though she had sold the entire land in the year 1962-64 itself. Total extent is only 4 acres. A charge sheet is filed. When Wazir impersonates her and executes the same.
Correct, but you have to at least seek for a declaration.
My only request that will do, ma'am. My only request is that mutation entry, which was made in 2000.
At least a declaration you have to.
I will do that, madam.
Let us see you take out notice. In their presence, I'll see you if I can do something.
The only request is this, because when that lady is dead, and
let them come in their
yes,
presence.
I do.
AG accepts notice for reasons 1 to 4. Emergent notice 5 and 6. Petitioner's liberty to serve. Counsel appearing for 5 and 6 before the tribunal. Consideration of interim prayer is kept open. Yes.
Much open.
Yes, government. He's saying that encroachment must be removed.
Like road is encroached and
Find out.
Earlier petition also, page number 29, other prakara, that the annexure C has to be considered as the objection and that has to be decided and order it, but that is not complied, madam.
Find out. AG accepts notice for respondents 1 to 3. Emergent notice to the 4th respondent. List the matter in the preliminary hearing list in the week commencing from. It's clarified that if there are no impediments, they if there is no, it's clarified that in the event there is no legal impediment, the respondent authorities are at liberty to take steps for removal of obstruction in accordance with law and take stand before the court by the next date. Yes.
Date.
List the matter in the week commencing from. Yes. AGA accepts notice for the respondents.
It's only for
The matter in the preliminary hearing list on. Same 12 and 16 same. AGA, yes. We'll call them together.
Yes, sir.
Different survey numbers are connected.
Not a connected matter, madam. Petitioners are different.
Different. AG accepts notice for the respondent. List the matter in the preliminary. Now, who's the private respondent?
Yes, my lord, is the respond number 4, my lord.
No, you are seeking for restoration.
Yes, implementation of the order, my lord. And now, my lord, by producing a will of a person who is very much alive.
Correct. AG accepts notice 1 to 3. Emergent notice to the 4th respondent. List the matter in the week commencing from.
In the meanwhile, my lord, now, my lord, by virtue of now he got the entries, by virtue of that earlier order, now he is trying to create third party's interest.
The 4th respondent in the interregnum is restrained from creating any third party.
Yes, much.
For petitioner, my lord, sort of writ of mandamus, my lord.
On the basis of
grant order, my lord. In pursuant to grant order, my lord.
AG accepts notice for the respondents. List the matter in the preliminary hearing in the week commencing from, yes, please.
15.
AGA accepts notice for the respondent. List the matter in the preliminary hearing list. 10 days ಆದ್ಮೇಲೆ date ಕೊಡಿ. Yes.
There is a cancellation of grant. All the Lordships on the last occasion, I said it will be disposed of with a condition under Rule 25. That's the reason, my lord. For last, my lord, 40.
Correct. Now they're saying they're going to conduct a survey to identify, according to them, it's forest land or not. After that survey, report would be forwarded to the revenue officials and appropriate order would be passed in terms of law. Till an order is passed, they will not disturb your possession.
So far as my cancellation of grant, now, my lord, the forest department is also contemplating under 64A. Apart from this, my lord, that is in respect of that they cannot encroach upon, my lord, the jurisdiction of a forest officer. That is a different, my lord. That's a different. They are contemplating, my lord, issue a 64A. That is there, my lord, the domain. Yes, in so far as the grant is concerned, my lord, what my learned friend says is, my lord, that is the assistant commissioner. The cancellation, my lord, after 4 decades, the lordship may kindly say, my lord.
No, let us see. Let us see. We'll take it step by step. We'll see. The petitioner has called in question the correctness of order passed by the Assistant Commissioner at Annexure G. In terms of the order at Annexure G, the Assistant Commissioner has made certain observations and concluded that the power of grant, cancellation of grant, is available under Rule 25(1) of the land grant rules.
Land grant.
And has directed a report to be submitted to the Assistant Commissioner while prohibiting any further durasti. AGA submits that the order at Annexure G is not a conclusive order and is only a proceeding in aid of contemplated action. Further submitted that a survey in order to identify whether the land is forest land or not would be conducted on 10th. It's further submitted that it's only after the report is prepared pursuant to the survey, and in the event there is any violation, same would be forwarded to the competent authority to take action. It is also stated that due procedure as mandated under law would be strictly adhered to insofar as the petitioner is concerned. Next, noticing the stand of learned AGA, while clarifying that the findings in Annexure G are not to be treated as a conclusive finding. The petition is disposed of as not calling for adjudication. All contentions of the petitioner as regards the order at Annexure G is kept open. Petitioner to be present at the site on 10th. Full stop. Needless to state, in light of the stand of the AGA, any further proceedings pursuant to the survey is to be done strictly in accordance with law after affording an opportunity to the petitioner to put forth his case. Accordingly, petition is disposed of.
All other
It's-
contentions of the.
Yes, all other contentions are kept open. That I have ordered. Yes.
To be, my lord.
Any action any action to be taken by the respondents is only after an order is passed. Until such time, no precipitative action to be taken.
Dreadful.
Which is the other? Which
Next
is
matter also, my lord.
same order.
Same order, same.
Same order.
Appearing on behalf of the petitioner, my lords. This is challenging annexure R, my lords, which is the notice issued by the Tahsildar. My lords, stating that the land which I am in possession since the year 1960, privately held land, is, if I may read, my lords, annexure R.
Page?
Page 167, my lords.
You're challenging R.
Yes, my lords. That is under challenge.
You take back your original. Don't give originals.
I will replace that.
It will fly away.
Yes, my lords. I'll replace that, my lords. That's the latest tax paid receipt.
No, don't keep originals here.
I'll make sure of that.
Page
167, my lords. Lords, if I may read, ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖದಂತೆ ಗ್ರಾಮಸ್ಥರುಗಳು ಮನವಿ ಸಲ್ಲಿಸಿ ಯಲಹಂಕ ತಾಲೂಕು ಜಾಲಿ ಹೋಬಳಿ ಎಂ ಹೊಸಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 86ರಲ್ಲಿ 1 ಎಕರೆ 20 ಗುಂಟೆ.
Annexure R is only a notice for you.
Yes, my lords. No, my lords, my land is a privately held land since the year 1960, my lords. And until 2024-25, my lords, I have paid taxes.
You're correct. Now, suppose.
Now they say that it's a Sarkali Gomal land.
Correct. Now, suppose after your reply, they
Lords.
were to take proceedings under 136(3) or any proceedings to cancel your grant.
Yes, my lords.
Stating it's government land or any such, then you can come. I'll keep open all your contention. You place your reply, let him pass an order. Against that you come. Now it's premature now. They only given a notice. I will clarify that I will to an order passed after considering your reply and hearing you.
Until then, my lords may kindly protect me. No precipitative action may be taken again.
Yes.
With those observations,
So far
my
as
lords wants to dispose of the matter. We were okay with that, my lords.
The petitioner has challenged the notice at annexure R, whereby the respondent, the Tahsildar, has issued a notice that the land in survey number 89 is Gomar land, and calling upon the petitioner to produce records relating to grant of land. Petitioner has raised various contentions, including that the predecessor of the petitioner had purchased the property through a registered sale deed dated 11/11/1960, and that the revenue entries stand
Yes.
in the name as on date, in the name of the petitioner as on date.
Yet to get it
Name of
rectified
the
in my name.
petitioner's husband. Full stop. Noticing that annexure R is only a notice, it may not be appropriate to entertain a writ petition at this stage. Full stop. The present proceedings initiated by the petitioner can be stated to be premature. Petitioner is at liberty to make out his reply to annexure R and be afforded an opportunity of hearing. Full stop. The respondent authorities may then proceed to record a finding as regards the stand of the petitioner in reply to the notice before initiating further proceedings. All contentions of the petitioner as raised in the writ petition and otherwise are kept open. Full stop. Needless to state, the respondent authorities not to take any precipitative action in so far as the possession of the petitioners.
Yes.
Full stop. Petitioner to be present at 11:30 a.m. AG accepts notice for respondent 1 and 2. Petition is disposed.
Obliged.
Petition is for a mandamus based on a sale deed at Annexure C, my lord. And there are challenge even mutation entries in respect of other persons, and that order has attained finality. AC order and DC order is also furnished, my lord. In spite of the same, in spite of the representations.
AG accepts notice for the respondents. List the matter in the preliminary hearing list. Preliminary hearing list. Preliminary hearing list. Otherwise, we'll give a long date. You just consider only. I'll have it in the preliminary hearing list in January. By then, you consider it. If there's no impediment, you go ahead and effect transfer. I'll list the matter in the preliminary hearing list in the week commencing from. Full stop. If it is clarified that if there is no legal impediment to proceed on the basis of the representation of the petitioner for effecting kata, authorities are at liberty to proceed.
Sale deed. A request was made. An endorsement has been issued saying that it's a granted land, it cannot be transferred. Class may kindly see page 38, Annexure G. A similar matter has been covered by judgment of this honorable court. This honorable court said, irrespective of the proceedings under the grant, mutation has to be certified based on the registered sale deed. Covered by judgment of this honorable.
Let us see. Let them take their stand. We'll see. Let them take their stand. We'll see.
Please. Kindly see paragraph number 5. There is sufficient substance in the submission of the learned counsel for the petitioner. The Tahsildar could not have declined to enter the name of the petitioner on the strength of registered sale deed. If the Tahsildar is of the opinion that initial sale made on 16/10/74 at the hands of
to find out, you have a look at this. AG accepts notice for the respondents.
There are no proceedings at all.
This is the matter in the preliminary hearing list.
Monday or
just wait.
Monday.
Government first.
ಕೊಟ್ಟಿದೆ ಅವ್ರಿಗೊಂದು
ಆಯ್ತು ಅವ್ರು ಏನಾದ್ರು ಕೇಳಿ ಹಾ
Lord, the body which was done has been cancelled, my lord, by the third respondent on a letter, my lord, issued by a political party secretary who has an axe to ground against the petition number 4. Because there are several proceedings, my lord, which was initiated by the complainant, who has nothing to do with this property, who is just a secretary of a political party. He gives a complaint.
Which order you challenge?
My lord, Annexure A, page 21, my lord.
Set aside?
Yes, set aside the body done, my lord, in respect of 4 petitioners in the different.
The original body was done in which year?
My lord, in 24-25. My lord, the revision petition is a suo motu proceedings. My Annexure A is a suo motu proceedings. My lord.
Okay, let us see. We'll see, madam. AGA accepts notice for the respondents in light of the contentions raised. That would raised that earlier body proceedings were concluded in the year.
My lord, it was concluded on my lord. 2025 mil, 20, annexure R mil,
Annexure
R,
page.
my lord, page 170, 189. Not of the producer. Huh? My lord, I'm sorry, my lord, annexure G, page 130 mil. 130, 130. 131, my lord, annexure H also might be kindly. Annexure H, page 132. Page 132. True copy of the DDLR letter, my lord, dated 19/12/2024. Approved the PODI, my lord.
And that the earlier PODI proceedings were approved on 19/12/2024. There will be stay of the order at annexure A till the next date. But what is your contention now?
My lord, it is just a politically motivated case. Now a third party who has no interest in the entire survey number. My lord, entire survey number, my lord, 9 individuals are allotted. All the 9 individuals have no objection. Politically, my lord, a secretary of a political party issues a complaint. The DDLR, my lord, directs a sumo motu proceedings, then directs the Tashildar to give a report. Tashildar gives a report that I am in possession of the property. All 4 of us are in possession of the property. He does not even look at the report. He says that we are not in possession.
Let us see. Yes. AG accepts notice for response 1 to 4.
Oblige. I request, my lord, any date, my lord, convenient.
List the matter in the week commencing from. Yes.
I'm challenging the annexure A, my lord, endorsement issued by the third respondent. My lord, stating that, my lord, the petitioner was not residing in the same address. My lord, kindly say, my lord, in view of the notification issued by the government, my lord, the survey number 86 of Chaudeshwaripura is declared as a revenue land, a revenue village. My lord, and in view of the notification, my lord, they call for application from villagers to issuance of, my lord, Hakupatra. In view of the notification, my lord, I made a application before the third respondent, annexure E, my lord. Now, my lord, without even villagers.
Just wait. AG accepts notice to the respondents. List the matter. The preliminary hearing list on Monday.
So till then, my lord, now they are.
Let us see.
Please.
On Monday we'll see.
Please.
Rights has been changed. Then I filed an appeal before the Assistant Commissioner at annexure F is the page number 46, my lord. The assistant, page number 29, sorry. Assistant Commissioner, after detailed inquiry, has rectified it, and column number 9 has inherited right. Page 29, my lord, annexure F. The last paragraph to 7 and 6, my lord, as inherited right to survival's legal heirs, their names has been indicated in the column number 9.
No, who went before the AC?
No, AC, myself. In that number 2, my first Manjulamma is my mother, and Srinivasaya and Suresh, these are the persons.
As on date, what has happened?
Now, before a stranger has again he made a claim that he is also one of the member in the family, and in the name of stranger, the deputy commissioner reversed the order of assistant commissioner and passed an order to indicate his name in column number 9.
As on date, in whose name the record?
As of the date is in the name of this appellant, this petitioner.
As
Yes.
on date.
As on the date. My appeal and request is let there not be a.
He accepts notice to respondents 1 to 3. Emergent notice to the 4th respondent. There will be an order to maintain the order of status quo as regards revenue entries as on date till the next date. EGA to take the stand in writing in 2 weeks.
Not to create third party is one important.
No, it's in your name now.
Please, my lord.
So I've stated status quo regarding revenue.
I'm obliged.
Copy.
Sir, a copy.
Yes.
I have filed an application for survey the land, my lord, and fix the boundaries, my lord.
AG accepts notice for the respondents. This is the matter in the preliminary hearing list on. Just find out.
Achoo.
It's only for conducting proceedings. Copy.
Yes, my lord.
Serial number 26.
May I please? Notes, the two office objections, my lords. One is with respect to furnishing of the type copy of the RTC, my lords. I have it and, my lords, that's ready. That is one, my lords. And as regards the prayer is concerned, my lords, they say that the order copy of the deputy commissioner is not being produced.
Petitioner files along with memo typed copy of RTC. Same is taken on record. Accordingly, office objection number 1 is overruled.
The other objection is regarding the non-production of the order of the DC, my lords. Milords, that is not yet been uploaded, nor a number is being provided, Milords. I have assigned the order of the DC at Annexure A. Milords, so order of the Assistant Commissioner at Annexure A, Milords.
The order of DC, what has the DC done now?
DC, Milords, without staying the operation of the order at Annexure A, Milords, has just issued in notice. That is why I am here before this court.
Objection at seal number 2 is overruled, accepting the explanation of the petitioner. But at least office copy of the appeal memo you have filed.
A copy of the appeal memo is filed.
So now what is the order of the AC?
Milords, we have engaged the services of Mr. Uday Olla today is not in station.
Correct.
If it can be taken up tomorrow, Milords.
If there's merit, I'll give you to read.
Please, Annexure A, Milords.
No,
the order of the Assistant Commissioner.
Your choice.
Very well, Milords. The order of the Assistant Commissioner, Milords.
It's your choice. Want it tomorrow? I take it tomorrow.
Client's instruction, Milords, is
okay.
It's tomorrow, Milords.
Release tomorrow.
For preliminary hearing.
Yes.
Please. Grateful.
Yes.
For the petitioner, my lords. One office objection is that, my lord, R2 to R6 are not made party, my lord.
Just one. Previous matter list and fresh matters list tomorrow. Yes.
My lord, one office objection is that, my lord, void annexure F, R2 to R6 are not made party, my lord. Pursuant to this, my lord, annexure G, I approach this honorable court, my lord. In the writ petition, all of them I have made party, my lords. They are the necessary party, my lord.
No, R2 to R6.
Void annexure F is not made party. That is the office objection, my lords. However, my lord, pursuant to annexure order at annexure F, I approach this honorable court in writ petition annexure G, my lord. There, my lord, whoever the party in annexure G, my lord, all of them I have made party, my lord, in this petition.
The land tribunal Bangalore East Taluk, they have to be made party.
But
because as per annexure F, page 94.
Now, what is his prayer?
The mandamus, my lord, to constitute the land tribunal and pass orders in accordance with annexure F. Now, annexure F, they have not made a land tribunal. Bangalore East as
my
party.
lord, land tribunal, my lord, currently it is not there, my lord. That is why, my lord, I approach this.
Correct. Pro forma, you make a party. I'll give you permission now. Petitioner makes a oral request to implead the land tribunal Bangalore East Taluk.
Please.
Represented by its secretary as an additional respondent. In light of the oral request made, they said request is acceded to. The land tribunal Bangalore East is arrayed as an additional respondent. Necessary amendment to be carried out. AG accepts notice for respondent number 1 and the newly added respondent.
Let's have this matter on Monday, my lord. I'll make.
I'm giving you permission.
Yes. Annexure D, my lord. It's the land tribunal's order, my lord. Where, my lord.
So you find out.
I will find.
That is the only prayer.
Please.
And then we'll dispense with notice to the private respondent.
Please.
Notice to respondent number 2 and 3 is dispensed with in light noticing the limited prayer of the petitioner being to constitute.
My lord, I make one submission.
You want to
against
seek
respondent number 2 and 3.
You want to seek interim relief?
Yes, my lord. I'm asking for
Okay, let us see.
Yes, ma'am.
Sadhvara. AG accepts notice for 1 and the newly added respondent. Emergent notice to 2 and 3. Relist the matter shortly. In the preliminary here, in the orders list on. Yes. Please. But notice must be served in their presence, I'll see.
Only office objection is, sixth respondent's name is Rajamma. It has been wrongly spelled as Rajanna in Annexure B at page 26. It's a typographical error. Rajanna bin Venkatramappa. It's Rajamma bin Venkatramappa.
The office
It is corrected in DC's order. In Annexure A, it has come as Rajamma only, appellate order.
The office objection.
Respondent number 3 in the Annexure A, my lord.
Is kept in abeyance in light of the explanation made. Yes.
Yes, madam. Your Lordship, it's a short issue, my lord. Your Lordship, can you take page 33, Annexure C? This is the family tree, my lord.
Yes.
The survey number 245/5 totally measures about 2 acres 17 guntas. Originally belonged to, my lord, this Venkatramappa. This was partitioned after his death, my lord, is partitioned amongst his 3 sons. 32, the question here is only with regard to 32.04 acres, which has fallen to the share of Naranappa, the second son. He died intestate. He left a will, my lord, in favor of the petitioners here. With whom he was staying. Will is there, registered will, my lord, as per annexure. Next, D, my lord, annexure D. Then after his death, my lord, he died in 85. After his death, Kata was changed in our names. Every Pakapode was done. Later, my lord, the first this Venkatraman's sons, he files a suit in 98 for declaration. That was dismissed for non-prosecution. They did not pursue it. Now they set up his grandson, saying that it's ancestral property. This has to come to us. So, our name is removed. The joint kata has been done now. On the basis of joint kata manner, they're trying to create third-party interest. That's the reason I seek for a stay also.
AC has directed affecting joint kata.
Joint kata.
And DC has confirmed.
Yes.
AG accepts notice for the respondents 1 to 4. Emergent notice to 5 to 14. In light of the contentions raised, private respondents are restrained from creating third-party rights till the next date.
Obliged.
That the office objection is annexure Q order passed by the deputy commissioner. Date is not forthcoming. Page number 53, 51 and 50. Annexure Q, page number 52. This is a Kandaya Adalat order passed by the deputy commissioner. All the fill in the blanks without made me as a party, without the notice. Sarkari, page number 52, annexure Q.
No, just one minute. Now, date of annexure Q is not forthcoming.
A date is not forthcoming. Kindly see the Adesha, page number 53. Page number 52. The deputy commissioner order passed in the Kandaya Adalat. Kolara Taluku Vyaptiya Kandaya Adalat.
So there's no date.
In page number 53, Adesha, Grama, Koteri, survey number, Innur Admuru, Pani column.
The office objection at CL number 1 is overruled in light of the explanation of the counsel for the petitioner that annexure Q does not bear a date. 2. Annexure to be stated correctly in prior.
That is, we have corrected the office objection.
You have corrected.
I have corrected.
The office objection at CL number 2 is stated to have been complied with. Accordingly, same is kept in abeyance. Yes.
That the land was granted 2 acre in the 1951
The grant certificate issued the 8/11/1951. Revenue entries are continued and Cody was done 1952. And new survey number given 213 for the earlier survey number is 110. Thereafter, the revenue entries are discontinued by the.
Anyhow, you take out notice. AGA accepts notice for the respondents. Stand to be taken in writing within 2 weeks. Yes.
Based on the Deputy Commissioner order, my lord, annexure to page number 55. That is the order passed by the Tahsildar. Q1, my lord. Page number 55.
No, your prayer at prayer B.
Yes.
You have said Q dated 21/1/2014. That is Q1.
Q1 is
Q1 is 6/6/2014.
What?
What is this second you say in the same column B? Quash annexure Q dated 21/1/2014.
That is, my lord, the Q1, the Adalat in the right side, my lord.
No.
The Deputy Commissioner order. Deputy Commissioner order in page number 55, Q1. That order, mutation affected by the Tahsildar on 5/6/2014.
Correct. In your prayer B, first you refer to Q1 dated 6/6/2014.
14.
Then on the fourth line, you refer to annexure Q dated 21/1/2014.
That is a Kandaya Adalat order, my lord.
No, correct. That is the order in which you said there is no date. Where is the date?
That is the date in Q1, my lord. Q1 ಅಲ್ಲಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಅದಾಲತ್ ನಂಬರ್ ಈ ಕಡೆ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಮೂಲ ಬಂದು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಆದೇಶ.
No, correct.
ಆದೇಶ
one
that is 21/1/2014 was 21/1/2014.
What?
That is the Deputy Commissioner order, Kandaya Adalat order. In the Deputy Commissioner order, no date, my lord.
Correct. Then the office objection, you could.
That is the date is refer in the Q1, my lord.
Okay, you take your stand.
Yes, I will serve.
Give a proper copy. Yes. Give a rectified copy.
Yes.
Sir, respondent put forward it, and my lord, cost title, my lord, I have given it little late, my lord. That needs to be accepted. And copy has served it in WhatsApp. That's only the amended cost title, my lord. That matter was heard last time, and your lordships directed me to give the synopsis.
Appearing for LRs of respondent 4, my lord.
Yes, madam. Are you ready?
Yes, ma'am.
Very short point for consideration, lordships. My lord, way back in the year 1970s itself.
What have you challenged now?
My lord, I have challenged the order of remand passed by the Karnataka Appellate Tribunal, lordships.
Yes.
My lord, way back in the year 1970s, my lord, if your lordships could see page number 22.
You take me through a synopsis.
Synopsis. My lord, Murray Gowda is a petitioner, my lord, M. Murray Gowda. My lord, he has issued Saguvali chit and grant certificate on 23/3/78 with respect to survey number 66 measuring 3 acres of land, my lord. My lord, this grant certificate, annexure A, my lord, page 22 is not challenged by anybody. My lord, later on, my lord, he applied for adbust to show his 3 acres extent of land. My lord, second point, my lord. Applied for Durast on the report of ADLR, it is found that Maregowda is in possession of 1 acre 8 kuntas in survey number 66 of Neralekere village and 1 acre 32 kuntas in 66, survey number 66 of Bettalli village. My lord, both are adjacent to each other. And my lord, adjacent to each other and share a common border. Tahsildar, my lord, Srirangpatna Void ordered 24/4/2000 issued modified Sagoli chit to the petitioner lordships. Annexure C, my lord, is the order, page 24. Modified Sagoli chit also, my lord, annexure D and E. My lord, that is done. Now, my lord, even according to that, my lord, mutation is also accepted. Annexure F and G. RTC extracts also, my lord, show in my name. Now, my lord, respondent number 4. My lord, his name is Mai Gowda. My lord, petitioner number name is Mari Gowda. On the ground that, my lord, he has filed an application for unauthorized cultivation of the land and that is pending. My lord, the Tahsildar, my lord, dismisses his application, the appeal, petition. Assistant Commissioner, my lord, also dismisses his appeal. Deputy Commissioner also, my lord, revision petition is filed. That is also dismissed. However, my lord, KAT, my lord, only on the sole ground that he has filed an application under unauthorized occupation, the act, my lord, the lands are overlapping. That is why, my lord, it remanded the matter. My lord, I am filing one more set of documents which I did not file it along with the petition.
No, but then you have to serve it to the other side.
I shall serve, because what they contend is, I will serve it, my lord. Definitely I'll serve it. My lord, he has already been granted with this, with the land which he claims that he is in unauthorized occupation. My lord, that is way back on 2020 lordships. 2004, my lord, sorry, April, 20th April 2004. And then, my lord, he also, my lord, gives a release deed in favor of his children. And RTC extracts are made out in his name. No, my lord, unnecessarily, my lord. Again, my lord, he says that I have filed some petition for unauthorized cultivation of the land, and land is not overlapping. And, my lord, the matter is remanded, my lord. Yes. My grant certificates are not challenged.
Sir, we'll have it next week. Just look into it, madam. Now they're saying that you have already been granted. So the ground that your application is pending cannot be a consideration to remand it further by the KAT. That's the submission they're saying.
My lord, we'll be submitting the objection statement, my lord. Time may begin.
The Land Council for the petitioner files along with memo list of documents and submits that the finding of the tribunal that matter requires reconsideration in light of the plea of the respondent that his application for regularization in survey number 66 is still pending consideration is contrary to order dated 20th April 2004 whereby grant certificate has been issued to the fourth respondent. For the say of the petitioner as regards such aspect, reads the matter in the same stage on
Monday.
Established, my lord.
It won't reach.
I'm appearing for respondent number 3 to 5, my lord. I pray for that accommodation, my lord. The on-record counsel is not in station, my lord. Henceforth, my lord, kindly grant a week's time, my lord.
Statement of objection will have to be filed. Government to AGA submit statement of objections would be filed within 2 weeks. Relist the matter in the week commencing from. Yes,
please. Petitioner. This matter was listed on Friday. The lordships have passed an order. The lordships may kindly look into that. I've served by hand on the proposed respondent number 7, where the
Tahsildar says that now the scheduled land is allotted in favor of BDCC Bank. I've implemented them.
Yes, I have filed Wakalat today. Yesterday I have received the copy, my lord. It's a week time to file my objections. Only I am the allottee.
Learned counsel so and so undertakes to appear for the seventh respondent.
Already filed
It
Wakalat.
submitted that statement of objections would be filed. Let them take the.
They have to file statement. They are the answering.
It's also permitted the Tahsildar to provide a sketch with respect to land bearing survey number 20.
May I submit the original record, Mill?
Yes.
Lordship may kindly see.
ಇದು ಅದರಿಂದ
The one what I have presented, that is a Mazar report with regard to the sketch. The black portion which is marked below, that is the encroachment area of 2.5 guntas, which is clearly stated below. Milord.
So the petitioner has encroached on 2.5 guntas.
2.5 guntas, that has already been taken, and along with that 2.5 guntas, another 2.5 guntas of the land. Construction. This was done in 2022, 2022 only.
The date says 11th August 2021.
No, but you were dispossessed in 22 itself.
Yes, if I believe
if you are leaving out this, if you are in possession, that's a different matter.
No, my only Millard's submission would be, I believe that whatever the sketch they have produced is dated 11th of August 2021. Prior to it, there are not one but several correspondences to say that there is no encroachment at all.
2922 is the sketch.
Please, and in that Mazar also it is clearly stated that notice was issued to them. They refused to sign on the date of the survey. That is what clearly states in that said Mazar.
No, also, Millards, in the earlier round of litigation, there was a clear order by the coordinate bench of this honorable court to pass considered orders upon affording an opportunity of hearing to the petitioner.
But they say that notice was given. You have
No, Millards, there was no such notice that was issued to me.
That is the Mahazar prepared.
The report clearly says.
Last occasion, I produced an application for stay. If your lordships may kindly see that.
No, but they say they prepared a sketch. They have shown the encroachment.
Prior to that, there are several round of sketch. There are several circulars issued. Correspondence also are issued.
No, but what is your document of title?
Because I have purchased. It is a registered sale deed way back in the year 1943. I've got the conversion order. Electricity is there. I've obtained license from the concerned authority to run an hotel. Straight away comes and demolishes the property. At least I could have an opportunity. That is all I am saying. When there was a clear order of status quo.
Anyhow, you file your statement of objection.
Please.
You also take a stand in writing.
Sorry, Miller.
You also take a stand in writing.
Please.
We have allotted in the survey number 91, my lordship.
Huh?
We are allotted the property in the survey number 91. We are constructing the in the government land, my lordship. What we are allotted. We have not
request
the possession of the petitioner.
I request your lordships,
They have,
make
the
one
petition
submission.
also, they have scheduled as shown as survey number 21. We have allotted in survey number 91.
The said land is adjacent to 20/1 is
20.
adjacent land of the Gomala land.
20/1.
20/1.
Is
In
it
the sketch, Milord, if your lordship may kindly see the sketch, the black portion, what is marked on the left hand side. Yes.
ಇದು ಒಳಗಡೆ ಗ್ರೀನ್ ಶೀಟ್ ಇದೆ ಗ್ರೀನ್
green. The Mazar
Yes.
Lord, in that sketch, if your Lordship may kindly see,
Huh.
on the left-hand side, what is marked as a black portion,
Huh.
till that.
Just come here, come here. You also come, please. No, which is 20/1?
This is what. This is also a land acquired by the National Railway for the government land. This portion, what is marked, the triangle portion is the land which was in their possession. That we have taken the position, and along with this portion, even in 5 guntas in our land, we have given it to the bank. Now, the entire extent of this portion is 20 bar. So we have not touched anything with regard to 20 bar.
No, they're saying that. No, now, insofar as this portion is concerned, insofar as this portion is concerned, let the bank go ahead with their construction, leaving out this for the time being. You just point it out to him. We'll find out. I'll have it on Monday. Yes. At the spot, you also ask the Tahsildar to call both of them. And once more, if you're informally, because you've already done a sketch, informally, you can point out what is the encroachment to them also. Huh? Huh. Are you ready to make another survey in their presence? Huh. Then we'll order them. The AGA submits that the petitioners, you file a copy of that sketch.
Please.
AGA submits. ಅದು ಕೊಡಿ, ಅದು ಒಂದು ನಿಮಿಷ ಸ್ಕೆಚ್ ಕೊಡಿ. AG has filed a memo, an enclosed copy of a sketch dated 22/9/2022. It's submitted that in terms of the sketch so prepared, there has been encroachment of Goma land by the petitioners, and such encroachment is demarcated in the sketch. Counsel for the petitioner submits that they were not present at the time of survey. Full stop. AGA, however, submits that in terms of the Mahazar, the petitioner's refusal to accept notice has been recorded. However, in order to ensure a quietus to the issue, the Tahsildar to conduct a survey in the presence of the petitioner as well as the 7th respondent.
Please.
Full stop. Both parties to be present before at the site on
11th, my lord, at 11:30. No?
At 11th at 11:30.
Yeah.
Relist the matter on 16th. Yes.
So they had issued one official memorandum way back on 2027.
Let us see. Let us see.
Let the bank not precipitate in construction.
The respondent bank not to take Any further steps for construction till the next date?
Great.
Yes.
The encroachment area,
Huh?
you already put up this stone mile.
ಬರೀ ಕಲ್ಲು ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿ ಪೂಜೆ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. But ಅದನ್ನ I will say something on the 16th my lordship. Till then ಏನು ಬೇಡ ಅಂತ ಆರ್ಡರ್. 16th I will submit my lordship along with the objections.
So I'll say you undertake not to take for the construction.
Just ಬರೀ ಸ್ಟೋನ್ ಅಷ್ಟೇ ಹಾಕಿರೋದು, ಬೇರೆ ಏನು ಮಾಡಿಲ್ಲ.
ಏನ್ ಬರ್ದಿದ್ದೀರಾ? Bank. So I'm only saying don't take any further steps till then. Yes.
Appeal for the petitions. It's the order of second respondent has been challenged. It's the petitioners are the owners of the property measuring to an extent of notes in survey number 80/1 to the extent of 1 acre 12 guntas.
Why is it come in orders list? Huh?
All office objections. Preliminary. Preliminary.
Why preliminary hearing list?
But still notice has not been issued. We are the owners of 80/1 to the extent of notes 1 acre 12 guntas of land. That's respondent number 5 to 15. They are the owners of 81/3.
Okay, you take out notice. AG accepts notice for response 1 to 4. Emergent notice to the private respondents. Yes.
Records are required.
Huh?
Take the government advocate. Secure the records.
Take the stand in writing within 2 weeks.
Because all revenue records have been put.
Serial number 34, my lord.
Yes.
In this matter, my lord, the only consider of representation, my lord, to do the podi, my lord. We given the applications, my lord. Thereafter, we again given a representation to consider that.
Yes, find out. Find out. AGA accepts notice for the respondent.
My lord, yes, well, objection.
Huh?
Already notice has been issued, my lord. 2 times they have taken the time to file an objection.
So you find out. ಅದು ನೋಟಿಸ್ ಬೇಡ, ಅಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆ. List the matter in the preliminary hearing list on. Yes, madam. A date ಕೊಡಿ ಅದು.
Care for the petitioner in this matter, my lords.
Yes.
My lords, this is with regard to the deemed conversion, my lords. My lords, on 29th had ordered, if my lords kindly peruse the order sheet for a moment. Beyond the stipulated period of time under 95 subclause 2, wherein.
Yes.
And also produce the judgments of this honorable
Within the time. So then you take your stand in writing, Wilson. AGA, to take the stand in writing, adverting to the aspect of deemed conversion as claimed by the petitioner. Statement of objections to be filed within 2 weeks. This is the matter in the week commencing from. Yes.
Right.
You permitted to add Tahsildar Anekal.
Petitioner makes a oral request.
In the last week, order has been passed.
Huh?
In the last week, order has been passed.
It's only come up for. So what has it come up for now?
For amending, adding of Tahsildar Anekal. Since the land parcel lies in Anekal, I have to add Tahsildar Anekal instead of Tahsildar Bengaluru.
Amendment to be carried out. We list week after next. Yes. Yes.
As far as petitioners 1 to 4 are concerned, petition is rejected.
Gauramma. On the ground, within 5 kilometers of the town municipal. So we reserve liberty for you to challenge these.
Please.
Now this is in so far as
Fifth petition.
Fifth petitioner. Then that day you what you gave? Just take me to that. So here all the 5 are there. 1 to 4. Ponnamma, Dodda Tayamma, Kenche Gowda, and Chikkire Gowda. The petitioners have sought for issuance of a writ of mandamus directing the respondent 4 and 5 to hold an inquiry as regards form number 50 filed by the petitioners, copies of which are enclosed at annexure A to E. During the pendency of the proceedings, the AGA has filed memo and produced order of the Deputy Commissioner whereby Deputy Commissioner has rejected the application of the petitioner 1 to 4 as per order dated 22/5/2025. Correct. Date is 22/5/25. 22/5/25. Full stop. Further, separate memo is filed dated 2/12/2025, enclosing copy of the order of the Deputy Commissioner rejecting the claim of the fifth petitioner, Gauramma. Isn't it? In light of the same, petition is disposed of, reserving liberty to the petitioner to take appropriate action insofar as orders of the DC rejecting the claim of the petitioner. All contention fifth petitioner ಅಂತ ಕೊನೆಯಲ್ಲಿ ಹೇಳಿದ್ವಲ್ಲ has filed a memo ಅಂತ ಬರ್ದಿದ್ದೀನಿ ಅದು 16/5 18/5/25. You must give certified copies for them. The respondents to give certified copies of the orders of rejection within 2 weeks to the petitioners to enable them to take appropriate action. Yes. Yes.
17 in AB.
17 in ANB. 31/10/2018 is the order.
And then you find out, take instruction, look into the records and say.
Please.
Or what, they have not taken possession.
No, they have not taken. I
They
have
have not
taken
taken.
instructions, my lord. They have not taken the position. Now he says it can be
Yes.
as per your lordship's order.
So we'll send it back or what?
It has to be sent.
Sent. Kodu.
ಅಲ್ಲ 15 lakhs sent it back now order pass sent it back and ಮತ್ತೆ ಲೇಟ್ ಮಾಡ್ತಾರೆ kindly pass 15 lakhs only sale consideration
ಇಲ್ಲ, that procedure. No? Now after 2 years you have challenged. Let us see. The petitioner has called in question correctness of the order at Annexure C, whereby the Assistant Commissioner has initiated proceedings under 79A and B of the Land Reforms Act and noticing violation of the said provisions has declared the sale deed dated 30/10/2013 as void and further directed vesting of land in the government free of all encumbrances. Full stop. Said order has been challenged on various grounds, including that the income of the petitioners was within the permissible limit, comma, that the authority has acted without application of mind and without specifically noticing that the petitioners nor their family members had any income from other sources except from agriculture. Full stop. It is noticed that
father purchase.
huh?
It is a father purchase.
Full stop. Peruse the observations 38 made in WP 28021 of 2025 at para 4. Full stop. Next. Taking note of the same, the order at Annexure C set aside, matters remitted for fresh consideration in light of the observations made in WP 28021 of 2025 extracted above. All contentions and minutes are kept open. Petitioner to be present before the Assistant Commissioner on. Yes.
Commissioner has purchased 0.0012
Freshman.
It doesn't matter. I have my files are not there. Maybe taken up on Monday, my lord.
Release the matter. Same stage on Monday.
Copy may be directed. So one copy.
An extra copy you give it to. Yes.
Cell number 40. Abhiraman.
Like for the certificate copy of the by today or tomorrow I will get my lot. So by today I will get the certificate copy before my lot.
My lord, I'm appearing for the impleading respondents, my lord. My impleading.
So far as impleading applicant is concerned, they have nothing to do with my claim number. Their grant is different, my grant is different. That certificate copy, my lord, on the next date.
Now state you have filed. Yes. Writ appeal is fine. Now, what has happened to the writ appeal?
My lord,
Let us,
if I may make one additional submission, my lord, the special DC order which has been submitted over here, I have also challenged that order, my lord. It is in writ petition number 21471 of 2023. That is still pending, my lord.
WP
21471 of 23. In my impleading application, my lord, I have submitted the petition copy at R4, R24.
list along with WP 21471 of 2023. Yes. Let us see. It requires hearing in the week commencing from. Yes. January ಅದು ಕೊಡಿ ಅದು 79 AB ಅದು. The petitioner has called in question the correctness of these are Lok Adalat. You can simply settle it. Petitioner has called in question correctness of the order at annexure F dated 28/11/2017, whereby the Assistant Commissioner, having initiated proceedings under 79A and B and recording a finding of violation of the said provision, has declared that the sale deed executed in favor of Ashok, son of Dase Gowda, as being void, and further directed vesting of land in the government free of all encumbrances. ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಅಂತ ಇತ್ತಲ್ಲ, ಆ ಹೆಸರು ತೆಗೆದ್ಬಿಡಿ. ಸೇಲ್ ಡೀಡ್ ಡೇಟೆಡ್ 11/5/2015. Next. Said order has been challenged on various grounds, including that Assistant Commissioner had passed an order without providing any opportunity to the petitioner. Peruse notice the observations made at para 4 in WP 28021 of 2025. Light of the same, the order at annexure F is set aside. Matters remitted for fresh consideration in light of the observations made above. All contentions are kept open. Petitioner to be present before the Assistant Commissioner without fresh notice on. Yes, accordingly petition is disposed of. What is this? at request, relist the matter in the week commencing from. Relist in the week commencing from. Just one. Which? So then you take it in writing. 43, just 43, AGA submits that they would file the statement of objections. This is the matter in the week commencing from. Yes. Yes. You have not paid court fee, madam. Court fee you'll have to pay. Court fee is not paid.
My lord, it's paid on 6/11 itself, my lord. I have made submission on that day. 6/11/2025 they are paid. The first time it had come before the pay. The receipt is with me.
It is unsafe, court fee.
The last section also I submitted.
ಇಲ್ಲಿ ಡಿಫಿಸಿಟ್ ಅಂತ ತೋರಿಸಿ ಕೊಡಿ ಚೆಕ್ ಮಾಡಿ. So what is your case?
My lord, I request my lord to see page number 88, my lord. There was a previous petition order, my lord. Where the entire proceedings are actually A and A were set aside by the Honorable Court, my lord. According to that order, my name has to be again entered in the RTC, my lord. That is not been considered. So I filing my representation once again after the disposal of the WC. But still that is not considered, my lord. Still under process. Connection again, page number 88.
This order at page 88, my lord, is being challenged now in a writ appeal.
Writ appeal.
We will not be considering the representation because it's a college ground. So till this is decided finally, my lord, we will not be able to consider the representation.
Take your stand in writing, please. EGA to take the stand in writing within 2 weeks. This is the matter in the week commencing from. Yes. No, they want to file objections. No, but they're saying there is some dispute. They're saying there is some dispute between the grantee and the GPA holder. Let them take the stand in writing, please. Yes, next. Let us see. Yes, next.
Petitioners 7180, 7181, and 7183.
My lords, these PTCL matters, my lords, here in 45.2 and 45.4, on the basis of your lordship order, because earlier, my lord, Mr. Leeladhar was appearing, thereafter he retired from the cases, notice was served upon the petitioner, and on last occasion, my learned friend Mr. Vishwanath undertook to file wakalat, but in other cases, not in respect of 45.2 and 45.4. Therefore, in these two cases,
45.2
and 45.4. Your lordship has categorically observed that if none appears, these two petitions will have to be dismissed for non-prosecution.
In serial number 45.2 and 45.4 are delinked and taken up separately. It is noticed that memo of retirement of earlier counsel was accepted and names of counsel for the petitioner was shown in the cause list. There is no steps taken for representation on behalf of the said parties. In WP 7182 of 2014 as well as 7184 of 2014. In light of the same, while noticing that petitioner is not diligent in prosecuting the proceedings, and despite there is no representation by legal counsel, the petition is dismissed for non-prosecution. Separate order ಮಾಡಿ 45.2 and 45.4. Pending IAs are disposed of as not calling for adjudication in light of dismissal of the petition. Yes. Yes.
Then, my lords, in other petitions, I had raised two important points, my lords. One, once the land is converted, then it is outside the jurisdiction of PTCL Acts, and I had placed reliance upon the full bench judgment in the case of Munnaya. That matter was taken up to Supreme Court, and Supreme Court has confirmed the judgment of the full bench in the case of Munnaya.
When was it converted?
My lords, it was converted in the year 1997.
First, you take me to the observation of the division bench.
My lords, your lordship may kindly. Lords, I have placed a memo with citations, my lords. In that, I have placed this judgment in Munnaya also. Memo with citation. And in Munnaya's case, your lordship may kindly come to page 29, my lords. Munnaya's case.
Yes.
Lords, 6 lines from the top. Therefore, in the case of a diverted land, the requirement of obtaining permission under section 4 subclause 2 of the Act does not arise, as the permission has to be obtained only in respect of granted land, and the land on conversion no longer remains granted land. Therefore, the issue whether an order of conversion passed by the Deputy Commissioner under section 95 of the Karnataka Land Revenue Act can be construed as prior permission by the government satisfying the requirements under 4 subclause 2 of the does not arise in the case of diverted land. The aforesaid issue is therefore answered accordingly. In view of the preceding analysis, the reference is answered accordingly.
Yes.
Then this matter was taken in SLP, my lords. In SLP Civil 21079 of 2021, and the Supreme Court wide order dated 28/1/2022 as confirmed the judgment is in Munnaya.
What is the date of conversion?
Date of conversion, my lords, will go case by case, my lords. In WP 7180 of 2014, that is in the case of Narayanappa and others. Lords, in each case, I have filed a synopsis, my lords, separately. Your lordship may kindly take the synopsis.
One by one.
Please give.
Yeah,
7180 of 2014, my lords.
Conversion on 27/12/1997.
Synopsis for 7180 of 2014, first case.
Yes.
Lords, here, my lord, the first document is the conversion order. It is dated 20 August 1997.
But there were sales before this order.
Lords,
there were sale transactions before this order.
There was sale transaction before that order also, and sale transaction subsequent to that conversion order.
Okay, so what happens to transactions before that order?
Let's,
Conversion made before transfer or transaction, then the proceeding is granted, not granted.
Insofar as,
Converted after
insofar as sale transactions, if challenged after the conversion, that would stand excluded. We'll agree with you. But the sale transactions earlier to the conversion order, if proceedings were initiated earlier,
yes,
that we have to consider.
that we have to be examined independently on other grounds. So far as this first case is concerned, the sale transaction is subsequent to the conversion order. Therefore,
what was challenged before the AC?
What was AC was the sale deed executed by the family of the grantee dated 27/12/1997.
27/12/1997. Just take me to the order of the AC.
Please. 5/7/1. Lord, the order of AC, your lordship will get at annexure B, which is dated 11/5/2012. 11/5/2012.
Yes, 24.
The proceedings were initiated in 2011-12. And the operative portion of the order of the assistant commissioner starts at page 24, running page 24, if the paginations are proper.
Annexure B.
Yes, annexure B.
Page 21.
Yes, and the operative portion of the order starts, the reasoning portion.
2011-12.
Yes, proceedings initiated 2011-12.
So we don't have to enter into the merits.
Yes, on this short ground it has to go, so far as this case is concerned. So far as 7180 of 2014 is concerned, since the conversion order was 1997, sale was subsequent to 1997.
Just one minute. So, what is the date of conversion?
Date of conversion, my lords?
In the first matter.
28/1997. 20 August 1997.
But sale was prior to that.
No.
Sale was on 27/2/1997.
Sale was
27/12 December.
But the order of the AC says 27/2.
12, my lord, typographical error. Sale deed is there, 27/12.
Sale deed is at annexure.
My lords, along with my synopsis, document number 2. Two sale. There are two sale deeds pertaining to 2 acres each. Total extent involved is 4 acres.
No, correct. 27/12.
12.
Both the sale deeds.
Both the sale. Both the sale deed 27. That is subsequent to conversion order.
So now, insofar as this writ petition,
yes,
we'll have to drop
follow
the
Munaya
proceedings.
and.
So we'll take one by one.
Yes.
WP 7180 of 2014 is delinked and taken up separately. The present petition has been filed by the grantee.
Children of the grantee.
Children of the grantee.
Legal heirs of the grantee, that would be appropriate.
Legal heirs of the grantee, calling in question correctness of the order at annexure A dated 7/12/2023. In terms of the order at annexure A, the appeal filed before the Deputy Commissioner by the purchaser came to be allowed, and the order of the Assistant Commissioner dated 11/5/2012 came to be set aside. Full stop. The order of the Assistant Commissioner at annexure B was an order passed at the instance of the legal representative of the original grantee. Full stop. Proceedings were initiated under Section 5 of the Karnataka Scheduled Castes and Scheduled Tribes Prohibition of Transfer of Certain Lands Act 1978, asserting that land was granted land and the sale of land was in violation of provisions of the Act. The Assistant Commissioner, by his order, had declared that the sale deeds as well as joint development agreement in respect of land in survey number 53 within bracket new number 92 measuring 5 acre 21 guntas situated at Dodda Hagade village, Kasba Hubli, Anekal Taluk as being null and void. Further, direction was made to the government to take over possession free from all encumbrances and restore the same in favor of the original grantee. Full stop. It is to be noticed that the sale deed, that the date of the sale deed referred to in the conclusion portion of the order of the Assistant Commissioner has been wrongly mentioned as 27/2/1997 instead of 27/12/1997. Such error would become apparent on a perusal of the sale deed dated 27/12/1997 enclosed along with the memo, which is a part of the record. Full stop. The order, as noticed above, order of the Assistant Commissioner was, however, set aside by the order of the Deputy Commissioner on certain grounds. And it is the order of the Deputy Commissioner that has been challenged in the writ petition. Next. Without entering into the detailed facts, the brief facts are that our Chikka Venkata Bovi, who is the father of the petitioner, is stated to be the original grantee. Full stop. Stated that the land came to be granted by an order of the revenue authorities, order of the Deputy Commissioner. On
Actually, my lord's grant is 28. Deputy Commissioner in the order improved.
Land came to be granted. Full stop. It is submitted that sale deeds were executed by the grantees and joint development agreement is also stated to have been entered into. Proceedings for cancellation of the sale deeds as being in violation of provisions of the PTCL Act came to be instituted in the year 2011, in the year 2011-12. Full stop. Next, it must be noticed that land has to be Act Nagaraj Act PTCL Act. Land has to be granted land in terms of section 2.
My lord, sir. In terms of section, my lord, sir.
3B, 3(1).
Yes, 3(1).
3(1)B of the Act. Full stop. as rightly pointed out by counsel for the appearing for respondent number.
That's I was on impleading application. Your lordship may formally allowed my impleading application.
You are the subsequent purchaser.
Yes. I am
Counsel
Lord's-
appearing for the subsequent purchaser.
From the
Respondent,
first respondent.
From the first respondent, that the full bench of this court in WP 60483 of 2016 has categorically held that once land is converted under section 95 of the Karnataka Land Revenue Act, it is to be treated to be diverted land and would no longer remain granted land. The full bench of this court in WP 60483 of 2016 has observed at para D as follows. Extract para D at page 28-29. Next. This next. This would make it clear that once land is diverted in terms of order under section 95 of the Karnataka Land Revenue Act, the same would cease to be a granted land under provisions of the PTCL Act. If that were to be so, question of obtaining permission for sale under provisions of the PTCL Act would not apply.
Then you come give
The order of the full bench of this court was taken up
before this
for the apex court. And the apex court in special leave to appeal 21079 of 2021 had rejected the challenge to the order of the full bench. No, but this full bench was only the reference.
My lords, yes.
But then the order then was passed. So this after the full bench reference, order was passed in the writ petition, and that must have been taken in writ appeal. And then
My lords, this full bench is the order passed in the writ petition dated 5th July 2021, which is produced, my lords, in WP 60483 of 2016. This is the order which I read out is the order.
Immediately last apex court and the said special leave to appeal came to be rejected, affirming the order of the full bench. If that were to be so, the present writ petition would have to be rejected, recording a finding that the land having been converted as per order of the DC on 20th August 1997 and copy of the order of conversion filed along with the synopsis on 24/10/2025 has resulted in change in the nature of land having been diverted in terms of order passed under section 95 of the Karnataka Land Revenue Act. It is further noticed that the sale deeds were dated 27/12/97 with respect to an extent measuring 1 acre in survey number 92 and further sale deed on the same date of 27/12/97 relating to further extent of
2 acres. 2 acres each, my lords, with both these acres.
huh?
In both these sale deeds, my lords, it is an extent of
1 acre.
both these sale deeds.
Both are 1 acre. 1 acre.
Both these sale deeds.
Full stop. Next. Admittedly, both the sale deeds were after the date of conversion. Full stop. Proceedings before the Assistant Commissioner came to be initiated only in the year 2011-12. In light of the lands not being granted lands, question of entering into other aspects on merits did not arise, and accordingly the writ petition is rejected. Now the full bench does not merely say that you need not take permission, but also says it's not granted land.
Yes.
Both.
Yes. Yes.
It's
Once
on
it
both.
is diverted, it says
Both.
But my lord, there is a subsequent bench judgment of the coordinate bench of this honorable court, where it says, my lords, if it was diverted at the instance of the grantees, then the full bench judgment is applicable. But if it is diverted by the purchaser, subsequent to purchase, then there is a distinction made by the coordinate bench of this honorable court of my lord's justice.
Correct, but here,
my lords, it was by the grantees family. Therefore, going by the full bench judgment, it is applicable. It has to.
One sentence I have. It's also noticed that the order of conversion also was at the instance of the
grantees or the legal representatives of the grantees.
No, here.
Well, here it is at the instance of the legal representatives of the grantees.
Who's this Ramaswamy bin Bodappa?
Bodappa was the grantee, my lords. Ramaswamy is the legal representative of the grantee.
In the present case, the order of conversion, it is noticed, was also at the instance of the legal representative of the grantee, which fact is not controverted. Accordingly, the writ petition is rejected and the order of the Deputy Commissioner is affirmed. So we don't have to enter into the merits.
Yes, not necessary, my lords.
Yes. Yes, next.
7181 of 2014. Here, my lords, the conversion order, which I have produced along with the synopsis, is dated 2/12/1997.
Synopsis with the memo of citations. The order of
conversion by the Deputy Commissioner
is dated
is 2/12/1997. And this was in respect of a land measuring 1 acre 20 guntas out of total extent of 4 acres involved in this petition.
No, so here it has to be demarcated.
Yes, my lords. Yes, my lords, there is.
Now you tell which is the other clear petition, we'll take it, then we'll come to that. If they require some hearing, we'll fix a date and we'll take it up.
In all other petition, there is some.
So you file your synopsis, we'll take up this next week.
Yes, ma'am.
List the other matters next week date today. Now you get ready on the rest. We'll see. Yes.
But in the last matter, my lords, in the last matter, that
Which
is
one?
WP 7191 of 2014, where my learned friend Mr. Leeladhar is appearing. There is one more short ground, my lords, without entering into merits, it can be dismissed. Here, my lords, the very same grantee, the very same person initiated PTCL proceedings earlier. That petition came to be dismissed and attained finality before the assistant commissioner.
On merits.
On merits. Thereafter, suppressing that, he files once again initiates PTCL proceedings. Therefore, my lords, now in light of the latest judgment of the Apex Court, which says that these principles of res judicata applies even to quasi-judicial authorities. In the list of authorities, my lords, I had produced. Your lordship may kindly take the judgment in the case of Fame Constructions. Fame.
ಕೊಟ್ರೆ ನಾವು ಎದ್ರ ಬಗ್ಗೆ ಯಾರೋ ಕನ್ಫರ್ಮ್ ಹೇಳ್ತೀವಿ ಎರಡು ಕೊಡೋದು ಇಮೇಲ್
ಆಯ್ತು ಅಲ್ಲ ಅವ್ರಿಗೆ ಅಷ್ಟು ಅಸಮಾಧಾನ ಇದೆ ಇದನ್ನು ಈ ಸ್ಕೀಮ್ ಒಂದಿನ ತಗೊಂಡು
Filed on?
May pass on this, my lords.
Yes.
ಕೊಟ್ಟಿದ್ದೀವಿ ಇನ್ನೂ ಒಂದು Fame Constructions Civil Appeal 26654 of 2020, Fame Makers Private Limited versus District Deputy Registrar Cooperative Society, Civil Appeal 26654 of 2023.
Paragraph?
My lords, I'm sorry, my lords, I have handed over my copy.
Para 11.
Yes.
Ujjambai versus State of UP.
Yes.
The previous order was passed on merits, sir.
On merits. It is observed in the impugned order. If your lordship now takes WP 7191 of 2014,
yes,
and annexure A, your lordship may kindly come to page internal page 6 of the order, my lords. From the bottom, unnumbered paragraph, my lords, so penultimate paragraph. This apart, your lordship got it, my lords. This apart, as contended by the appellant, one Venkatappa son of Dodda Abbaya, Shri D.V. Narayanappa son of Venkata, and Shri D.V. Krishnappa son of Venkatappa, second respondent herein, against the appellant herein, had claimed restoration of the land in survey number 53, new survey number 54, measuring 4 acres 1 guntas, situated at Doddagadde village, that the assistant commissioner, having initiated proceedings under section 5 of the act in case number K SC/ST 65, 65, 67, 2008, by his order dated 31/5/2010, had dropped the proceedings while rejecting the claims of the petitioner herein. Thus, the matter has already been decided one, and it cannot be taken up for fresh inquiry. Relied on the decisions reported in so and so, so and so, so and so. Thus, on this ground also, the order dated 21/9/2012 impugned herein also bad in law and does not stand in the eye of law.
Let us see. Now you'll have to answer this question.
ಕೊಡ್ತೀವಿ ಇದು ಇವಾಗಲೂ ಹೇಳ್ದೆ ಇನ್ನೊಂದ್ಸತಿನೂ ಕೊಟ್ಟಿದ್ದೀವಿ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ.
So, but the legal position appears to be
whether the said order has communicated to the parties concerned. That aspect has to look into.
That is,
when the order has not been communicated to the parties concerned, then the order is not next in the eye of law.
He is the person who initiates. Therefore, there is no question of communicating. He is not the respondent. He is the person who is the applicant initiating proceedings under the PTCL Act. If that is decided on merits and dismissed, He cannot once again initiate one, he has to challenge that. That remains final.
You are the petitioner in that.
He was the petitioner, he was the applicant.
If it's announced in open court, there ends the matter.
Next, you address that aspect.
HA just checked. They want to know if the order was passed in open court. Otherwise, you produce the order sheet. There
Yes.
is it.
Date,
Relist the matter on.
Let's see.
9th, 10th, 11th, 12th.
Even if he is not aware of pronouncement of that order, now that he has to challenge that order subject to limitation.
Let us 10.
12th.
Friday, Monday. 15. But that's too technical a contention.
Days.
No representation on behalf of the petitioner. List the matter after winter vacation. Next.
47.
This case, I am for impleading a second, my lord. My lord, there is an.
Direction on the Tahsildar to consider my representation filing of form number 1 seeking the grant of land since I was there cultivating the land.
Form 1.
Form number 1 and the land grant to page number 10 lot annexure C is the form number 1.
Yes, government.
They will be issued the end of because he is just 42 years as of the date of 1997. He would be around 20-21 years. He would have never been in occupation for more than 4 years or to occupy land.
Yeah, whatever you take
that
your stand.
property belongs to me, my lordship.
Huh?
That property, what they're
You are the.
I'm the impleading applicant, my lordship.
No.
In this
who are you? You're the
I
owner.
filed an IA for impleading in this writ.
No. Who are you?
I am the bona fide purchaser, my lordship.
You are the purchaser.
Yes, my lordship.
He is purchaser from a party lot whose application before the Deputy Commissioner for Inams has been rejected. After the rejection of the order, somehow his vendor's name has been entered in the mutation.
Then you take your stand in writing. AJ to take the stand in writing.
In the meanwhile, my application may be allowed, my lordship.
Let us see. AJ to take the stand in writing. List the matter.
Or my lords,
Let it come. Let them come. Once they say who it was, etc., from their records, then it becomes clearer. ಒಂದು ನಿಮಿಷ ಇದರಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ನಲ್ಲ ಅದರಲ್ಲಿ ಒಂದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅದ್ಯಾವ್ದು ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ದು 718 for impleading is allowed, taking note of the amendments in the application. May say amendment to be carried out to the cost title. So let the state take the stand in writing, then we'll know who is the first, second.
please, in the meantime, I may be permitted to file statement of objection to the impleading
File. Yes. No, you file. I'm not passing an order. You can file. Yes. Who is the sixth respondent?
Now the land is notified by the KID. So now I have to arrange them as the party, common parties. No relief is sought against them. Not annexure C is the recommendation.
No, but then what happens?
Here, they will not get a grant because it comes within 18 kilometers.
So then you take a stand in writing. AGA to take the stand in writing within 2 weeks. List the matter in the week commencing from.
One submission that I will take. This is of year 1992. Even still now they want to take standard. As of date of 1992, Lord.
Yes, sir. Still, the BBMP jurisdiction as on that is.
R7 notice.
R7 and R6 and R7, my lord. In fact, they are not at all necessary parties.
It's up to you. It's up to you. If you feel.
I had made such submissions, my lord, and
Yes, so we'll
dispensed notice to R6 and 7.
already.
Previously, my lord, but
Just-
your lordship said notice to R6 and R7 should also go. Just because R6 and 7 are not appearing before the court, my lord, there was delay in proceedings. I also requested for giving permission to take out hand summons, my lord. As per the order of the court, my lord, I have served both R6 and R7. R6 has signed the hand summons, but R7, though he has received the summons, my lord, he has refused. I have filed acknowledgement to that.
No, correct. Correct. Now, once we have stated notice necessary, you take 3 times, do substitutory service, then we'll take it up.
No, my lord, there is already, R6 is already served, my lord.
By hand.
Yes, my lord.
That's not sufficient. I'm not going to accept.
The
Has to
reason,
be-
my lord, I may permitted to hand over this sketch for a moment, my lord. The reason
Not
why
on-
R6 and R7 are
I'm
not
not-
proper and necessary parties is that, my lord.
I have observed, once the court has observed, we can't argue about that. You complete service, we'll take it.
Poor man's case, my
Fresh
lord.
steps.
They are
No,
not
no.
interested in- They are not interested.
That's a
parties,
different
my lord. That is
matter.
the reason why, in spite of
Proceed.
service, they are not coming, my lord.
Proceed. That is what we can do. Take it out and take it in the newspaper. There ends the matter. There are no shortcuts to this. Fresh steps to be furnished for taking out notice to R6 for the second time. Office to put up report regarding notice issued to R7. Full stop. Petitioners simultaneously permitted to take out fresh steps to R7 as well to avoid unnecessary delay. Relist the matter week after next. Next.
Kindly a date will fix, my lord.
In the week commencing from. List the matter in the week. Yes. Next.
For the response number.
Not interior matter, kindly listen.
Interim order and operations extended till the next date.
ಇದರಲ್ಲಿ appearing for the respondent number 3 to 5. The sixth respondent is the vendor of the petitioner.
Is there?
The sixth respondent hearing is the vendor of the petitioner. Their grievance is only to participate in the proceedings before the assistant commissioner. Because they are
Now what has happened?
during the pendency of the revenue appeal, they have purchased the property, the petitioner hearing. So we have already filed impleading application before the assistant commissioner because the respondent 3 to 5 are the appellants before the assistant commissioner.
Are
the appellants, the respondents 3 to 5 hearing are the appellants.
You?
Yes, please. Now we already filed application for impleading the petitioner as a respondent number 3.
You have filed?
Yes, please. So if they have appeared and contest the proceedings before the assistant commissioner, instead of keep the matter pending before the Supreme Court. There is a one their grievance.
No, but they have sought for other.
Pending before the assistant commissioner. On the ground that, my lord, during the pendency of, initially the appeal is not against the petitioner. During the pendency of the appeal, they have purchased the property. Therefore, we have filed impleading application.
Yes. What is there?
Let them appear before the assistant commissioner. Such liberty can be, the writ petition may be disposed of.
We'll have it tomorrow.
Next week,
This is the matter in the preliminary hearing list, Monday or Tuesday. On 8th. Yes.
Great.
Week's time granted to take necessary steps as regards R7. Yes. ಅದು 51 ಒಂದು ನಿಮಿಷ 51 ಅಲ್ಲಿ ಆಮೇಲೆ 51.1 ಅಲ್ಲಿ week's time granted to take necessary steps to R6 to 11. Further, steps to be taken in case steps to be taken in respect of deceased 12 as well. Yes. Next. Yes.
Application for regularization that not has been rejected, not partially it is allowed insofar as the despite there being a recommendation not by the ADLR and not the Tashildar saying that the said extent can be regularized in my case, which is within my property. The application is rejected on the ground that not it is a Sarkari Katte.
Sarkari?
It is a Katte. Katte is not a pond. There is no pond, not in fact, that's what the report also says. And with not it was a tank, not which is.
No, correct. Now, have you take a stand in writing?
Yes, they have taken a stand in writing.
Huh? Huh?
The objection is also up by. Not this issue, not this. In fact, what they do is not by virtue of the order review. They change not A Karab to B Karab, which not is not permissible as held by the Supreme Court. Can I just show notes the village map for a moment?
No, this requires some hearing. Let us see.
This is very short. Can I request the court please turn to the page 51 for a moment?
Page?
51.
Ah.
But this is the photograph of the property. But there is nothing in the property. There is no nala. There is no tank. Earlier, not for our agriculture purpose, my vendor is I did not put up not the tank. So the private tank used for that purpose. So please then turn to the village map at page 55. So this village map not taking permit to the show not the top itself. Left side there is a line that is not my survey number 57. But
Yes. Yes.
So can you see, literally there is nothing not except that one day. That not they have no difficulty.
No, now, do you have a copy of the Akar Band? You produce it, that will have a classification of the Karab, there ends the matter. A, B or C.
We filed a statement of objections, my lord. There is no dispute that this is a Kharab. Now, what has happened is there's a committee constituted, my lord, for regularization of these A Kharab lands. This committee follows a circular which is produced by the petitioners themselves at annexure L, my lord. Basically,
complete the narration for a moment.
Oh, please.
The issue is only this, Lord. I just take notes of report also that is filed. The report also says, Lord, there is no blood nala whatsoever, no tank whatsoever. But village map notes are seen, Lord, there is no blood tank, there is no nala there also. Can you then turn to page 59 for a moment? But it is their own report. Can I request the court to please turn to the second paragraph? ಈ ಸಂಬಂಧಿ ಈ ಸಂಬಂಧ ನಿರೀಕ್ಷಿತರು ಶಿವಾ ಹೋಬಳಿ ಉಲ್ಲೇಖ 2 ವರದಿಯಂತೆ ಆಲೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 414ರಲ್ಲಿ 2.09 ಜಮೀನು ಪೈಕಿ 1.34 ಜಮೀನು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ಮೈಸೂರು ಸೋವಂತು ಅಧಿಕೃತ ಜ್ಞಾಪನಾ ಸಂಖ್ಯೆ ಸೋವಂತು ಲೇಔಟ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿಸ್ಥಿತಿ ಆಗಿರುತ್ತದೆ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 57/2ರಲ್ಲಿ 1 ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ಸೋವಂತು ಅಧಿಕೃತ ಲೇಔಟ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿಸ್ಥಿತಿ ಆಗಿರುತ್ತದೆ ಮಹಣಿಯಂತೆ 57/1 7 ಗುಂಟೆ ಹಾಗೂ 57/2 4 ಗುಂಟೆ ಏಕರ ಜಮೀನಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. Therefore, this is not disputed. ಹಾಲಿ ಪ್ರದೇಶದಲ್ಲಿ ಖುಲ್ಲಾ ಇದ್ದು ಅರ್ಜಿದಾರರ ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತದೆ ಹಾಗೂ ಈ ಪ್ರದೇಶದಲ್ಲಿ ಯಾವುದೇ ಕಟ್ಟಡಗಳು ಹೈ ಟೆನ್ಷನ್ ಲೈನ್ ಹಾದು ಹೋಗುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ ಹಾಗೂ ಸರ್ಕಾರ ಸುತ್ತೋಲೆಯಂತೆ ಮಂಜೂರು ಮಾಡಬಹುದಾಗಿದೆ ಎಂಬುದಾಗಿ ವರದಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಆದ್ದರಿಂದ ರಾಜ್ಯ ಸಮೀಕ್ಷೆಗಳು ವರದಿಯಂತೆ ಹಾಗೂ ಉಲ್ಲೇಖ ಒಂದು ಸುತ್ತೋಲೆಯಂತೆ ಮೈಸೂರು ತಾಲೂಕು ಸೋವನ್ನು ಕಸಬಾ ಹೋಬಳಿ ಸೋವನ್ನು 7 ಗುಂಟೆ ಹಾಗೂ 57/2 4 ಗುಂಟೆ ಏಕರ ಜಮೀನನ್ನು ಮಂಜೂರು.
Now what happened? Correct. Now after this, what happened before the?
This is the ADLR report. He says, Lord, please turn about after 4 lines. ಭೂಮಾಪಕರ ವರದಿಯಂತೆ ಸರ್ವೆ ನಂಬರ್ 57 ಬಾರಿ 3 ಗುಂಟೆ ಕಲ್ಲು ಮರಟಿ ಏಕರ ಬಸ್ತು ಮತ್ತು 4 ಗುಂಟೆ ಕಟ್ಟೆ, ಬಟ್ ಕಟ್ಟೆ is only issue here, ಬಗ್ಗೆ ಏಕರ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 57 ಬಾರಿ 2 ರಲ್ಲಿ 4 ಗುಂಟೆ ಕಲ್ಲು ಮರಟಿ ಬಗ್ಗೆ ಎರಡನೇ ರೀಕ್ಲಾಸಿಫಿಕೇಶನ್ ಖರಾಬು ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಇಂದ ಗುರುತಿಸಿದ್ದು ಜಮೀನು ಸ್ಥಿತಿಯಂತೆ ಯಾವುದೇ ಖರಾಬು ಕುರುಹುಗಳು ಇರುವುದಿಲ್ಲವೆಂದು ವರದಿಸುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ದಿನಾಂಕ 16 ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿದ್ದು ಸ್ಥಳದಂತೆ ಯಾವುದೇ ಖರಾಬು ಕುರುಹುಗಳು ಇರುವುದಿಲ್ಲ ಕಂಡುಬಂದಿದೆ. ಕಚೇರಿಯಲ್ಲಿನ ಸರ್ವೆ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. Please turn to the rightmost column. ಎರಡನೇ ರೀಕ್ಲಾಸಿಫಿಕೇಶನ್ ಮತ್ತು ಹಿಸ್ಸಾ ಟಿಪ್ಪಣಿಯಂತೆ 3 ಗುಂಟೆ ಕಲ್ಲು ಮರಟಿ ಬಗ್ಗೆ ಮತ್ತು 4 ಗುಂಟೆ ಕಟ್ಟೆ ಬಗ್ಗೆ ಏಕರ ದಾಖಲಾಗಿರುತ್ತದೆ. That is drawn. Now got the serial number 4, please.
Serial number
4 there.
1, 2, 3.
4 after the sketch. But there is a sketch. They show this portion which is marked with line hacked.
Now what is written as 4?
So here in that page 58.
Yes.
Bottom.
Yes.
ಈ ಬರಹ
ಈ ಚಿಹ್ನೆಯ
ಗುರುತಿನಂತೆ ಸರ್ವೆ ನಂಬರ್ಗಳಂತೆ ಸರ್ವೆ ನಂಬರ್ 57 ಬಾರ್ 1 4 ಗುಂಟೆ ಕಟ್ಟೆ ಬಗ್ಗೆ ಏಕರ ವಜಾ ಮಾಡಲಾಗಿರುವುದು. ಆದರೆ ಎರಡನೇ ರೀಕ್ಲಾಸಿಫಿಕೇಶನ್ ದಾಖಲೆಗಳಂತೆ ಮಾತ್ರ ಖರಾಬು ಚಿಹ್ನೆ ಇದ್ದ ಜಮೀನು ಸ್ಥಿತಿಯಂತೆ ಯಾವುದೇ ತರಹ ಲಗಾಯಿತರಿಂದ ನೀರು ಹರಿದು ಬರುವ ಬಗ್ಗೆ ಗ್ರಾಮ ನಕಾಶೆಯಂತೂ ಅಥವಾ ಜಮೀನು ಸ್ಥಿತಿಯಂತಲಾಗಿ ಚಿಹ್ನೆ ಅಥವಾ ಕುರುಹು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಏಕರ ಮಂಜೂರು ಬಾಬ್ತು ಅನುಮೋದಿಸಲಾಗಿ ವರದಿ ಸಲ್ಲಿಸಲಾಗಿದೆ. There is nothing now on this basis. Instead of not regularizing, please turn to page K. Page 61. The relevant portion is at page 62. Para 4.
Yes.
ಮೇಲ್ಕಂಡ ಕಲ್ಲು ಮರಟಿ ಪ್ರದೇಶ ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ 16 ಸುತ್ತೋಲೆ ಅನುಮತಿ ಪಟ್ಟಿ 1ರಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 16 3 ಗುಂಟೆ ಮಾತ್ರ ಮತ್ತು 57 ಬಾರ್ 4 ಗುಂಟೆ ಏಕರ ಪ್ರದೇಶ ಖಾಸಗಿ ಆಗಿರುತ್ತದೆ. ಮೇಲ್ಕಂಡ ಖರಾಬು ಪ್ರದೇಶವು ಎರಡನೇ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಸರ್ವೆ ದಾಖಲಾಗಿರುತ್ತದೆ. This serial number 7 and the next page 63. ಸರ್ವೆ ನಂಬರ್ 57 ಬಾರ್ 1ರಲ್ಲಿ 3 ಸಾರ್ವಜನಿಕರಿಗೆ ಉಪಯೋಗಕ್ಕೆ ಬಾರದ ಕಾರಣ ಹಿಡುವಳಿದಾರರಿಗೆ ಸೇರಿರುವ ಏಕರ ಎಂದು ಸಮಿತಿಯು ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 57 ಬಾರ್ 1ರಲ್ಲಿ ಉಳಿದ ಸರ್ವೆ ದಾಖಲೆಯಂತೆ ಕಟ್ಟೆಯಲ್ಲಿರುವ 4 ಗುಂಟೆ ಪ್ರದೇಶ ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶ ಜಮೀನು ತೀರ್ಮಾನಿಸಲಾಯಿತು. But they declare that it is not.
No, correct. That is their decision. How you can say that the decision is wrong?
It is ekara.
Maybe.
Ekara cannot
No,
be
correct. But I'm
converted.
saying regularization is not a vested right. You are asking if they want, they'll give it. The government doesn't want, they won't give it. Okay, let's see what. No, it's not a vested right. So what I'm saying means what I'm saying.
I'll point out for one judgment of the Swami Court, where this court is saying, if you want to reclassify not from A Karab is a land which can be regularized. B Karab cannot be regularized. So they cannot convert not A Karab into B Karab. That too without not giving notice to me, without informing me that I'm going to convert and treat it as B Karab.
No, they're not converting it. They're saying 4 guntas of cut. Application for regularization is being decided by them.
Yes.
So they may regularize, may not regularize. There's no vested right. Let us see what the government. Yes.
My lord, no doubt there is a recommendation for regularization, my lord, but both these recommendations say as per the circular. The circular is produced at Annexure L, my lord, which is dated 16/5/2018. The petitioner had sought for regularization of two lands, my lord.
What does the circular say with respect to A?
Circular makes out two lists, my lord. If your lordship would turn to page 66.
Yes.
Third point, my lord.
Yes.
ಕಂದಾಯ ದಾಖಲೆಗಳಲ್ಲಿ ಬರುವ ಕೆಲವೊಂದು ಖರಾಬು ಜಮೀನುಗಳನ್ನು ಅನುಬಂಧದಲ್ಲಿನ ಪಟ್ಟಿ 1 ಮತ್ತು ಪಟ್ಟಿ 2ರಲ್ಲಿ ನಮೂದಿಸಲಾಗಿದೆ. ಪಟ್ಟಿ 1ರ ಪ್ರಕಾರ ಬಳಕೆಯಲ್ಲಿರುವ ಖರಾಬುಗಳನ್ನು ಎ ಖರಾಬು ಹಾಗೂ ಖಾಸಗಿ ಎಂದು ಪರಿಗಣಿಸುವುದು. ಪಟ್ಟಿ 2ರ ಪ್ರಕಾರ ಬಳಕೆಯಲ್ಲಿರುವ ಖರಾಬುಗಳನ್ನು ಸಾರ್ವಜನಿಕ ಬಳಕೆಯಲ್ಲಿ ಬಿ ಖರಾಬು ಎಂದು ಹಾಗೂ ಸರ್ಕಾರಿ ಜಮೀನುಗಳೆಂದು ಪರಿಗಣಿಸುವುದು. Thereafter, my lord, point 4, ಪಟ್ಟಿ 1 ಮತ್ತು ಪಟ್ಟಿ 2ರಲ್ಲಿನ ಖರಾಬುಗಳು ಸರ್ವೆ ಕಾರ್ಯ ಕೈಗೊಂಡ ಸಮಯದಲ್ಲಿ ದಾಖಲು ಮಾಡಲಾಗಿದ್ದು ಅಥವಾ ಹಾಲಿ ಜಮೀನು ಸ್ಥಿತಿಯಂತೆ ಬಳಕೆಯ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸಿದ ಪಟ್ಟಿಯಾಗಿರುತ್ತವೆ ಮತ್ತು ಸೂಚಕ ಪಟ್ಟಿ ಇಂಡಿಕೇಟಿವ್ ಲಿಸ್ಟ್ ಆಗಿರುತ್ತದೆ. 7th point, my lord, ಸಮಿತಿಯು ಪಟ್ಟಿ 1 ಮತ್ತು ಪಟ್ಟಿ 2ರಲ್ಲಿ ಅಲ್ಲದೆ ಪ್ರದೇಶವಾರು ಬಳಕೆಯಲ್ಲಿರುವ ರೂಢಿಗತವಾದ ಕಾಯಂ ಜಮೀನುಗಳ ಲಕ್ಷಣಗಳನ್ನು ವಿವೇಚನೆಯುಕ್ತವಾಗಿ ಪರಿಶೀಲಿಸಿ ನಿರ್ಧರಿಸುವುದು. So the power to regularize has been given to the committee, my lord. Thereafter, my lord, if your lordships would turn to page 68. This would give out list 1 as well as list 2. The stand is whatever falls under list 1 can be regularized. List 2 is to be classified as B Kharab, subject to survey, etc. And the decision is to be taken by the committee. Now, as per the spot inspection, there is a report given that there's no such thing as cut, etc. It could be regularized, but in terms of the circular, my lord. So therefore, the committee decides
now,
that only insofar as that 4 gunte.
Correct. In the Akar Band and settlement, whether it is shown as A Kharab or B Kharab, you produce the Akar Band.
Please.
Let us see. If for any reason it is not shown as B Kharab, and in light of the thing, then we can send it back for the committee to decide.
My lord, may I make a submission? This circular is only applicable to classification of A Kharab, my lord. So all of these lands are A Kharabs. But depending on the list, so whatever comes in Patti 2 will have to be classified, considered as B Kharab is the. Now what I read out, they'll all be classified as A Kharab, my lord. But as per this circular, because of these features, they'll have to be considered as B Kharab is.
Okay, let us see. Produce the Akar Band, let us see.
It is all A Kharab itself.
No, let us see, let us see. It requires, see, it's if the circuit discretion. Let us see. You take a chance. Relist the matter in the week commencing from. Yes, you take your chance. Before another bench. Yes. Yes. I am little conservative. Yes, next. That request, relist the matter in the week commencing from. Interim order earlier granted is extended to the next date. Next. R5.
Service to R5 is awaited. It's a case where the respondent authorities have conducted the survey by overlapping the petitioner's land. Petitions by overlapping the petitioner's land. In spite of the specific directions issued by this honorable court repeatedly, they have not issued the notice before conducting the survey. Now they have conducted by overlapping the portion of it. Now today I learned some developmental activities are being taken place in my land. So an order of status quo, not to develop the land in question
No, what have you challenged now?
The order of annexure A passed by the joint director, my lord, rejecting my appeal. But as per the survey sketch at annexure H and J, the survey ADLR has fixed the boundaries, my lord, with respect to the property belonging to the fifth respondent. Wherein, my lord,
Page
page
48.
please.
Where is the respondent's property? Where is your property?
But this is like ಎರಡನ್ನೂ ತೋರಿಸೋದಿಲ್ಲ ಇಲ್ಲಿ.
So which is that? Where is it shown? Earlier, were there any POD proceedings earlier?
Please. Annexure F, my lord, is the sketch.
Page?
Page. Page 43, my lord. This is with respect to my property.
Respondent's property?
But that is in survey number 9 of Kopa village. It is shown in annexure.
Now this F at page 43 is of which year?
This is 11 and 12.
Huh?
11 and
That is your certified copy.
please.
But this you are saying is earlier to that.
Please, madam, this is earlier to that. This is relating to my property. Petitioner's property. Petition to the society is a converted land.
Yes.
Now, my lord, they have prepared annexure H and J with respect to the land in survey number 9 belonging to the respondent, my lord, wherein they have not shown the encroachment EPR. They have fixed the boundaries, my lord, overlapping on my property to the tune of 3 gutas. Then, my lord, I filed a writ petition before this honorable court. But this honorable court set aside that and issued the direction to the respondent authorities as per annexure, my lord, K. Annexure K, page 61. To carry out the annexure J and K are quashed as the Tahsildar has not considered the case of the petition on minutes, only on directing the petitioner to approach the deputy commissioner. Now, my lord, I have approached the deputy commissioner, the joint director. Joint director, my lord, without issuing notice once again, he has confirmed the earlier order, my lord, void annexure M and M1.
There was no notice to you.
There was no notice.
Have you stated that in
Your
your...
Lordship, they have, when I sought for the information about the notice, my lord, they have furnished an acknowledgement. Your Lordship, may kindly peruse page 95. 95. This is dated 23/2020. Whereas the annexure M1 and M2 are dated 22/22. That is even otherwise this was not sent to me. This is relating to another communication. I have produced the copy of that, my lord, at annexure R1. Obtained under RTI. Acknowledgement is at page 95. I'm sorry, brother, 96. Annexure R2. This is dated 23/22. Whereas annexure M1 are dated 22/22. That is before service of the alleged notice. In fact, no notice is served. Now, my request is, my lord, let them not carry out any alterations in the land in question.
The petitioner, it is noticed that the notice issued to respondent number 5 has not yet been served. Petitioner submits that this court by order in WP 31049 of 2013 disposed of on 11th June 2014 had remitted the matter after setting aside the survey reports which were enclosed as annexure J and K in the said writ petition with a direction that the jurisdictional surveyor was to conduct survey of land in presence of adjacent landowners. Submitted that subsequent to such order, though survey has been made and boundaries fixed in terms of annexure G and H. H and J as regards the respondent, private respondent, which has the effect of overlapping with the petitioner's property. Petitioner has not been issued notice. Full stop. Submitted that this aspect has been wrongly appreciated by the regional by the Joint Director of Land Records in the order at annexure A. Accordingly, subject to further consideration, there would be stay of the order at annexure A. Stay of annexure M and M1 till the next date. Relist the matter in the week commencing from. Office to put up report regarding notice issued to the private respondent.
55, for the M.
Yes.
Respondent in query has issued a passed an order for demolition. Subsequent to that, my lord, they have issued notice, my lord, for demolition, my lord. As in earlier two matters, the stay has been granted, my lord. I had filed it annexure.
Annexure?
Annexure N, my lord, the case status I had filed, my lord. N and N1, my lord.
Now, what is this order that you have challenged?
That order, my lord, for demolition order, my lord. That we are in unauthorized construction.
Annexure?
Respondent number 4 had filed a writ petition, my lord. In that writ petition, we are not made as party, my lord. So, without hearing us, my lord, the order was passed for demolition, my lord.
Where is that page?
Page 44, my lord.
Yes.
Annexure H, my lord.
Yes.
That the respondent number 4 was directed to
take appropriate action to implement annexure F.
On that, my lord, the respondent number 3 had given a notice in annexure J, my lord. That was challenged before your lordship, my lord. Since it was a notice, show cause notice, it was directed to plead before the respondent number 3, my lord.
Let us see, you take your stand in writing. There is no conversion, that you take a stand in writing. The AGA is directed to take the stand in writing. In the interregnum, there would be stay of the proceedings pursuant to annexure M. No, but it's only a notice now.
No, my lord, notice subsequent to this order, they have given.
Where is that?
Annexure M and at page 69.
No, that is a notice, isn't it?
Please, my lord. After this order, they has given the notice, my lord. After filing of this two writ petition, they have passed this, they have issued this notice. Page 69, my lord. Annexure M.
Annexure L is the order.
Please, my lord. Please, my lord. Annexure L is the order.
So annexure L you have challenged here.
Please, my lord.
There would be stay of the order at annexure L as well as the notice at annexure M and proceedings thereto, pursuant thereto till the next date. Office to put up a report regarding notice issued to R4 and R5. Yes. Page. Let us see if there's any. This is the last chance. 230.
Lords, leave, my lord. Seal number 64 is with respect to rejection of the grant, my lord, saying that it's fake. The original records should be required, my lord.
Sir, 64. So 64 on the next week on date, sir.
Court officer?
Serial number 22, third listener, will file detailed objections. Pray for some time. Third list, serial number 22, my lord. I have to file objections.
Just inform the other side.
Please.
List at request of the respondent, list the matter in the week commencing from. Yes. ಅಲ್ಲ ಅದು ಕೊನೆಯಿಲ್ಲ ಅದು ಆಫೀಸ್ objection.
This was serial number 57, TM 138.
List the matter after winter vacation.
Serial 58.
57, huh? 57.
Filed application for amendment.
Ah.
Last occasion they had issued
Put-
the government had issued an endorsement. Based on that, they have filed application.
What is the endorsement?
Uh, Endorsement dated 27/8/2008. Statement.
What was your?
It does not come with a.
No, this you have to challenge. Where is the state?
Henceforth, we have sought for amendment to seeking quashing.
You have to challenge by way of appeal. That you have to challenge by way of appeal, not by way of a writ. I'll reserve liberty for you, and then you can challenge that separately. State cuts. No, they'll ಹೊರಗಡೆ ಇರ್ಬೇಕು. I'll reserve liberty to challenge it separately. No, the petitioner. State has withered away.
Sorry,
Petitioner has sought for issuance of writ of mandamus to direct respondent 2 to 4 to consider application of the petitioner in form 53 at annexure A. During the pendency of the proceedings, the AGA has filed. Now, this one you got this during the pendency of the proceedings.
Yes, yes. They had given the last statement.
It was brought to the notice that the authorities, that the Tahsildar has rejected the request on 27/8/2008 by a separate endorsement. Right? In light of the same, the petition is disposed of, reserving liberty to the petitioner to challenge the endorsement in appropriate proceedings. All contentions are kept open. Yes. Recalling which order? Recalling which order? Huh? Pending consideration of IA for 1 of 24, petitioner is permitted to comply with the office objections. You comply, then we'll see. Huh? 22. List the matter in the week commencing from. Yes. Next. Dismissed for. No, it was dismissed on what ground? Now you comply that. Pending consideration of IA 1 of 24 and 2 of 24. Petitioners permitted to comply with the office objections. Yes.
Good.
That code itself, they got it cancelled. Then even our coding procedures are not been completed. Lordship had informed us them and also asked us whether we are ready to, on the basis of the same rates, to and our accessibility.
Fresh code.
My lord, I'm for the respond number 6, my lord. Some inconvenience today, my lord. I seek for time for today, my lord. Any date may be fixed for
Day after tomorrow. We have suggested Monday. We have suggested whether there could be a fresh board taking note of documents of both sides. There ends the dispute.
Please.
This is the matter. Now, in case you are acceptable, let there be a fresh vote on the basis of documents of title.
Please, please.
Only on that. If it requires hearing, that's a different matter.
Please. Please.
We'll list the matter in the preliminary hearing stage on Monday. You find out if on the basis of the documents, fresh vote can be done, there ends the matter.
Please.
Number 61.
So,
Lordship had directed in this matter for the petitioner before that, may I produce this particular a sketch, clearly identifying the property of the petitioner herein, which is an encroached portion in respect of a lake property is concerned. May I for a moment, please, my lord?
Just wait. What happened to the RSA?
It is not listed.
Already there is a decree against the state. It was contested.
Yes, state, you have to move the judgment, RSA.
RSA, here, we have already taken the question from all other villages. They were all surrendered.
If your lordship, for a moment, kindly peruse this particular sketch. Elru bitcoat pididare. The only acquired portion is only this, his property is concerned.
So you move the RSA and get it dismissed.
There is a categoric finding by the against the state, holding that survey number 92 is not a lake, which was the defense set up by the state in the Supreme Court.
Correct, you have to move your RSA.
I have moved my RSA, my lord. Even the state has preferred RSAs against the decree of title granted in favor of my
That you
RSA.
move your RSA.
All those three RSAs are directed to be connected, but are to be taken up together after obtaining the permission from the Honorable Chief Justice. Matter is pending for consideration before the Honorable Chief Justice, my lord. I have referred in the office. My submission has been placed on record. That apart, my lord, I have taken the.
Let us see. Then let us see if the RSA is rejected. There ends the matter.
My lord, for a moment, if your lordship may.
No, correct. In pendency of RSA, how do you?
I understand, my lord. The point would be, my lord, my submission would be, my submission to the court would be, please, my lord. Now he claims what he claims in the suit. My lord, I have produced those particular two judgments. He claims under a registered sale deed on the first aspect. On the second aspect, he contends that he has filed an application for regularization of unauthorized cultivation. Thirdly, he takes a defense of adverse possession is concerned. My lord, he has suffered a decree before the civil court against the first appellate court and before the RSA is of the year 2018. Your lordship may kindly appreciate. RSA is of the year 2018. Till today, please, my lord, he has not even secured an injunction order from the court is concerned. Now that, please, my lord, by virtue of the interim order granted, my lord, now he is squatting on the property. If your lordship would kindly peruse the aerial sketch, my lord, which has been clearly demarcated, more than, my lord, 30 persons have been, my lord, they have given up their property is concerned. For a moment, your lordship may kindly peruse the sketch. Because of his unauthorized occupation, my lord, the state, my lord, or the, my lord, the concerned persons, they are unable to develop this particular lake, my lord, which is be very useful for the surrounding villages for the very own good.
No, what? Which is the? No, just wait. No, state, what are your RSAs now? Against what?
My lord, with respect to other who has occupied, means who has been granted or occupied or in the possession. These two RSS, which one maybe which has been filed, will become except the RSS which is contesting petitioner hearing. Only in regard to that two RSA, it will become infructuous because they have already surrendered it as a lake. Then it would be the decree has to be means a compromise.
And so far as the others.
Other RSS.
Only this one.
Only this will be contesting RSA by the petitioner hearing.
Lord, why, my lord, let me put it very simply, my lord, the fact is concerned. My lord, what my learned friend would agitate, my lord, in respect of one particular person of one Lingapura, the Muniappa, my lord, there was a grant in that particular aspect is concerned. That is the reason, please, my lord, he was excluded from this present impugned proceedings in the writ petition is concerned. Now, my lord, the petitioner would take a shelter under the decree, my lord, in respect of a Lingapurad Muniappa. My lord, that case, my lord, and to the case of the petitioner is totally a different. Maybe, my lord, the state might have prepared an appeal insofar as against the decree as against Lingapur Muniappa is concerned. But that is a different aspect, and here the case of the petitioner is a totally a different aspect.
Let us see what. Now, if you don't move the RSA, what?
If Lordship has granted sufficient time to the petitioner, please, my lord, to secure a.
We can only say whatever order we pass would be subject to the outcome of the RSA and decide this. Then decide this.
Allowed, my lord, if that.
Decide this matter, I'm saying, not keep it pending. Your headache, how you are going to move the RSA? That's not this court say. No, I'm saying not on merits.
I'll just make one submission. State is trying to dispossess me on the pretext that survey number 92 is the government tax. And it is their problem. On this pretext, impugned proceedings are initiated at his feet and I am being dispossessed. In respect of that very same survey number, to the entire extent of 27 acres and 27 and odd acres, there was one person occupying with my immediate adjacent neighbor had preferred a two declaration.
They've given up. They've given up is what the state is saying.
That is wrong. State is contesting an RSA.
My lord, if your lordship,
they have given up possession is what
they or possession illa. If your lordship perus, a sketchally has no access to that particular Lingapur Muniappa and Theltarala. Out of sketch illa. If your lordship would peruse this particular pink portion, Lingapur Muniappa, out dilve illa. My lord, he is extreme to the right hand side.
I'm unable to understand. Every time I start speaking, he interrupts. My lordship,
now if you don't move your RSA and get it's your headache. That's not my headache. That's your headache. It's made that's not my headache. Whatever it is you do, you have to sort it out. However, I'm not good.
If the state has suffered a decree, and
that's on merits what you're saying. Don't argue that before me. Learned counsel for the petitioner submits an RSA filed by him is pending consideration. It's made clear that if there is no interim order obtained by the petitioner in the said regular second appeal by the next date, this court would be constrained to dispose of the present proceedings without awaiting for the outcome of the regular second appeal. List the matter in the week commencing from
19
Jan.
19 Jan. My request in this, my lord, in this.
Let us see.
19 Jan would be, my lord.
Let us see. Interim order and operation extended.
My lord, at least my impeding application may be considered.
This is not a
we'll see.
He has
Let us see. Yes, next.
Next. 62. Ajay Prabhu.
Lordship, if I may submit, the IA copy, clear copy has not been served upon.
Forget about IA for hearing. Main only you see.
A short.
Now we'll have this in B group.
It was being listed in B group.
Correct. We can't hear it in orders list.
The only question is whether the land tribunal can review its own order. They are not rival claimant nor neither owner. They filed application for amendment of the extent of land. The tribunal has granted their
correct. That there is a provision, isn't it? In case there are some minor discrepancies, Form 10 could be amended.
No, it is not our case at all. Neither the owner nor the grant has filed application. It is filed by third party.
He's not a landowner. He's not a party.
Your Lordship, what has happened is they have.
After 41 years, they have filed application for amendment.
Your Lordship may have it in B group. Senior will argue. What has happened is that applied only for 0.4 acres, but 0.67 acres has been allotted to them. My portion of the land without making an application. My Lord may.
There is mention in their favor. You kindly see page number 23.
You get the records. Huh?
Secure.
Then you have a look at it. Relist the matter on Tuesday in the same stage. Both of you have a look at the records.
Yes.
But no in-depth hearing matters before vacation. I'm just adjourning. I've got other parted matters. Yes, please.
63.
Let us see. Tuesday. Tuesday will.
63.
Yes. Much.
Bina PK.
Yes.
Beg to appear for respond number 1 to 5.
Yes.
Filing an IA. Because it's already matter was disposed of. After that, there was a direction by this honorable court to disburse the pension and gratuity benefits along with the 6% interest. So the IA is filed because the interest component, even now it is not paid. So because the petitioner is put through much difficulty because basically, even though there are 8 respondents.
Now, where is the order? You file contempt now.
That's because
No.
almost I agree.
No, where is the order? Where is the order?
The order's relevant portion is attached with the IA itself.
My lords, I have placed my objections on record to the
No,
IA.
what objection? Disposed of matter.
Please, my lord.
Ah.
The interest payable, what my lords have recorded in the final order, my lord, while disposing of the writ petition, is made subject to, my lord. They have recorded in the page 5 of their IA, my lord. Extracted, the relevant portion is extracted on page 5.
Para 12 minutes.
No. What is the direction?
That's if I may read.
What is the error in the order now? You're filing review. Then what you have filed?
What they are contending is that.
No. Why have you filed?
Because the correct respondent is not mentioned is what they are saying.
No. What is not mentioned?
That is that if I may read that parameters, if that were to be so, that is the 12th parameters. If that were to be so, the petition entitled for an interest at the rate of 6% per annum on the delayed payment of superannuation benefits. So, which respondent has to give this interest is the reason that they are giving, and they are troubling me day by day. I am asking for this amount. They are not giving this interest. They are telling we don't have a clear direction which respondent has to give, whether the airport authority has to give or whether the EPF, the government has to give. We don't have a direction.
Who has to disperse the service benefits?
No, the airport authority has to disperse it. It is very clear.
Then the interest has to be paid by them only.
Yes, sir.
Then
But they are
you
not
file
doing
contempt. No, file contempt. Why are you asking? There's nothing to be clarified. I am not going to clarify. So some clerk in their office is going to interpret my order in this fashion. You go file contempt. Let them face the music. File contempt. This you withdraw is not pressed IA for direction, reserving liberty to file contempt. You file the memo. Memo filed. In light of the same, petition is application is dismissed as not pressed. You file contempt, let him go and answer it. That's all. Why I should interpret my order when, according to me, it's clear to any person who can understand English. Yes. Now don't go and say that before the contempt court. You interpret it. Once we pass an order, it's my end. My job ends. If you must enforce it in contempt.
So we have made the payment, interest but will pass.
I'm not going to interpret so that any clerk in his office can't understand. Yes, next.
Serial number 64, Karthik.
Memo. Yes. Records you have to gather. This is the matter in the week commencing from.
Serial number 65.
Land has been granted in JNP for restoration proceedings are pending. Now my grant without cancelling my grant. Land has been allotted to respond to PMA as per annexure. Where I challenge the annexure without any point of time, no notice has been issued.
My lord, may I make a submission, my lord? The locus standi of the petitioner, admittedly, even as per the averments in the writ petition, my lord, the land has been sold in 48. The petitioner says allegedly. No records are produced as to the grant in his name, my lord. There's absolutely none except for Annexure C. Family tree has been produced, my lord, only claiming the petitioner is he's himself the legal heir of the original grantee. These records are not filed. Now, this has happened in the year 2019, my lord. Since 2019, even as per his government, since the first sale in 74, the petitioner has not been in possession. In fact, the petitioners were not even born at that time. So they have not been in possession, my lord. So this urgency that they are urging that they are going to be dispossessed.
So they're claiming some proceedings for restoration
Please, my
are
lord.
pending under the PTCL Act.
Please, my lord, they are pending. Now, even they're seeking for regrant of the land, my lord. So they're not exactly grantees at the moment, which is a land that was granted in their favor. Absolutely no documents are produced, my lord. They're simply saying that, yes, they've been granted lands. But where are these documents, my lord? And now they're seeking an interim injunction insofar as the land that has been reserved for graveyard. My lord, insofar to verify even these records, we need time, my lord. My submission would be that this does not call for granting of any sort of.
You seek for whatever relief before the deputy commissioner.
Please, my lord.
Where the deputy commissioner is not taking up the proceedings.
My lord, the next date has been posted.
Where the respondent,
May I-
order is given for annexure for the graveyard, where the respondent 3 and 4 are putting up the construction instead of 2 acres of the land.
My lord, the
No, see, now your petition is still to be allowed. Land is still, correct. Land is still to be restored to you.
Please, my lord.
Then where is your locus standi?
It's a pending adjudication. Before that, the grant itself has been cancelled.
My lord, it's by sale, my lord. It is not
cancelled. Notice to me. The grant itself has been cancelled as per annexure A.
My lord, they have themselves sold the lands, rightly or wrong. The petitioner says alleged sale dates, my lord. Admittedly, there have been sales from the year 74. They're not in possession. So this urgency they're alleging, my only submission would be this, my lord. Insofar as re-grant proceedings, that's pending before the assistant commissioner. And next date has been set down, my lords. I've produced these proceedings, if my lords may.
I can only say any action taken would be subject to the outcome of this writ petition.
Please, my lord.
Any action taken by the respondents or state would be subject to orders to be passed in this writ petition.
These, in fact, this relief they're seeking before your lordships, they may even seek before the assistant commissioner, my lord, because re-grant proceedings are pending.
Let us
there.
see. We don't know what will happen to
The
this.
respondent 3 and 4 are putting up the construction. Only the grievance is flat. Only the photographs are.
Any action taken by respondent 3 and 4 would be subject to outcome of the petition. Yes.
66, CV Rajshekar.
Here for the respondent.
You're seeking for?
It's filed in September, my lord. The order of stay that they have obtained.
What rejoinder you want to file? Get ready on the main petition. For what? Huh? Relist the matter in B group in the week commencing from. In B group, you get ready.
19th.
Or you want on the vacating stay only. List the matter in the same stage in the week commencing from.
19th.
Yes.
67.
Lord, next week.
No, not before vacation. Interim order in operation extended till the next date.
67.
Huh? EGA, submit statement of objections would be filed within 2 weeks. List the matter in the week commencing from.
19th.
The state wants to file SOB. Yes, next.
Number 68.
Appear for the petitioners in this matter, my
For the
lords.
respondent number 5, my lords. My lords, it's a key.
1 minute, just 1 minute.
Report to permanent filing, they have not even corrected.
Okay, let us. Yes, next.
Say number 68.
For the petitioners, my lords.
For the respondent number 5, my lords. My lords, the case where, my lords, there is a there are two conflicting partition deeds based on which both the parties are petitioner and respondent fire, my lords, claiming land, and the joint director, my lords, has correctly held that since there is dispute in the title or there is conflicting deeds itself, then the appropriate authority is the civil court. So, my lords, for that reason, my lords, we will go to the civil court, and this is not maintainable, my lords, this writ petition.
My lords,
It has to be
there is
heard
no
now.
such two partition deeds, my lords. My lords, kindly have it on Monday, my lords. I'll appear in physical and an argument. There is only one partition deed. As per partition deed, the parties
List
are
the
in
matter.
possession.
List the matter in B group in the week commencing from. Yes.
Much obliged.
Obliged.
There are respondent in this case.
The short question in this case is in absence of any record, even the Xerox copies of land order or the Darkhas register or the.
No records are there.
No record. Kindly peruse page number 69, Lords. Assistant Commissioner.
Yes. No, this order was affirmed by the DC.
This order was set aside by the DC, my Lords, without assigning any reason.
Page.
That is in section L, my Lords. Section L, my Lords. Yes, given the reason that the amendment has been brought into force, therefore,
That has nothing to do with this.
is the only reason given by the.
Page.
Page 118 and 119, my Lords.
Where is his reasoning?
Annexure L, my Lords.
No, then you take your stand. Now, some page 118, one line is written. ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ page 118 read.
ಕಡತ್ತೂರು ಸಭೆ ನಂಬರ್ 54 ಹೊಸ ನಂಬರ್ 111 136.
So just verify, otherwise there is nothing. The AC has clearly heard, observed that there are no documents. So now is there anything in their support, and will that be sufficient? Counsel for the petitioner submits that the Assistant Commissioner has rejected application for restoration, observing that there are no records evidencing grant. Observation that there is a mention of grant in certain records. AGA to take stand in specific stand regarding the same. Relist the matter. Vacation kinta munche onse. Interim order and operation extended till the next day. So if you were to take a stand, there is no record, there ends the matter.
Say number 70.
Respond number 14 and submission, my lord. There is a land, this is Malamashan Kunti, this is Baldaretti village. That is converted to revenue grama. We obtained a stay order, I have no objection. Whereas, al school katlikki magli tondre ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. School ಅಲ್ಲಿ ಬಿದ್ದು ಹೋಗ್ತದೆ. More than 30 years ಆಗಿದೆ ಅದು. School. ಅದು government has already sanctioned some amount to the construction of the school building. For that purpose, they are avoiding the distribution. The petitioner went to the spot and avoided to the not to allow the permit to work there.
In which survey number? In which survey number?
84, my lord.
Now the Form 7 is for which survey number?
That's why inspection is already conducted by the revenue authority, the Tahsildar and Assistant Commissioner and ADLR also. They have produced the certificate, inspection
We have
certificate.
to hear it. We have to hear it. How we can decide it now?
Please.
Is the matter?
Allah, kindly accommodate tomorrow, my lord.
No, no, not.
Allah, ಅದರಲ್ಲಿ ಸ್ಕೂಲ್ ಗೆ my request, humble request. ಅಲ್ಲಿ ಮಕ್ಕಳಿಗೆ ಸ್ಕೂಲ್ ಬಿದ್ದು ಹೋಗ್ತಾ ಇದೆ.
It has to be heard.
Allah, tomorrow. No. At least day after tomorrow.
No, no. Yes, released week after next.
Allah, date may be given, my lord.
Right, in the week commencing from.
Date may be given.
B group matters, B group. You can't file IA and have it heard.
Allah, but that is very clear. But the date could provide, but ನನಗೆ they allow the permitted to work there in the school itself, my lord. That is my humble request.
Yes, next. Interim order and operations extended till the next date.
Appearing for 71, the issued end of month connection M. The applicants made an application for restoration of Khata. In the RPC, it is mentioned as Sarkar below. The pressures are ready to pay the land revenue without holding any inquiry from the Tahsildar issued an endorsement. They are stating that there is no provision for restoration of Khata. Connection M is the endorsement. I have to submit the petitioners are the grandchildren of one Jingegowda.
No,
His name was appearing in the RTC. He died in 1971. These petitioners were not aware that this land.
Yes, government.
On a short term, this may matter be disposed of, covered by the judgment. The number of judgments are there. As long as the petitioner is ready to pay the land revenue.
No, correct. We don't know on what basis it's written as Sarkari Bilu. Let them take their stand, then we'll see. AGA to take the stand in writing within 10 days from today. Relist the matter in the week commencing from. No, we don't know on what ground it said. Let them. So let them take the stand in writing. Let them take the stand in writing. Yes. Yes.
This week, next week, 8th or 9th. Because the matter was moved several times in people.
I've given a date. I've given a date. Let us see. Yes. We have given a date. Yes.
72, Janardhan Ji.
Total email is also produced. To the law article has been sold. 4,170.
How many acres?
It is around 27 quintas. And acquired for 1800 plus 1 acre, out of which 17 quintas has been notified for
So,
the 1800 project.
so 40 quintals. 40 quintals.
Now 40, it is 40 quintals.
No. 40 quintal of Ericanet.
Yes, raw reconet, it was not cured. And before that, it was a rate of 60 rupees per kg. Now it comes to 2,45,520 rupees. And that amount.
Counsel for the petitioner has filed an affidavit stating that they have harvested Ericanet and it has been sold. Affidavit is enclosed with the details of the harvested crop. Same is taken on record. Affidavit is filed pursuant to the observation of this court in its order dated 17/11/25. Full stop. List the matter in B group in the week.
Respond on the 4th day, but I filed the application in the office yesterday to bring the LRs of respond on the 4 on record. That's my direct office.
Office to put up IA filed. Huh? Yeah.
IA filed 6.
Now notice must go.
But my friend is if they undertakes, that would be sufficient. Otherwise, I will take.
Office to list IA 4 of 25 and 5 of 25. Yes. So you had a good harvest. You have a good harvest.
That is true, but some the crops it was recognized used to fall down because of the season that it starts.
No, correct. But for 27 guntas, 40 quintal is a good harvest.
But they also, 1 acre, they also harvested.
Yes, next.
Sale number 73. Very good.
For spot number 4 million. Now, madam, PDCL, my lord, the amended act has been challenged, my lord. The coordinate bench has seized the matter.
It has also been answered by the division bench of this honorable court.
No, correct. There is some petition pending. I'll have it in B group. We'll see. It has to be heard. We'll have it in B. The coordinate bench has reserved some writ petition on the validity of the amendment. No doubt the division bench, what you are saying, has clarified, it has attained finality before the Supreme Court. Now this amendment they have challenged. Once it comes, things will become clearer. Only on limitation.
Amendment only, my lord, that has been clarified by the division.
Recently.
April 2025.
What is?
The Chief Justice. I may permit I to pass it on.
No, this we have
This
seen.
is the old.
Let us see. We'll have it in B group. Anyhow, there's a stay in your favor.
Please, this is also similar, my lord. The Assistant Commissioner holds there are no documents for grant. Surprisingly, the Deputy Commissioner passes an order looking into the documents on the available record. It is granted. There is a 67 years delay, and the competent authority has also issued an endorsement saying that those documents which are delayed are not available in the records.
The list of
Application is filed for vacating the interim order. I may pray for rejecting.
list the matter in B group in the week commencing from interim order earlier granted is extended.
26.
Yes.
Sale number 74.
I was granted 3 acres of land. Grant certificate is not issued. Therefore, I made a representation.
Yes.
My lord, the land was acquired way back in the year 1984 itself for Vishweshwaraya Memorial.
Not over. The grant is issued on Annex 3, may kindly see in page 82.
Then you take a stand in writing.
Yes, ma'am. I will put in.
EG.
Several writ petitions are prepared. Every writ petitions we have given an endorsement for him. That LSC was also filed. That was also honored.
May kindly see the endorsement.
Let us see. Let us.
Forest land Annex 90 in page 90. How many acres ground?
Let him take a stand in writing.
Much obliged.
AGA to take stand in writing within 2 weeks from today. Is the matter in the week commencing from. Yes.
75.
Respondent. I have filed a vacating interim order, my lord. There is no document, my lord, to piece of document show that the, my lord, they are the owners of the property, my lord. Based on the survey report, my lord, revenue records has been changed in the name of the petitioner, my lord. I have that respond number 4, my lord. Through will, my lord, is it the right, my lord? But the petitioners, my lord, because of their in possession, all the RTC and other revenue records has been changed in the name of the petitioners. Therefore, my lord, I filed a challenge that order before the assistant commissioner, my lord. Last occasion or Bandila Swami.
This request made on behalf of the petitioner as a last chance. Relist the matter on.
Any date, my lord. They are disturbing my possession, my lord. I am cultivating the land, my lord, from last several years.
13-1.
Meeting order is extended till the next date.
Seal number 76.
This is about an application has been filed. Seeking for an amendment to incorporate certain factors. Your
Right of way, amendment made in the application and that please are necessary in light of the subsequent event. Application is allowed, amended petition to be filed.
7. Mahesh BJ.
My lord, I have filed an application for impeding this case, my lord. I filed an application for impeding the president, my lord. This matter has come up before your lordship by special orders, my lord.
26/3/2005, at my instance, what the lordship has said that I should remove the fourth floor within a period of 5 to 6 months. And I filed an application seeking extension of that period for removal of the fourth floor. The fourth floor is only having 3 rooms. 26/3/2005 or 25 is the order. That IA you are not listed. I filed it on 9/11 itself. 9/11/2025. Here may be ordered to be listed.
No.
Extended monsoon and the medical condition of the husband of the.
No, how much time you want? You file affidavit, we'll close it. How much time you must state?
Yes, madam.
That you must state. How much time you are going to remove? Where is the order? No.
26/3/2025.
26/3/2025.
2025.
Matter was disposed of.
No, matter is pending.
No, my lord, it is pending, my lord.
So far as the court, pleading applicant, not impleading applicant is neither the complainant.
No, wait, forget.
We don't have voice now. Let him not.
I am not hearing him. Now.
26/3/2005, matter not is still pending. 248 proceedings, Lord, my appeal was dismissed again with this petition is filed. Your lordship has felt that at least if I should remove the fourth floor, which is beyond the permissible limit, regarding other aspect can be considered later.
No, how has it come before this court?
But because it came before this lordship justice,
My lord, Justice Nataraj was disabled in this matter, my lord. Therefore, by special orders, it has come up before your lordship. I have filed an application on impeding. The impeding applicant is the Talkaveri House Building Cooperative Society, my lord. They complained to the BBMP, my lord, stating the facts that a provisional order was issued in this matter. Thereafter, a proceeding was initiated and a confirmatory order was also issued. And my lord, a demolition order was also issued, my lord, as per annexure R. Please, my lord, as per annexure R4C at page 13. Thereafter, I represented to the BBMP, my lord, that no action has been taken. Meanwhile, my lord, the matter which was pending before the commissioner, my lord, was dismissed. Challenging the same, my lord, my learned friend is before this honorable court. In this matter, my lord, he gave an undertaking on 26/3/25, and he also filed an affidavit in which he stated that additional floors would be removed, my lord, within a period of 3 to 4 months.
Affidavit.
My lord, since the affidavit is dated 26/3/25, my lord.
6/3/25, my lord. On same day, my lord, the lordship has passed the order. And at some time, my lord, in view of the extended monsoon, my lord, if I remove that fourth floor, there's every chance that, my lord, the slippage.
No. So how much time you want now?
Another, please, my lord, another 3 months time.
No. In June, orders passed in June.
The lordship may also
July.
consider. No,
Huh?
the lordship may also.
My lord, order is passed in March, my lord, 26/3.
Let my lord, impeding application.
I'll refer it so moto for contempt.
No, that's true.
I'll refer it for
No, your
contempt.
lordship may kindly
It's
see.
noticed
Lordship,
that.
no, my lord, the reason I'm sorry.
No, that's not my headache.
Lordship may
That's
kindly
all.
see the
In
application.
one sentence, I say it's not my headache.
The lordship may kindly see the affidavit.
No, you said within 3 to 4 months you'll remove it.
Yes, my lord.
Orders passed in March.
Yes,
There ends the matter.
now, my lord, the lordship may kindly see. The reason I have removed the extended months.
No, so when will you remove? You tell.
Another 3 months, that is what. Or your lordship, any grant, my lord, which will be granted, any time which will be granted by my lord, will.
You tell keep your client present because he doesn't realize the seriousness of an affidavit given before the court. In his presence, we will order.
Petitioner's husband is present.
No, let the petitioner be present.
No, any time, Lord, which should be granted.
No. I want to know, let the petitioner be present. Affidavit is filed. They can't simply file just like that without application of mine.
So the affidavit was filed now.
Relist the matter in the preliminary hearing list on Monday. You bring an affidavit and you keep the petitioner present and then I'll see.
My lords, it is showing non-filing a photocopy. It may be dispensed. He himself is ready to remove the. Showing some orders, my lord,
Let the
non-filing of
BBMP file
photo.
the statement, my lord. Let the BBMP file their, as per the provisional
He
order.
himself has admitted that he is going to remove the extra
Correct.
construction.
You should have moved for contempt.
That I need, actually, my lords, I don't have writ petition copy also. I have filed a wakalat, my lord, 2025 matter. I was.
Give a copy of the affidavit.
I'll take instructions, my lords. By Monday.
Tuesday. No. There's no seriousness. Petitioner must be present. In presence of the petitioner, you give the affidavit. I'll fix the time. You can't take it lightly. 6 months, 3 months.
It's not for only a breathing time to remove it, my lord.
I'm asking you how much time. You're saying again 6
That's
months.
what, my lord. 3 months, my lord, I shall remove it.
You keep the petitioner present.
I shall keep it.
Yes. Otherwise, I'll refer it for suo motu contempt.
Meanwhile, my application could be allowed, my lord.
No, we'll consider your purpose will be served if they remove it. We'll see what is to be. No, that we'll see. Yes, next.
78.
Monday, my lords.
Tuesday.
Tuesday, I have some, may I request for Wednesday, my lords? 10.
Wednesday.
Oblige.
Please.
78.
Filed application for vacating the interim order. My lord, here, the assistant commissioner interview.
Order was granted after hearing both the parties.
No.
Was present.
No.
My lord, now
I submit. My lord, this is assistant commissioner interfered and changed the mutations and all revenue records during the pendency of this suit before the civil court. He filed a suit for declaration, declared him as a owner to the entire extent of 4 acres 10 guntas. That was pending. He filed an application for vacating interim order, that is for injunction. That was not granted, but because he suppressed of the facts before the court. And he failed to get the interim order before the civil court. He approached the civil revenue authorities and changed the parties and everything in his name by the order of the assistant commissioner. After lapse of 20 years, 25 years from the date of entering of the names of the respondents in the revenue records. This is how the revenue authorities have interfered, my lord. The suit is pending before the trial court.
Suit for
declaration, to declare him as a owner to the entire extent of 4 acres 10 guntas. My lord, here in 2000 there was a partition, a regional partition between the parties. That there he accepted, he has taken some share and he sold his share to the third parties. Not, there he accepted the ownership of these respondents for the remaining extent. That extent again he want to change his name to show his name for as a owner.
Yes.
There are three sets of declarations suits that were filed. Two were filed by respondents. So it was all meant for declaration of title. Well, admittedly, the property belongs to my grandfather. Well, in an auction, he purchases in the year 1948. And that is produced as Annexure C, in my writ petition. Annexure B, 1949, he purchases the entire extent of land. Well, I am the grandson of the person who purchased by name Busappa. Well, he executes a registered deed in my favor concerning 1/3 portion of the land. And my lord, he retains to himself 2/3 extent. Now, after the death of my grandfather, my lord, though my mother was there, my lord, on the basis of Pauti Varsi, my lord, the respondents, who my lord are the brothers' children, my lord, would go and get the revenue entries mutated to their name. My lord, I filed an appeal before the assistant commissioner.
Now, after the death
of my grandfather, my lord, they suppress the fact that my mother was there. What they do is, my lord, they are the sons of brothers of my grandfather. So they go, my lord, and on the basis of Pauti Varsi, my lord, they get the revenue entries mentioned to their name. And it so happens that, my lord, they file declaration suit. Two sets of declaration suits are filed by them. My lord, one is dismissed for non-prosecution. No steps are being taken till today. That is what, my lord, I placed on record now along with a memo. And that is in my lord, OS number 63 of 2020. There is another suit that was filed by them, my lord, that is also dismissed for default. Now they say that miscellaneous is filed. As on today, my lord, there is no restitution. Now, as far as I am concerned, my lord, I have stated so very specifically in my petition itself, produced the plaint also, where I have stated that I have filed the suit for declaration of title and that is pending. Now, in this factual background, my lord, the assistant commissioner did not ask the revenue entries to be made in my name or in the name of the respondents. He said that let it go in the name of the original person who purchased the property. That is my grandfather. Under a registered sales certificate, my lord, his title is evidenced. Now,
as
Busappa's name.
as on date in whose name it stands?
Busappa's name, my lord, is what the assistant commissioner directed to do.
As on date.
As on day, my lord.
As on date, all the persons are, the respondents' names also appeared in the revenue records as per the register partition deed between.
My lord, what happens now is, my lord, if Busappa's through inheritance, my lord, I get the property, revenue entries will be there in my name. If at all he proves against all odds that he being the brother's son, in spite of no document being there, he will be entitled for a share, which, my lord, he has
No, the
chosen to have a declaration.
assistant commissioner, what did the assistant commissioner?
All that assistant commissioner says is, let the name be made in the name of Busappa, who is the person who purchased it under the sale certificate. Page number 83, my lord, is the operative portion of the order.
Then against that order?
Against that order, he prefers an appeal before the deputy commissioner. The deputy commissioner, my lord, holds that the revenue entries will, he sets aside the order of the assistant commissioner and says that the final decision of the OS will have to be awaited. And thereafter, the steps will have to be taken.
Till then, it has to be in your grandfather's name.
That's all, my lord, is being done by assistant commissioner.
No, then let it be in your grandfather's name.
Yes, I don't have any difficulty. Let it be there
No,
in the
no.
name of the grandfather. If at all he proves, my lord, that after Busappa's brother got the property and thereafter brother sons are entitled to that property, albeit the fact, my lord, that his
No,
declaration
so you take
is
me
already
to,
dismissed.
My lord.
take me to the AC's order.
Please, my lord, AC's order, my lord, page number 83, my lord.
Conclusion. You put.
I'll read, my lord, from the first paragraph.
No, no, sir. Just conclusion. Now let me see. If it requires hearing, I'll see.
Yes.
I just want to know
Yes.
whether the assistant commissioner said let it be in the name of your grandfather.
Please. My lord, Adesh operative portion.
Yes.
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಚಿಂತಾಮಣಿ ತಾಲೂಕು ಕೈವಾರ ಹೋಬಳಿ ಪೆರು ಮಾಚನಹಳ್ಳಿ ಗ್ರಾಮದ ಹಳೆ ಸರ್ವೆ ನಂಬರ್ 156 ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 156/1ರ 4 ಎಕರೆ 10 ಗುಂಟೆ ಪೈಕಿ 2 ಎಕರೆ 25 ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕೆಳ ನ್ಯಾಯಾಲಯದ ಎಂಆರ್ ನಂಬರ್ 4 ಗಳನ್ನು ರದ್ದುಪಡಿಸಿದೆ. ಮೂಲ ಖಾತೆದಾರರಾದ
ರದ್ದುಪಡಿಸಿದೆ.
ಮೂಲ ಖಾತೆದಾರರಾದ ಬುಸಪ್ಪರವರ ಹೆಸರಿಗೆ 4 ಎಕರೆ 10 ಗುಂಟೆ ಪೈಕಿ 2/3 ಭಾಗಾಂಶ 2 ಎಕರೆ 25 ಗುಂಟೆ ಜಮೀನಿಗೆ ಖಾತಾ ಕ್ರಮ ವಹಿಸಲು ಆದೇಶಿಸಿದೆ. ಬುಸಪ್ಪ ಮೈಲಾಡ್ is my grandfather. Now
2 acres, 2.25.
2.25. The other 1/3 mylord, there is a registered gift deed in my favor, and hence mylord 1/3 is not touched. As far as the 2/3 is concerned, the assistant commissioner says, let it be there in the name of the original purchaser, the grandfather. And whoever.
What happened? Yes, what happened before the deputy commissioner?
Deputy commissioner mylord operative portion is at page number 99. He only speaks about my suit. Their suit is already dismissed for default. That is not touched. Be it as it may, mylord. Page number 99, mylord.
No, now, as of now, the order of the assistant commissioner stated that 2/3 of the total extent would be standing in the name of Busappa, and the such entry would be subject to the outcome of the civil court. So let it remain like that. We'll see, we'll hear this matter. Let that order remain then.
What happens, my lord, subsequently? My lord, only 1/3 of share executed by the Busappa in favor of grandson, that is the petitioner. Regarding 2/3 share is concerned, is undivided property, stands in the name of two brothers, 2/3 share. But after that, the oral partition took place between the parties.
You're correct.
And they are in position, and mutation was changed. There are so many mutations. Subsequently, in 2000, I produced R3 in my statement of objections, my lord. The register partition deed. This is register partition deed, where we got, that is 1 acre, that is
No, that
1/3 share, 2/3 share, 1/3 share to the respondents, 1 to 5 to 7,
That is
and
dated.
8 to 11 is concerned.
That is
1/3
dated.
share ಬಂದಿದೆ.
That
Register partition deed backup ಇದೆ.
That
ಇದನ್ನ
is-
ರೆಫರೇ ಮಾಡಲ್ಲ ಅವರು.
that is
ಇದನ್ನ
date-
ರೆಫರೇ ಮಾಡಲ್ಲ.
that's
ಅದು ಹೇಳುವುದಿಲ್ಲ ಅವರು.
dated.
But this is dated 2000. That is one minute. 24/6/2000. Register partition deed. 24/6/2000.
The petitioner is a party.
But petition is a party. He has to, no, he is a party. He is a registered partition deed. I have produced over the. He has signed it, and he has taken some share in that. That share is sold to the third party. Where he is in that sale deed, he referred this partition deed, saying that I got this property from in the partition. ಅದನ್ನ ಹೇಳಿಗೆ ಮಾರಿದ್ದಾರೆ ಬೇರೆಯವರಿಗೆ. ಅದನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ ನಾವು.
Annexure.
Annexure R3.
This is with respect to the.
Page 11, mirror.
This is with respect to the remaining 1/3.
No. This is a partition deed.
Correct. This is with respect to that remaining 1/3.
Hello?
Assistant Commissioner stated 2/3 will be in the name of Busappa. This partition deed you're referring refers to the remaining 1/3.
Now, for 1/3 he got already. We have no dispute. In the 2/3 is concerned, 2/3 ನಮಗಿದೆ ಇದರಲ್ಲಿ. 2/3 ನಮಗೆ ಪಾರ್ಟಿಷನ್ ಬಂದಿದೆ.
Assistant Commissioner has stated 2/3 will be in the name of Busappa. That's the order of the Assistant.
Yes. 2/3 has to be added in the name of Busappa. After the partition in the 2000 ಆದ ಮೇಲೆ, where the petition is also a party, ಅವರು ಶೇರ್ ತಗೊಂಡಿದ್ದಾರೆ ಬೇರೆ ಇದರಲ್ಲಿ, ಅದನ್ನು ಮಾರಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ. ಈ ಶೆಡ್ಯೂಲ್ ಈ ಪ್ರಾಪರ್ಟಿ ಬಂದು ಅವ್ರಿಗೆ ಹೋಗಿದೆ, ಬಿ ಪ್ರಾಪರ್ಟಿ ನಮಗೆ ಬಂದಿದೆ ಇದರಲ್ಲಿ. ರಿಜಿಸ್ಟರ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್. Page 11, madam. Starts from page 11, R3.
Yes, what do you say regarding this?
I'm not privy to.
No, Lord Rashid, see the signature. Is a registered partition deed.
Nowhere, my lord, these documents have been, my lord, ever, my lord.
My lord, subsequently, my lord, one submission. Subsequently, there is another sale deed I have produced before the court.
No, this is a registered document.
Registered partition.
You're not a party, is it? No. Page 11. Are you a party or no?
No, I'm not a party.
Your lordship can kindly see the
name.
ಎಸ್ ವೆಂಕಟರಾಯಪ್ಪ. ಆದ ನಾವು ಮಾಡಿಕೊಂಡ ವಿಭಾಗ ಪತ್ರ ಏನೆಂದರೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲೇ ಇದೆ.
Venkatrayappa is?
Yeah, that is petitioner here. He put his signature.
Yes, what do you say?
But in addition to that, after taking a share in this, he sold his share to the third party as per annexure, ಎಷ್ಟಂದ್ರೆ
What do you say regarding this?
R9.
Just see the password. Just see.
R9 ಇದೆ.
Password. If it is so, then you will have to take your stand. Find out. I'll find out. Relist the matter on.
14 month.
Yes.
Number 80.
Lord, I am appearing for the respond number 4. It has become infructuous, my lord, because they have already approached the deputy commissioner in a revision petition. They have challenged him to the assistant commissioner order before this court, my lord, and the second prayer is only seeking a mandamus for furnishing the certificate copy of the assistant commissioner order. The prayer itself is, my lord, is become infructuous. No, we are not produced. He has already approached the deputy commissioner. Please see the prayer.
Only after filing of this petition, my lord, the respondent number 1, that is, assistant commissioner has produced the certified copy of impugned order, my lord. Thereafter, we have challenged the impugned order before deputy commissioner. Now it is pending.
So we'll dispose this off.
It has been dismissed, my lord, has become infructuous. They have got the interim order also.
They are trying to eliminate the
Counsel for the petitioner files a memo and submits that the order in RA 658 of 2024 has been challenged before
Deputy commissioner.
special DC.
Yes.
in RP number 377 of 2025.
In RP number
377 of 2025.
377 of 2025.
I have produced the order sheet, my lord.
In light of the same, the petition is disposed of as not calling for adjudication. All contentions of the petitioner are kept open to be considered in RP 377 of 2025. It's clarified that there has been no adjudication in the present proceeding. You file a memo stating the details of the RP. Yes.
So number 81.
No, so I appear for R5.
Now you are the purchaser.
I'm the purchaser. I purchased the property in 19.
The settlement between you and
the
grantee's family.
legal representative from grantee.
No, so I appear for R5, Manoj. I have no information. May I request for a week's time, Manoj, I'll be getting. Much of.
You are, who are you? You
I
are?
am for the grantee, Manoj.
This is the matter in the preliminary hearing list on Monday.
So number 83.
Now
Of Gromor Food Scheme.
law is now settled insofar as rumor is concerned. But the DC comes to the conclusion that I should have taken a permission. That's all it is. And after a lapse of more than 25 years, he approaches them.
So on merits itself, we can pass an order, keep this in mind.
Yes.
But merits, I have already filed my objections.
So let us see if you have entered into a settlement.
Delay and lapses are both two things that are.
Let us,
That also I have filed already.
no, correct. They say you have entered into a settlement. Find out.
I'll verify.
Yes.
Registered document. 83, Abhinav?
Petitioner.
Yes.
Annexure B has been challenged.
No, now there is a interim order in your favor.
There is an interim
What
order.
is the urgency now?
But I filed my application.
Uh,
But despite this interim order, my lord, survey is being conducted in my property. Not let them conduct the survey, my lord, in respect of the adjoining properties. It should not have any grievance. Not my property, my lord, respect the interim order, they cannot come and conduct the survey. For that reason, my lord, I have filed this application.
no, what is that got to do with your case? Your case is only PTCL. That you have to separately challenge it. How we can injunct them in this proceedings?
They cannot survey in my property is my grievance.
No, correct. I'm saying for that, there is a separate proceeding. This is only limited to PTCL Act
What
only.
has happened, my lord, is by virtue of, my lord, please take annexure D, my lord. Page number,
No, no. What are they doing survey for?
respondent, it is done at the behest of respondent number 6, my lord. Where, my lord, there are proceedings that were initiated. And I was not a party to it. That is what has been, my lord, clearly noticed by this honorable court while granting the interim order. The lords may kindly see the interim order for the moment. Counsel for the petitioner submits that the interim notice at annexure D dated 21/7/2025 has been issued by the revenue inspector Chandrayapatna Hubli calling upon the petitioner to evict himself from the lands in question within a period of 3 days from the date of the notice. Senate counsel submits that the ground on which the fifth respondent is seeking the petitioner's eviction from the land in question is such that an orders are said to have been passed in the PTCL proceedings in favor of the respondent number 6, where the petitioner is not a party. Moreover, the petitioner himself is claiming to the original.
No, you find out in what context this survey is being done.
My only limited phrase.
Let them find out. Let them find out.
Application, my lord, is you can conduct survey, my lord.
No, no, for what we have to find out why they're conducting survey. AGA to clarify the context in which annexure D was issued.
My application where my kindly be seen, my lord. What I have sought is if they want to conduct survey, my lord, they can do so, my lord, insofar as the property of one, my lord, Shamanna, son of Munishamappa is concerned.
AGA to clarify and take the stand insofar as IA2 of 25 filed by the petitioner. Relist the matter on date.
16th.
Yes.
Number 84.
Interim order and operation extended till the next date.
84, Ramesh.
Respondent number 5 in this case, madam.
Election is concerned. We have, though we have paid the Himmat, but there is, they did not consider by the way, both the State Commissioner as well as the Deputy Commissioner. That's been dismissed. And then there was Padana on the there, plus entire survey number is concerned, not there, in 7 acres 25 hectares. But here, only 3 kuntas has been allotted to the petitioner.
Now you take your stand in writing. AGA to take the stand in writing within 2 weeks from today. Relist the matter in the week commencing from
26th Jan.
Yes.
Possession has been, respondent by disturbing my possession.
No, correct. Now they'll have to take their stand.
The thing is that they are saying that we are not paid the Himmat. Himmat has been paid as per annexure B. In that 55 rupees has been paid, CA number 51.
No, your grant is still to be made by them. So we have to.
There are 3 members,
other three members are not paid the Kimatu, but only the petitioner has paid the Kimatu.
No, minutes.
Let them file their,
Respondent number 5 is disturbing my possession, my lord. That is only the interest.
no, who's the R5?
R5 is the private person, my lord. He has nothing to do with this because only he has filed and suit has been dismissed.
No, the land is of the government, no?
Yes, my lord. But now he is squatting the property in this concern. Respondent number 5 is squatting.
You find out how a private person is encroached upon your property. One sentence add ಮಾಡಿ. Petitioner submits that while the claim of the petitioner is as regards government land, if the respondent who is a private person is encroaching upon government land, the respondent authorities to look into it and take appropriate action if it is found that there's any encroachment of government land by private persons. Yes.
Date will be fixed.
Yes.
More matters.
Date, my lord.
What is it? What is it? Is serial number 1 bar.
Wait, please will also say appeal for the petitioner. This matter pertains to the illegal action.
Just 1 minute. We are at serial number 1. We are at serial number 1. Just wait. Yes.
Conversion to the land, my lord. Can you see the connection C, my lord? Page number 31.
Yes.
ತುಮಕೂರು ಜಿಲ್ಲೆ ಶಿರಾ ತಾಲೂಕು ಹೋಬಳಿ ತಾಲೂಕು 51 ಎಕರೆ 3 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ವ್ಯವಸಾಯ ದರ ಲೇಔಟ್ ಉದ್ದೇಶಕ್ಕಾಗಿ ಅಪ್ಗ್ರೇಡ್ ಆಧಾರಿತ ಪರಿವರ್ತನೆ ಯೂನಿವರ್ಸಿಟಿ ಅವರು ದಿನಾಂಕ ರಚಿಸಿದೆ. My lord, as per procedure followed by the revenue department by following the inquiry title forwarded by the Tahsildar toward thereafter assistant commissioner. So land all the revenue records will be passed on to the deputy commissioner. Deputy commissioner is the part of conversion. My lord, after conversion of the order, I approached the SUDA. The SUDA also approved the revenue. My lord, now all the annexure M kindly see that, my lord. Annexure M. Town municipality Sira has been issued a 27/10/2025. ವಿಷಯ ತುಮಕೂರು ಜಿಲ್ಲೆ ಶಿರಾ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಕಲ್ಲುಕೋಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 91/2 ಎಕರೆ 3 ಗುಂಟೆ ಜಮೀನನ್ನು ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ವಿನ್ಯಾಸ ಪ್ರದೇಶದಲ್ಲಿ ರಸ್ತೆ ಚರಂಡಿ ಹಾಗೂ ಇತರ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿ ಮುಕ್ತಾಯ ವರದಿ ನೀಡುವ ಬಗ್ಗೆ. My lord, everything has been completed. I paid the amount and to the concerned authorities. My lord, the page number 58, my lord, 58 sketch. 58, 57 photographs.
Yes.
On concrete roads has been found. Now suddenly, my lord, annexure N, my lord. Kindly see that. Annexure N. Page number 60, my lord. ಶಿರಾ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಕಲ್ಲುಕೋಟೆ ಗ್ರಾಮದ 87ರಲ್ಲಿ ಒತ್ತುವರಿ ಮಾಡಿರುವುದನ್ನು ತೆರವುಗೊಳಿಸುವ ಮಾನ್ಯ ಶಾಸಕರ ಶಿರಾ ವಿಧಾನಸಭೆ ಕ್ಷೇತ್ರ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ವಿಶೇಷ ಪ್ರತಿನಿಧಿ ನವದೆಹಲಿಯವರ ಪತ್ರದ ಸಂಖ್ಯೆ. My lord, on the base of influence letter by the local MLA that the Tahsildar has issued a kindly see that. ಆದ್ದರಿಂದ ಕಂದಾಯ ತನಿಖಾಧಿಕಾರಿಗಳು ಕಸಬಾ ಹೋಬಳಿಯವರು ಹಾಗೂ ತಾಲೂಕು ಭೂಮಾಪಕರು ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ಶಿರಾ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಕಲ್ಲುಕೋಟೆ ಗ್ರಾಮದ ವ್ಯವಸಾಯ ಉತ್ಪನ್ನ ಮಾರಾಟ ಸಹಕಾರ ಸಂಘದ ಸರ್ವೆ ನಂಬರ್ 87ರಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನಿನ ಬಾಬ್ತು 30 ಗುಂಟೆ ಜಮೀನನ್ನು ಸರ್ವೆ ನಂಬರ್ 71ರ ಖಾತೆದಾರರು ಒತ್ತುವರಿ ಮಾಡಿದ್ದು ಸದರಿ ಜಮೀನಿನ ನಕ್ಷೆ ತಯಾರಿಸಿ ಒತ್ತುವರಿ ಪ್ರದೇಶವನ್ನು ಗುರುತಿಸಿ ನಕ್ಷೆಯೊಂದಿಗೆ ವರದಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಆದ್ದರಿಂದ ಈ ಕೆಳಕಂಡ ಖಾತೆದಾರರು ತಿಳುವಳಿಕೆ ನೋಟಿಸ್ ತಲುಪಿದ 7 ದಿನಗಳ ಮೇರೆಗೆ ದಿವಸದೊಳಗಾಗಿ ಒತ್ತುವರಿಯನ್ನು ತೆರವುಗೊಳಿಸಲು ತಿಳಿಸಿದೆ. ತಪ್ಪಿದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು ಎಂಬುದಾಗಿ suo motu they issued it. Before that, my lord, all the formalities has been found. The Tahsildar himself recommended for formation of lake.
Before conversion, all would have
All
been
the
looked.
Lord, this land has now been allotted to someone else. They also have to be arrayed as parties. the Agricultural Marketing Society, Cooperative Society, my lord, para 11 of the writ petition, page 8. They also may have to be arrayed as a party.
No, we will
Also, my lord, whether the adjoining portion has been converted or not is something that we'll have to see.
No, he's saying that there is some complaint by that society.
Yes.
Stating that their land has been
Encroached.
And that is the letter given by the.
Yes, my lord.
On the basis of which they've given a notice.
Notice.
So they are saying that before conversion, approval of the plan, etc., everything would be looked into. So at this point, to state that there's encroachment.
Adjoining area may not be converted, my lord. Adjoining area may be encroached. No, conversion may apply only for his land. But if he's encroached a land, which is non-agri, which is agricultural.
So he has converted it and he has already got a plan approved. While in the conversion process, everything is seen is what he said.
But assuming it's encroached, that area may not converted.
Correct, but if it's converted, then they will have to go before the civil court and
these ones.
My lord, Annexure G, my lord.
Now you make them a party.
No, but without issuing notice to us, my lord.
No,
They're not
this is a
conducted-
notice.
But they have no right to conduct a survey, my lord, without, and the Tahsildar themselves conducted survey and issued a Level state with the assistance of ADL for formation of level before that for conversion of order. That is the procedure.
We'll give you some protection, but you make that other person a party, let him also come. We will give you protection, but you make that person as a party.
But every 63 site has been formed.
No,
Now
correct.
ready to for registration. In view of lender, my lord, I
correct.
invested huge money, huge amount.
We'll protect you, but you make that person as a party. We will consider and pass some interim order. The petitioner is directed to implead the Kallukote Agriculture Marketing Cooperative Society as an additional respondent. Petitioner submits that the notice at annexure N issued by the Tahsildar does not take note of the order of conversion of land for non-agriculture purpose and also reports of the Tahsildar during the process of conversion of land for non-agricultural purpose. It's submitted that if there is any allegation of encroachment into neighboring property, the said property owner is required to approach the civil court but cannot move the Tahsildar. Full stop. Matter requires consideration. In the interregnum, there would be stay of the notice at annexure N and proceedings pursuant thereto. AG accepts notice for respondent 1 and 2, emergent notice to the newly added respondent. This is the matter in the week commencing from. Carry it out now itself. Yes.
Serial number 2.
Hand delivery, my lord, in view of interim order.
Kodi.
Classic has been.
Kodi.
I appear for the petitioner in serial number 2.
Yes.
Lord, this is pertaining to an educational institution run by the petitioner trust. The certificate of affiliation is at page number 47, annexure C. The international school
No, what
has
have you
been
challenged?
I
What
challenge
have you
the
challenged?
I challenge the action by the BMTF pursuant to the order issued by the Tahsildar without following the due process of law. There has been no notice.
Notice is issued by?
Notice was issued by the Tahsildar, which you also should get at page number 48, annexures D. This notice is issued by the Tahsildar on 36/2025. You will also have that date, page 48.
Just. No, but this is a notice of June 25.
Yes, this is of June 25, I've submitted my objections, now sought for certain documents at page number 49, annexure E, and no documents have been furnished to me. Page number 66 may kindly see the photographs of the school, 66, 67, 68. Kindly see page number 69, the photographs of the officials of the BMTF visiting the school premises on the oral instructions by the Tahsildar in order to demolish the building. The proceedings before the Tahsildar are still pending. No orders have been passed. No
We'll
documents
have
have
it
been.
tomorrow, find out. We'll have it tomorrow. AG
Will not
accepts
ma-
notice for response 1 and 2. K. Krishna for third respondent. BMTF. BMTF? Pavan Kumar. No, government. Huh. AGF for 4. Pavan Kumar for 5. Relist tomorrow. We'll find out.
Great. In the meantime, my lord, there may
Impression.
not be any precipitative action.
Let us see. Let us see. Tomorrow we'll see. Yes.
Let them give an undertaking before this court. They do come in the early morning and do anything. No.
Nothing will happen. Let us see. You're before the court.
The school
Tomorrow.
students' education is being
Nothing will
hampered.
happen.
That is the
You call the government advocate if anything happens. Tomorrow we'll see. 3:30.
Great.
2:30. ಈಗಲೇ ಹಚ್ಚು, ಕೊನೆಗೆ ಹಚ್ಚು.
85 pass over 86.
ಆಯ್ತು 85 ತಗೊಂಡ್ಬಿಡಿ ಅಷ್ಟೇ. ಇದು ಬಂದಿಲ್ಲ.
Serial number 85.
ಬೇರೆ ಡೇಟ್ ಕೊಡ್ತಾರೆ ಅಷ್ಟೇ.
Just ask.
On that default bail aspect.
Only that's the last leg of the argument. An incomplete complaint and a defective complaint. It cannot extinguish the right of default bail. That was the submission I was on, and I was to rely on the judgments. Now, my lords, because I mentioned that the complaint is incomplete, I will just point out the complaint and then I will go through these judgments which I have given, my lords.
Yes. Yes.
Can I just pass on the complaint which has been filed?
Yes.
My lords, notice this complaint, my lords. Please notice the very front page of this complaint, my lords. What is it that the ED is investigating? My lords may notice in the right in the first page of the complaint, in the case of Buddha scam, my lords will get that in the first page. Prosecution complaint in file number so and so. Prosecution complaint in file number in the case of Muda scam. So their entire investigation, my lords, pertains to this scam as a whole. And how ED would get jurisdiction to investigate the PMLA offense is based on the predicate offense. Now, predicate offense, my lords should notice page 2 of the complaint, FIR 11 of 2024 in a table, my lords, table number 1. page 2, table is there. FIR number 11 of 2024 dated 27/9/2024. Now, this is based on the PCR that was given, referred under 156(3). There were about 4 named persons and others. And the second one we see is a PCR, Malot, a private complaint again which was filed. PCR 32 bar 2023. So it's not based on any investigation or a charge sheet that has been filed anywhere, Malot. It is based on an FIR which is still pending investigation and a private complaint that has been placed. With this, Malot, if Malot would notice.
Now this second column.
Yes, sir.
The CC number is referred to.
On a private complaint. A private complaint
No,
was
correct.
filed.
Correct. But where is the charge sheet file?
No charge sheet.
Then how is it converted to a CC?
PCR, no, but what happens in a PCR, once the sworn statement is recorded and cognizance taken, it gets numbered as CC. You don't have to wait for any.
This is a 200 complaint.
Yes, Manoj, it's a complaint under 200. So on recording the sworn statement under 200, if they're not dismissing it under 203, they will proceed with 204 of issuance of process and it gets converted to CC. So it's not a matter which is investigated. My lords would notice that, my lords, in brief summary of cause of action, just below that table, the first portion relates to the FIR that was done, and thereafter an addendum in the next page, my lords, about line about 8. Thereafter an addendum to the said ECIR was issued on 15/9/2020. I'm sorry, my lords, the first paragraph on the right hand side, line about 10 from the top. Thereafter an addendum, my lords, gets that portion.
Yes.
Addendum to the said ECIR. So first the ECIR was based only on this crime number 11, my lords. So then they themselves do an addendum to bring in this private complaint, other private complaint, also to treat it as a predicate offense. That's why we get that, my lords. Thereafter an addendum to the said ECIR was issued on 15/9/2025 after the approval of the competent authority based on CC number 60, registered by the Honorable Court of the First Additional Senior Civil Judge and CJM Mysore, registered under section 420 and 406.
CC 60 of 24 was originally PCR 32.
It was PCR 32 of 2023.
That was filed by?
One Murray Joseph, my lords, a private individual, Murray Joseph, against Stanley, who was a secretary of one Cathedral Paris Society. So the allegation is, my lords, there have been certain illegal allotments done to that society also. So they brought it under the ambit of their investigation on the Muda scam.
Now the addendum was to the effect?
Addendum was to the effect, not just the FIR 11, which will be treated as predicate offense, but we are also going to be treating PCR 32 of 2023, which has become CC number 60 of 2024, as a predicate offense. That was the addendum.
Correct, but if there's a difference between 156(3) and then converting into a CC and a CC under 200 insofar as only after notice is issued under 204, a PCR under 200 will be equivalent to at least.
Now the fundamental difference, my lords, between a private complaint and that of an FIR under 154 would be 154 would go through the reams of an investigation and ultimately we get a charge sheet under 173. But when it's a private complaint, my lords, and the court feels the complaint contains enough allegation, I don't need to refer it under 156(3). The court has the power to take cognizance on the complaint, post it for sworn statement, record the sworn statement, and proceed further to issue process.
At
But the burden in a private complaint will be on the complainant to prove his case, because he doesn't have the aid of any investigation papers. He will have to prove his case on what he has stated in the private complaint. That is the difference. It becomes a private litigation between two parties. Whereas, my lords, here state gets involved, it can become an offense against the state.
Yes.
So, my lords, anyway, so this is what they file as an addendum. And in fact, this PCR 32 of 2023, my lords, which was later CC 16, this is stayed by our High Court, my lords, by order dated 14/7/2025. It is in volume 2, page 185.
Order dated
14/7/2025.
in
WP number 20875 of 2025. Volume 2, page 185 is where we have produced it. But my endeavor is not so much to argue the aspect of the stay part of it. My endeavor is to show, my lords, how this complaint, in my respectful submission, would be an incomplete complaint which has been filed only against the petitioner when your investigation involved the entire Buddha scam. And my respectful submission is this complaint has been filed only to deny a statutory bail which the petitioner would have been entitled to.
What is the date of stay is 14/7.
14/7/2025. My lords may have page 5 of this complaint. The page nation is in the bottom, my lords. Complaint runs to about 172 pages. Page 5. If my lords 3.2, Roman number 2 is noticed, investigation in the ECIR reveals that the accused persons who are public servants, real estate businessmen, influential persons, private persons, colluded with dishonest intention and conspiracy involving criminal activity associated with schedule offense to illegally obtain sites, which is proceeds of the crime, from Buddha in the guise of compensation for land acquisition by Buddha by representing false facts, forgery, cheating, use of undue influence, etc. So, my lords, this investigation involves all these persons: public servants, real estate businessmen, influential persons, private. So if you are going to be saying your investigation involved all this, how is it that you have ended up filing this complaint against one person?
Now, if ECR is filed insofar as money laundering offences, it should restrict itself only to the laundering part of it.
Absolutely.
While
That's
the,
the second aspect which
while
I'm
the,
pointing out.
while the predicate offence relates to the.
So here, my lords, when this complaint is filed, they start on the footing saying the allotment is illegal. Whether the allotment is legal or illegal is subject matter of investigation which the Lokaयुcta police is doing in FIR number 11 of 2024. That, my lords, should get to notice at page 7. My lords, I did use the word, you're usurping the power or a culpable exercise of power. Because, my lords, ED does not have the power or jurisdiction to investigate a predicate offence. ED's role comes into play after a predicate offence is established, there is a proceeds of crime, and there is a process of activity in furtherance thereof. That is the starting point of the power of an ED to do an investigation. But here, my lords, when an investigation is pending, and the investigation is to see whether there has been illegal allotment, ED in the complaint says there is illegal allotment, there is proceeds of crime, there is process activity, we get power. That, my lord, goes way beyond the power of the ED. I'll also notice that
That you are saying is still a matter to be,
investigated, my lord. Because one part of the investigation was over. A B report was filed against the persons who were named in the PCR, and the investigating agency, they kept it open on investigation on the whole scam as such. Now, without a conclusion to that, my lords, the tearing hurry with which ED commences their investigation and they give a finding that it is illegal allotment. So, what remains to be done for the predicate offence?
now in the event the B report is filed, this goes automatically.
It goes. And acceptance of B report, not just a B report, acceptance of B report. Because Vijay Madanlal Chowdhury's case, my lords, they use the language quashment, discharge, or acquittal. They use that. And PMLA always is dependent on schedule offence. PMLA can't stand by itself without a schedule offence. So if my lords should notice page 7, my lords, they virtually conclude that this is illegal allotment. Page 7, 5.2, large scale allotment of sites by Muda in collusion with real estate businessmen, influential persons. 5.2, third line, my lords. Page 7.
Yes.
And what do they narrate in so far as petitioner? Now they bring him under the category, my lords, as one of the masterminds. Now there are many persons involved. One of the mastermind is the petitioner, which my lords should get at 5.3, page 9. Who are the other masterminds? Why is it that you have not completed your investigation against the other masterminds? 5.3, the third line.
Some masterminds have been left out.
No. So whether this
Your
get
contention, no, your contention is the predecessors are left out.
predecessors left out. The persons or in whose favor all this are done are left out in this complaint. What they do is they reserve the liberty to file supplementary complaints. So this is done, my lords, only to ensure that I can't seek statutory bail. Because beyond 60 days, I'd have been entitled to a statutory bail. So whether this complaint can be considered to be a complete complaint or an incomplete complaint.
In that Vijay Madanlal Chowdhury's case, just if you remember, which is that paragraph? Stay quashment. Which is that?
Precise point that
461.
it is there.
Huh?
461.
No, no, just.
I will give it, my lords. I'll just give that number.
No,
the
that's
paragraph
okay.
number.
That's okay. Yes, continue.
My lords, page 22, 11.1, the nature of investigation being carried out by the ED. 11.1, investigation in the ECIR reveals that large-scale scam Muda in the process of payment of compensation through criminal activity associated with the schedule offence, 22, page 22. 11. Yes. My lords may notice the broad outline of the modus operandi is described below. The accused persons are public servants. Now your whole complaint is filed against one person. Please notice the language which they use, my lords. The accused persons are public servants, real estate businessmen, influential persons, and private individuals. So how did you restrict this complaint only to one person? My lords, on the right side, page 23, the chart which they have done, criminal activities associated with schedule offence for generation of crime. Next to it, my lords, illegal allotment of sites in the form of compensation. So would this not be a case of ED investigating the predicate offence or schedule offence? On the right hand side, my lords, illegal allotment of sites in the form of compensation in ineligible cases by officers. So you're virtually investigating a predicate or a scheduled offense.
Yes.
My lords, I'll not trouble my lords with more aspect, but it goes on the same lines. But please notice, what is it that they seek as their prayer? My lords should get that at page 146. 146. At the bottom, my lords. One is to take cognizance for offences under 3 and 4. Roman number 3 may be noticed, my lords. To at the page 147, to permit the complainant to file additional complaint or supplementary complaint, if any, on completion of further investigation, which is still ongoing. They themselves admit the investigation is still ongoing. And in this complaint, they themselves say many persons are involved and they give business when real estate agents XYZ, but are not accused in this complaint.
Now, the time period is 60 days.
60 days, because it is offense punishable with up to 7 years.
That 60-day period ends on? No, that's okay. That's, yes, yes, no, that.
15/11/2025.
So, I'm just trying to understand. So, you're saying even otherwise, whatever investigation they complete, they have to finish it within 60 days. The very factum, your argument, the very factum of seeking, reserving liberty would mean, we would imply that investigation is not complete. If that were to be so, then they're eligible for default bail under 162.
167 subsection
167.
2, 187 subsection 3 of BNSS.
So you're saying this would indicate that it's not complete.
Complete. Because, my lords, this complaint is virtually equivalent to a charge sheet, because you have an ECIR and the usage of language under PMLA is investigation, and you ended up with a complaint under section 44. But that's virtually a charge sheet, my lords, after the investigation.
No, this is not same as 173(8).
Now, my lords, 173(8) is a power of the investigating officer to file a supplementary charge sheet. Now, when does this power get exercised, my lords?
That they have to move the court?
They don't even have to take permission, my lords. The whole object of getting this 173(8) was, my lords, for any reason, your investigation, you finish, you file a charge sheet. After having filed the charge sheet, and the law requires you to file the charge sheet within that time, or there is statutory bail, only for the purpose of statutory bail. Now, after you have filed it, then certain events that come across the investigating officer, which discloses there's a need for a supplementary charge sheet, events that have transpired after the filing of the complaint. There may be a case, my lords, in a 302 case, you have arraigned A as an accused. Now, it comes to the notice of the investigating officer, it is not A who had committed that murder at all, but B. He is not powerless. That is the reason, my lords, 173(a) would give him the power to file a supplementary charge sheet. It is not to seek extension of time to say that I will file my charge sheet later. The object of 173(8) is that events that come to your notice subsequent to the filing of the charge sheet is when you exercise the powers under 173(a) and file supplementary charge sheet. But now, my lords, it appears in most of the matters, it is not subsequent events, but events that were within the knowledge by the time the charge sheet is filed is being used to file supplementary charges under 173(a). That's not the object of 173(a) at all. There even contra decisions to what I'm submitting now. My submission is this is an incomplete charge sheet, and if it is an incomplete charge sheet, Supreme Court holds we can't consider it to be a charge sheet. You're entitled to default bail. Now, this is one line, my lords. However, there's a contra, my lords, which would say that if investigation is complete in respect of certain accused and a comprehensive charge sheet is filed against them, but the investigating agency has to investigate against some other persons, then the first set of persons can't have any grievance over it. That's the contra set of judgment matters, which I will point out because both the judgments has to be before the court to see which of it applies to the facts of this case. Because that second set, matters, we found Supreme Court noticed in one case, investigation took place, and then post-investigation, a charge sheet is filed against 45 persons. Then, in that, the investigating officer writes that in so far as certain shell companies are concerned, and some other persons, we are still investigating into it, we may file a supplementary charge sheet. So the persons who are already arrayed as accused, my lords, they took a contention in saying, since they mentioned that they will file a supplementary charge sheet, then it means this is not a complete charge sheet, and therefore we are entitled to statutory bail. Now that contention was accepted by the special court and they were given default bail. High Court agrees with that view, but when the matter went to the Supreme Court differed, my lords. They said so far as you are concerned, it had been done, all of you. So far as shell companies, merely they're saying they're doing a supplementary investigation that you can't take benefit of. That's the contra ruling. I will even point that out, my lord, so that we are clear.
You're saying that insofar as you are concerned, at least it should be complete.
Yes, my lord, but in my respectful submission, the manner in which they themselves have claimed in the complaint that they have investigated against all these persons who real estate, private persons, that one, this one. But when you file the complaint, it is only me. Where are the others? At least to the extent of what you have investigated, would you not have made them accused in this complaint? So you make this complaint only focusing on me so that I am prevented from applying for statutory bail. Is that the object of investigation? As I pointed out, my lord, the whole object of investigation is that it should be done speedily. So how the transition that has taken place from 1898 to now, initially 24 hours, outer limit 15 days. Thereafter, my lord, 1973, when the new code came in, they made it 60 days. 1978, my lords, edition of 167 2B, where for serious offences, 90 days. But the object is you have to finish your investigation at that time. When we look at the object and these two sets of rulings, my lords, which I will show, then the court would be in a better position to decide what is the object of an investigation to be done within a time-bound manner. So, my lords, the judgments which I relied on yesterday's set, I will just come into that. My lords, the very first judgment, Rakesh Kumar Paul, 2017, 15 SEC, page 67. Now, this is with regard to the indefeasible right of statutory bail. It was a 3-judge bench, my lords. The majority view was that of Justice Lokur and Justice Gupta. That's a majority view. And the dissenting judgment is of His Lordship Justice Pant. My lords, this particular judgment probably we missed it out, my lords, in our previous case where we were arguing under COCA, my lords. In COCA, the usage of language was 3 years or more, 2 preceding offences of 3 years or more. Somehow, my lords, we missed out. It's our mistake in missing out on this judgment. Because here, the interpretation that took place up to 10 years and 10 years and more. So up to 10 years can be 10 years. 10 years and more, it's 90 days. But if it's up to 10 years, which ends with 10 years, does not mean your statutory bail period from 60 days goes up to 90 days is the interpretation given. So up to 10 years, you have to complete your investigation in 60 days. Now kindly notice this, my lords, what the court would hold. Let's at page 'and everywhere, my lords, we get the constitutional bench ruling of Sanjay Dutt, my lords. That's a constitutional bench ruling, and that is important for the fact that before the charge sheet is filed, you should have filed your application. And that they have consistently maintained. Even now, I'm sorry, yesterday I felt, my lords, one judgment might have said even after charge sheet, but no, my lords. I've gone through the whole line of judgments. You should have filed your application before they file the charge sheet. You should have
But-
availed.
Correct.
Right.
So that is again the stand in Sanjay Dutt.
Yes. So there, if it is going to be filed after the charge sheet is filed,
Then you-
your right is extinguished. That's how they held. And repeatedly, Supreme Court has been reiterating that. And in fact, there's one case, one of they filed the application beforehand, but
Decided later.
that got rejected.
Huh? Hmm.
Then charge sheet was filed. Then they filed another application. That was rejected by the lower court. But when went to Supreme Court said you had filed it earlier. That was wrongly rejected. So we're granting this statutory. My lords, page 18 may be noticed, my lords. The importance of liberty of a person, paragraph 1 itself, my lords.
Page 80.
Page 1A. Starting point of the judgment itself, my lords. Could I just read that
Yes.
one?
Yes.
In measure for measure, the Duke complains in the given situation and liberty plucks justice by the nose. The truth is that personal liberty cannot be compromised at the altar of what the state might perceive as justice. Justice for one might be perceived as injustice for another. We are therefore unable to agree with the learned counsel for the state that the petitioner is not entitled to his liberty through what is commonly referred to as default bail, or that justice of the case should persuade us to decide otherwise. Paragraph 2. The facts in this case are not in dispute. We need not go into them in great detail, since we are really concerned with the interpretation of the words imprisonment for a term not less than 10 years. So, my lords, the argument was if it is not less than 10 years, it will include 10 years. Now, if it includes 10 years, it is not 60 days but 90 days, is what the state argued. But Supreme Court said no. If it is going to be 10 years or more, only then 90 days. If it is up to 10 years, it is always 60 days. And that is how, my lords, the majority judgment granted default bail. My lords, may kindly have page 19, the history behind the enactment of section 167 CRPC, the bottom, my lords. This is what I was pointing out, my lords. Earlier, it was only 24 hours for investigation. And in the next page, 15 days on the outside. That was what was the intention of investigation. Then they extract, my lords, 1898, which read as follows. So 1898, my lords, it would be 15 days as the outer limit, but otherwise it would say within 24 hours your investigation should be over. That was how it was envisaged. Well, it's paragraph 12, how the Law Commission notices this. Paragraph 12 at page 22. Prior to the CRPC of 1973, my lords, the Law Commission notices. And then, my lords, paragraph 13, 167 of CRPC 1973, how, my lords, it was extended to a period of 60 days, which my lords should get at page 23, provided that 60 days is how it got enhanced to. Page 23. Then, my lords, paragraph 14, 1978, where, my lords, for serious offences, they made it 90 days. Now, my lords, we notice paragraph 16 at page 25.
Yes.
My lords, this is how you cull it out, how the progression that has taken place. So 17, significance of the period of 60 days or 90 days, as the case may be, is that if the investigation is not completed within that period, then the accused, assuming he or she is in custody, is entitled to default bail if no charge sheet or challan is filed on the 60th or 90th day. The accused applies for default bail and is prepared to and does furnish bail for release. As can be seen from the narration, no charge sheet or challan was filed against the petitioner on the 60th day, but was filed before the conclusion of 90 days. Consequently, was the petitioner entitled to default bail after 60 days? According to the petitioner, the answer is an affirmative, since he has not committed an offence punishable with imprisonment for not less than 10 years. But according to the state, he has committed an offence punishable with imprisonment for 10 years. Then, my lord, the discussion on interpretation, page 26. And from the point of view of personal liberty, my lords, paragraph 28 at page 29. They deal with it on the basis of personal liberty, paragraph 28 and 29 may be noticed, my lords. The intention of the legislature on investigation. Then, my lords, coming to default bail. Coming to default bail, page 31, paragraph 34. Page 31, paragraph 34. What is forgotten is that the indefeasible right for default bail accrued to the petitioner when the period of 60 days for completing the investigation and filing a charge sheet came to an end on 3/1 or 4/1/2017, and that an indefeasible right continued till 24/1/2017. The question is whether during the interregnum the petitioner was entitled to default bail or not. Ordinarily, the answer would be yes, but in the present case, the petitioner was not granted bail and charge sheet was filed against him on 24/1/2017. Was his indefeasible right completely taken away? Then they fall back on Sanjay Dutt. But what the court then noticed was, my lords, when they were arguing the matter in the High Court, though they did not file an application in writing, orally they asked for it. That the court held was sufficient. As long as you are bringing it to the notice of the court that I am willing to give bail and the period of investigation is over, the court says that is sufficient. But that portion of it subsequently, my lord, subsequent ruling, they felt it is better that it is in writing. So, but here it was an oral request for default bail and that was considered. I'll also notice that well, it's paragraph 40 at page 32. In the present case, it was also argued by the learned counsel for the state that the petitioner did not apply for default bail on or after 4/1/2017 till 24/1/2017, on which date his indefeasible right got extinguished on the filing of the charge sheet. Strictly speaking, this is correct since the petitioner applied for regular bail on 11/1/2017 in the Guwahati High Court. He made no specific application for grant of default bail. However, the application for regular bail filed by the accused on 11/1/2017 did advert to the statutory period for filing the charge sheet having expired, and that perhaps no charge sheet had in fact been filed. In any event, this issue was argued by the learned counsel for the petitioner in the High Court, and it was considered but not accepted by the High Court. The High Court did not reject the submission on the ground of maintainability but on merits. Therefore, it is not as if the petitioner did not least orally before the High Court. In our opinion, in matters of personal liberty, we cannot and should not be too technical and must lean in favor of personal liberty. Consequently, whether the accused makes a written application for default bail or an oral application for default bail is of no consequence. The court concerned must deal with such an application by considering the statutory requirement, namely whether the statutory period for filing a charge sheet or challan has expired, whether the charge sheet or challan has been filed, and whether the accused is prepared to and does furnish bail. We take this view keeping in mind that in matters of personal liberty and Article 21 of the Constitution, it is not always advisable to be formalistic or technical. The history of personal liberty jurisprudence of this court and other constitutional courts includes petitions for a writ of habeas corpus or for other writs being entertained, even on the basis of a letter addressed to the Chief Justice or to the court.
Now, just one clarification. The default bail is a separate application. Here,
yes,
you filed.
Yes.
And then you had also arguing on the merits.
Yes.
Now, if the court were to consider only default, we could just leave it at that.
Yes, madam. If the court finds there's merit in my application for default bail, the merits need not be tested. As soon as, for any reason, whether it is an
No,
incomplete.
correct. So I'm just understanding. Suppose the court were to say the default bill is to be given, that you have filed by way of an IA.
Yes.
So the main one can be just disposed of, saying in light of this we
It does
don't.
not survive for consideration because we don't have to test the merits of the matter. But that is only the court finds substance that the complaint is incomplete or the complaint is defective. Because they did file this complaint on the 59th day. If the court finds it's either incomplete or defective, and the court feels that it has been done to defeat the rights of the person, then the default bill can.
Yes.
My lords, then paragraph 44 at page 35. Even the duty of the court, what is considered, my lords, as soon as the default bail application is there. And then after 44, my lords, they use it to the present in that particular case and grant default bail. So that is between paragraph 45 to the conclusion at paragraph 49. My lords, then we had the concurring judgment of His Lordship Justice Deepak Gupta, my lords, which commences at page 37. Page 37.
Yes.
At paragraph 58 at page 38, two issues arise for consideration. Paragraph 58, well, the two issues are pointed out.
Yes.
My lords, I will not trouble my lords with the other parts of it. It deals with all default bails, indefeasible right, and ultimately, my lords, the concurring part. My lords may notice paragraph 81 at page 45. Various judgments are considered. A reading of the aforesaid judgment leaves no matter of doubt that if an accused files an application for grant of default bail and is willing to furnish bail, then he is deemed to have exercised his right to avail of bail, and this right cannot be defeated by filing the charge sheet thereafter. This is the point which they hold, my lords. And paragraph 84 at page 46 would concur with the lead judgment. The dissent is by this Lordship Justice Fund, which we get from paragraph 87 onwards, page 47. But my lords, I will not deal with the dissenting part because the majority view was this, my lords, even if it was an oral one and if it has been brought to the notice of the court to be considered personal liberty. Then, my lords, 2020-10 SEC, page 59, Bikramjit Singh versus State of Punjab, 3-judge bench. One paragraph at paragraph 36, my lords, page 95. This is where, my lords, what we get from the Constitution bench is reiterated. A conspicuous of the aforesaid decisions would show that so long as an application for grant of default bail is made on the expiry of the period of 90 days, which application need not even be in writing, before a charge sheet is filed, the right of default bail becomes complete. It is of no moment that the criminal court in question either does not dispose of such application before the charge sheet is filed or disposes of such application wrongly before such charge sheet is filed. So long as an application has been made for default bail on expiry of the stated period before time is further extended to the maximum period of 180 days, default bail being an indefeasible right of an accused under the first proviso to section 167(2) kicks in and must be granted. So what they would say is, my lords, if it is going to be regular under the IPC offences 90 days period, if you file your bail application before the charge sheet is filed, you are entitled to bail, indefeasible right. But in case the charge sheet is filed and then you try to file your application, you won't be entitled. Now, if it is going to be special statutes where you can ask for extension of time to 180 days, your request should have been done before they ask that extension of 180 days. So, 90 days, immediately after that, you should have filed it, and then if they file the application for extension, then you are entitled to statutory bail. But if they have asked for that extension and then you file it, you are not entitled to it. That's how they have interpreted. But subsequently, they say, my lords, even this extension of time that has to be asked for should be done before the 90th. That's how they interpreted subsequently. But during this time, the interpretation was like that. They said, before they ask for extension, you should have asked for it. So, my lord, paragraph 37 on the facts of the present case, High Court was wholly incorrect in stating that once the challan was presented by the prosecution on 25/3, as the application was filed on 26/3, the appellant is not entitled to default bail. First and foremost, High Court has got the dates all wrong, and ultimately, my lord, they grant statutory. On this indefeasible right, the last judgment, my lords, M. Ravindran versus Intelligence Officer 2021 2 SCC 485, page 97. Well, it's paragraph 6 at page 109. Compulsive bail or default bail, court touches upon it. Common legal parlance. Paragraph 6 at page 109. Well, what's the object of fixing this time limit? We get it page 116, paragraph 17.6. See, if there's no time limit, then the society at large will lose faith and develop cynicism towards the criminal justice system.
17 point.
0.6 at page 116. That whole paragraph, my lords, they say if you are going to be delaying it, what would happen is society at large, that's the object of having an investigation within the time provided. And my lords, very interestingly, insofar as our case is concerned, my lords, the ECIR was registered in 2024. So it was 1/10/2024, the ECIR gets registered. I get arrested on 16/9/2025, and after all this, when they filed this complaint, filed only against me. Not that they had very little time where they could not have done some investigation into this whole scam. So from 2024, you say you're investigating, and now you file the complaint only against me. Why? You yourself in the complaint admit that so many people are involved. Where are they in your complaint? My lords, page 130, the conclusion which the court would draw, paragraph 25. (25.1 to 25.4). Very clearly, my lords, they say when you would be entitled to default bail. (25.1 to 25.4). And my lords, if you don't file your application on time, 25.3 may be noticed, my lords. However, where the accused fails to apply for default bail when the right accrues to him, and subsequently a charge sheet or additional complaint or a report seeking extension of time is preferred before the magistrate, the right to default bail would be extinguished. The magistrate would be at liberty to take cognizance of the case or grant further time for completion. So, my lords, these judgments are insofar as indefeasible right when the period are over. Now, what would be the position where an incomplete charge sheet is filed? My lords, Ritu Chabria's case. Yesterday we did have a discussion on Ritu Chabria's case in terms of what happened recently, my lords. My lords, Ritu Chabria's case was decided on 26/4/2023, my lords. 26/4/2023, Ritu Chabria's case was decided. Then, my lords, in the case of ED versus Manpreet Singh Talwar, the court, on a submission made, wanted to see whether there is a relook that has to be done to Ritu Chabria. So, 3 orders of the court in this ED versus Manpreet Singh, daily orders may be noticed, my lords. 3 orders. The first order is dated 1/5/2023. Post Ritu Chabria, which was decided on 26/4/2023. 1/5, immediately after that. Please notice paragraph 3 in that order, my lords. In the meanwhile, in the event that any other applications have been filed before any other court on the basis of the judgment of which recall is sought, my lords, is insofar as Chabria's case is concerned, Ritu Chabria, they shall be presently deferred beyond 4th May 2023. Please notice the next order that comes to be passed, my lords. That is dated 12/5/2023. In continuation, of the interim order of this court dated 1st May 2023, we clarify that the order shall not preclude any trial court or, as the case may be, the High Court from considering an application for grant of default bail under 167 of CRPC independently of, without relying on the judgment dated 26 April 2023 in writ petition number 60 of so and so. That's Ritu Chabria. My lords, next paragraph is important. Mr. So and so Solicitor General states that Union of India is in the process of filing a review against the judgment of this court dated 26 April 2023 in writ petition number 60 of 2023. Now, my lords, they filed a review. Now, that review order is dated 31st July 2025 in Ritu Chabria's case. My lords may notice in my list of citations, my lords, in my list of citations, page 146. Then I will come to the last order here, my lords. Page 146 is this review which was filed. Having perused the review petition and the connected papers with meticulous care, we do not find any justifiable reasons to entertain the review petition. The review petition is accordingly dismissed. In Ritu Chabria. Now, my lords, in this backdrop, please notice the last order in the ED versus Manpreet Singh. That is dated 12/8/2025. After the review petition was dismissed, 12/8. All that the court says is, list this matter with all connected matters before a bench of 3 weeks. Probably, my lords, the order of review was not made known at this stage, but otherwise the review was dismissed. So Ritu Chabria, my lords, in my respectful submission, what is laid down in Ritu Chabria is even applicable as of now. With this backdrop, my lords, please notice Ritu Chabria, how the Supreme Court comes down on incomplete charge sheet, and if the incomplete charge sheet is filed to take away the indefeasible right of bail, then it is bad in law. Now, my lords should have page 131 in the judgments, 2024-12 SCC 116. Page 131. My lords may notice at page 134, the writ was filed under Article 32, directly to the Supreme Court. Page 134, first paragraph. The present writ petition under Article 32 of the Constitution has been filed seeking the release of her husband on default bail. The writ petition also raises an issue of grave importance of personal liberty enshrined under Article 21 of the Constitution of India. My lords may notice paragraph 3 and 4. My lords, in a nutshell, I'll just put it across, my lords. CBI commences an investigation. CBI files a charge sheet. One person had been arraigned as a charge sheet witness. Then the investigating officer in the CBI changes hands. A new investigating officer who comes, my lords, continues further investigation, and he, in his supplementary charge sheet, would include a person who had been arraigned as a charge sheet witness as an accused. Now, my lords, once he was arraigned, he was arrested. The person was arrested. Now, once he was arrested, my lords, what this subsequent investigating officer does is, he only files a supplementary charge sheet before the person could apply for statutory bail on the ground that the investigation is not completed within the time limit. He files a supplementary charge sheet. Thereafter, he keeps filing more and more supplementary charge sheets. So then the point arose, did you file that supplementary charge sheet only for the purpose of denying that person the statutory bail. Now that is answered in the affirmative in saying this practice of yours in filing such supplementary charge sheets only for the purpose of denying a person a statutory bail is bad in law. My lords may notice the issues at page 136, my lords. The first issue is very important. 9.1. Can a charge sheet or a prosecution complaint be filed in piecemeal without first completing the investigation of the case? Now, my lords, in my respectful submission, we straight away fit into this first issue in our case, my lords. 2024, you registered ECIR, and now after arresting me on 16/9, you filed this complaint in piecemeal only to ensure that I am denied the benefit of statutory bail.
There are two ways of looking at it. One to state that insofar as the person in question, even as regards him, it is not complete. That's one way of looking at it. And the second is, since the ECIR was a larger issue, they are taking time in installments insofar as the others. But it's your argument that even as against him, it's not complete.
Well, it's probably the counter argument, it's complete insofar as I am concerned. They will not do anything more so far as I am concerned. That, my lords, in my respectful submission, in the complaint itself, when you reveal that your investigation involved so many people, and it's a case of conspiracy, how is it you would say that it is complete insofar as I am concerned? Who are my co-conspirators? With whom did I have the common intention, to put it in their words, to illegally allot sites? And their own investigation says, investigation in the case of Muda scam. So my respectful submission is, my lords, unless you're going to be putting in all the persons who you think have committed this scam, how would you say that this is complete insofar as I am concerned? My predecessor, my lords, Natasha, who is also the person who had allotted sites, for him quashment has taken place. Proceedings against him are quashed. The beneficiaries of these sites, you don't even mention, though you mention the names, they're not even accused. So how can this be complete insofar as I am concerned? Who are my conspirators, fellows? If 120B is there, they have to. They may say, my lords, we have shown who all he has allotted to. According to us, it's illegal. Which again, they can't say because that's pending consideration in the investigation by the Lokaita police. So any way we look at it, my lords, though they may contain, this is complete in all its respects, insofar as petitioner is concerned. That may not be right when they are investigating this scam.
We'll continue.
Yes.
Arguments remain inconclusive. Matters relisted tomorrow. I have released my default bail. Have a look at it. I have released a default bail one on this. On the other matters, just have a look at it.
Yes, Manoj, I will have a look at it. That is in so far as the other matter in COCA involvement is concerned, where they filed the application for extension. Please.
Thank you.
Thirdly, serial number 13. Let- One sufficient. The matter is very urgent, my lord, with request, my lord. My lord, the public, in the public interest, the division bench of the Honorable Court directed the government to take the position. Then that has been suppressed by the petition before this court after an interim order. By virtue of that, they are not implement the order. That's why the matter is that more than 100 crores of properties worth has been acquired by the petition before this
Seek
court.
for vacating stay.
I already filed an impleading application. That application is pending for last 1.5 years.
Seek for vacating stay. It will come
Implead
up-
ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. I'm not impleaded as a party.
What about that? I will still hear you.
Please.
I will still hear you because your application is not ordered.
No, it's not.
Correct. So I'll still hear you.
Please.
So you file vacating stay, it will come up in IF hearing and I'll consider.
And also I filed the impleading application also.
Consider, I'll consider.
Please.
You make request to the court officer, dates will be given.
List.
68. Sir, Monday.
Sir, list 3.
Monday.
Sir, list 3. Half month.
ಕೇಳಿಸ್ತಾ ಇದ್ದ ಮೇಡಮ್ ಏನಾದ್ರು ಲಿಸ್ಟ್ ಡೇಟ್ಸ್ ಹೇಳ್ಬಿಡ್ತೀನಿ ಕೋರ್ಟ್ ಆಫೀಸರ್
Sir, list 3 ನಲ್ಲಿ.
8-12 ಮೇಡಮ್ ಇದೊಂದು ಡೇಟ್
Three.
Serial number 6.
ಆಯ್ತು ಹೇಳಿ ಸರ್ ಒನ್ ಕೇಳಿ ಕೇಳ್ಬಿಟ್ಟೆ ಒಂದ್ ಹೇಳಿಲ್ಲ ಸಾಹೇಬ್ರು ಕೇಳ್ಬಿಟ್ಟು ಬರ್ತೀನಿ
Serial number 2, 5126, 3, 5126, 456, 45, 5126, 6 and 7, 12, 1. Serial number 9, 10, 12, 1. Serial number 11, 12, 1.
ಆಗಿದೆ ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರಿ
Serial number 13, ಒಂದು ನಿಮಿಷ. Serial number 13, 19-1. Serial number 14, 9-1, 19-1. Serial number 15, 19-1. Serial number 16, 19-1. Serial number 17, 19-1. Serial number 18, 19-1. Serial number 19, 19-1. Serial number 20, 26-1. 21, 26-1. 23, 26-1. 24, 25, 26, 26-1.
Serial number 6, sir.
Bench officer. Court officer, serial number 1.
List 3, sir.
Third list, serial number 1.
Screen ಹೇಳಿದ್ದವರು ಇಲ್ಲ ಸರ್ ಇಷ್ಟೊಂದು
Court officer.
ಅಜ್ಜನ ಸುಮಾರು
ಅದು ಕೇಳಿ ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಜನವರಿಗೆ
Court officer.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಸರ್.
ಡೇಟ್ ಬೇಡ ಸರ್.
ಅಲ್ಲ ಇಲ್ಲ ಅದು ಇಯರ್ ವೈಸ್ ಕೊಟ್ಕೊಂಡಿದ್ದೀನಿ ಅಷ್ಟೇ.
ಸೀರಿಯಲ್ ನಂಬರ್ 7 ನೋಡಿ ಸರ್, ಲಿಸ್ಟ್ 3.
ಯಾವ್ದು? ಅವ್ರು ಹೇಳಿರೋದು ಕೊಟ್ಟಿದ್ದೀನಿ ರೀ. ಅವ್ರ ಸಾಹೇಬ್ ಹೇಳಿರೋದು ಮಾಡಿದೀನಿ. 5 ಒಂದೊಂದು ಡೇಟ್ ಕೊಡಕ್ ಹೇಳಿದ್ರೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ, ಮುಗೀತು. ನಾನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ರಿಪೀಟ್ ಮಾಡಿ ಸರ್, ಇಲ್ಲ ಕೊಡಿ ಸರ್ ಅದರ
ಡ್ರೆಸ್ಸಲ್ಲಿ ಹೇಳೋದು.
ಮತ್ತೆ ಹೇಳಿ ನಾವು ಇವಾಗ ಬಂದಿವಿ ಸರ್.
ಈಗ ಡಿಸ್ಪ್ಲೇ ಆಗುತ್ತೆ.
ಮತ್ತೆ ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 7 ನೋಡಿ.
Court officer, serial number 1.
ಸರ್ ಈ ತಿಂಗಳಲ್ಲಿ
20 ಸರ್. 20 ಲಿಸ್ಟ್ ನಂಬರ್ 3.
26 1.
ಸರ್ 26 1 ರಜಾ ಸರ್. ಅಲ್ಲ ರಜಾ ಸರ್.
27 ಹಾಕ್ತಾರೆ. ವೀಕ್ ಕಮೆನ್ಸಿಂಗ್ 4 ದಿನದಲ್ಲಿ ಒಂದಿನ ಹಾಕ್ತಾರೆ. 11 ಗೊತ್ತಿದೆ ನನಗೆ, ಗೊತ್ತಿಲ್ಲ 26 1 ರಜಾ ಅಂತ.
Court officer.
ಇಲ್ಲ ಬ್ಯಾಚ್ ಮ್ಯಾಟ್ರ್ ಏನು ತಗೊಂಡಿಲ್ಲ, ಏನು ಆರ್ಡರ್ಸ್ ಆಗಿಲ್ಲ. ನೋ ಆರ್ಡರ್ಸ್ ಏನು 11 ಸರ್. 5126 ಎಲ್ಲ ಅದ ಆಗಿದೆ, ಈ ಸಲ ಮಾಡಿದ್ದೀನಿ. ಯಾವ್ದು ಹೇಳಿ? ಅಲ್ಲ ಕೊಲ್ಲಲ್ಲ.
Court officer.
ಪ್ರೀವಿಯಸ್ ಇದೆ.
ಎಂಟ್ರಿ ಮಾಡೋ ಎಷ್ಟು ಆಗುತ್ತೆ ಸರ್? ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಎಕ್ಸ್ಟ್ರಾ ಆಗುತ್ತೆ.
ಆಗಿತ್ತು ಆಯ್ತು.
ಮತ್ತೆ
ಆಗಿದೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 11
ಸರ್ ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್
11 12 1 ಸೇಮ್ ಡೇಟ್.
Court officer.
ಡೇಟ್ಸ್ ಹೇಳ್ತಾ ಇದ್ದೀನಲ್ಲ.
List 3 serial number 1.
44 ಇಲ್ಲ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
List 3 serial number 1.
ಲಿಸ್ಟ್ 3
serial number 1.
ಸಾಹೇಬ್ರ ಸೇರ್ ಮಾಡ್ತಾರೆ, ಡೇಟ್ ಇನ್ನ ಅಸೈನ್ ಆಗಿಲ್ಲ. ಆಯ್ತು ಮುಗೀತು.
ಲಿಸ್ಟ್ ನಂಬರ್ 3 23 ನಂಬರ್
ನಾಳೆ ಎರಡು ನಾಳೆ.
The list 178.
Shout out, otherwise you won't.
ಸರ್ ಗೋಲ್ಡ್ ಬ್ರಾಂಚ್ ಕೇಳೋದು ಮೇಡಮ್ ಅಲ್ಲ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
ಸರ್ ಲಿಸ್ಟ್ 323 ಇರುತ್ತಾರೆ
ಸರ್.
ಸರ್ ಸರ್ ಲಿಸ್ಟ್ 323 ಸರ್.
One week.
Submission.
ಹಾಕೋದಲ್ವಾ? ಸರ್ ಲಿಸ್ಟ್ 3 ಇದು ಏನು ಸರ್?
ಎಲ್ಲ ಜನವರಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಲಿಸ್ಟ್ 3
ಡೇಟ್ ಅಸೈನ್ ಆಗಿದೆ ಜನವರಿ.
ಅದು ಬ್ಯಾಚ್
26/1.
ಅದೆಲ್ಲ ದ ವೀಕ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಫ್ರಮ್ ದಟ್ ಅದು ವೀಕಲ್ಲಿ ಲಿಸ್ಟ್.
ಸರ್ ಅದು ಏನಿಲ್ಲ ಸಾಹೇಬ್ರನ್ನ ಡೇಟ್
ಲಿಸ್ಟ್ ದಿಸ್ ಇನ್ ದ ವೀಕ್ ಬಿಗಿನಿಂಗ್ ಫ್ರಮ್ 26 ಅಂತ. ಸೊ 26ರಿಂದ 30 ಯಾವತ್ತೂ ಆಗ್ತದೆ. ಈಗ 26 ಇಸ್ ಮಂಡೇ. ಆ ವೀಕಲ್ಲಿ ಅಲ್ಲ 26 ಆ ವೀಕಲ್ಲಿ ಅವತಾರ ಕೊಡ್ತಾರೆ.
ಹಲೋ ಬೇಕಾ ಮೇಡಮ್ ಕೊಡಿ ಫೋಟೋ 7 ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಹಲೋ ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 85 ಇದ್ದಾರೆ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ 14/7/95 ನಾಳೆ 2:30 86 ರಿಟ್ ಪಿಟಿಷನ್ 10544 ನಾಳೆ ಪ್ರಿಲಿಮಿನರಿ ಹಿಂಗಲ್ಲಿ ಬರುತ್ತೆ.
ಹಲೋ ಸರ್.
ಹಾಂ
ಎಸ್ ಸರ್ ನಾನು ಬರ್ತೀನಿ.
ಪ್ರಿಲಿಮಿನರಿ ನಾಳೆ ಓಕೆ ಎರಡನೇ ಮಿಕ್ಕಿ ರಿಪೀಟ್ ತಂದ್ಕೊಟ್ಮೇಲೆ ನಾನು ಕೈ ಬರ್ಬೇಕು ಅದು ಇನ್ನೊಂದಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿತ್ತು ಮತ್ತೆ ಕಳಿಸಿದ್ದೆ. ಓಕೆ ಹಾಗೆ ಇದಾಗಿದೆ ಅದೆಲ್ಲ
ಲಿಸ್ಟ್ 3 ಏನ್ ಮಾಡಿದ್ರಿ ಸರ್? ಅಸ್ಮಾಟ್ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ.
ಫಸ್ಟ್ ಅಲ್ಲಿ 1/2 ಸೀರೀಸ್ ಇದೆ ಏನು ತಗೊಳ್ಳಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಫಸ್ಟ್ ಯಾವತ್ತು ಅಂತ ಇದ್ದೀರಾ? ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್.
ಅದನ್ನೇ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಸಾಹೇಬ್ರು ಏನು ಹೇಳಿಲ್ಲ. ಅದನ್ನೇ ಮೇಡಮ್ ನೀವು ಅಂದ್ರೆ ನಾನು ಏನು ಹೇಳಿ ಗೊತ್ತಿಲ್ವಲ್ಲ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ.
ಚೇಂಬರಲ್ಲಿ ಬೇಕಾ?
ಮಧ್ಯಾಹ್ನ 2:30 ಅಗ್ರಿಕಲ್ಚರ್ ಕೇಳಿ ಆಗಿಲ್ಲ ಅಂತ. ಕೇಳಿ ಹೌದು ಕೇಳಿ ಧಾರವಾಡ ಫೋನ್ ಮಾಡ್ತಾರೆ ಅದು ರಮಾ ಕ್ಲೀನ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ವಾಪಸ್ ಕಳಿಸ್ಬೇಕು. ವಾಪಸ್ ಅಲ್ಲ ಸರ್, ಅದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಇದು ಆಗ್ತದೆ ಅಷ್ಟೇ. ಅದು ಒಂದು ನಿಮಿಷ
ಜಾಗನೇ ಇಲ್ಲ ಹೋಗಕ್ಕೆ. ಅಲ್ಲಿ ಬಿದ್ದಿದೆ ಫೈಲು, ಅದು ಹೆಂಗ್ ಜಾಗನೇ ಇಲ್ಲ ಅದು. ಯಾವ ಕಡೆಗೂ ಜಾಗ ಇಲ್ಲ ಸರ್ ಹೋಗೋದಕ್ಕೆ.
ಸರ್ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ರಿಸರ್ವ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸರ್ ಲ್ಯಾಬ್, ಅದಕ್ಕೆ ವೆಯ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
68 Monday.
68 ಇದು 68 ಅಲ್ಲ 78.
78.
ಹಾ 8 ಕೊಡು. ಅಲ್ಲ ತೊಂದರೆ ಮಾಡುತ್ತೆ. ಸಬ್ಜೆಕ್ಟ್ subject leaders of the prediction and any action of part A not for subject to the result of this prediction. ಆಯ್ತು ಮೇಡಮ್, ಅದೊಂದು ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀನಿ ನಾನು ಸೇರ್ ನಂಬರ್. ಅದೊಂದೇ ನಂಬರ್. ಇಲ್ಲ ಏನೋ ಲೇಟ್ ಆದ್ರೆ ಹೋದ್ರೆ ನಾನು ಲಾಗೌಟ್ ಮಾಡ್ಬಿಡಿ ಮಾಡಿ. ಮಾಡೋದು ಯಾರು ಮುಗ್ಬಿಟ್ಟು ಮತ್ತೆ ಮಾಡೋದು. ಸತೀಶ, ಇವೆರಡು ನಾಳೆ ಡೇಟ್ ಅದೇ 2:30 ಇತ್ತಲ್ಲ, ಚೇಂಬರ್ ಹೋಗುತ್ತೆ, ಸಿಗ್ನೇಚರ್ ಆಗಿ ಬಂದಿದೆ. ಮತ್ತೆ ಇದೆಲ್ಲ ಪ್ರಕಾಶ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಏನ್ ಬಾಕ್ಸ್ ಎಲ್ಲಿ? ಮೆಟಲ್ ಎಲ್ಲಿ ಹೇಳಿ? ಆ ಬಾಕ್ಸ್ ಫಿಲ್ಟರ್ ಜಾಗ ಎಲ್ಲಿದೆ? ಕೆಳಗಡೆ ಇರ್ಬೇಕು. ಹೌದು. ಹಲೋ. ಓಕೆ ಓಕೆ ಓಕೆ.
15 ಸರ್.
ಹಲೋ. ಅಲ್ಲ, ಇದು 2 ಫಿಲ್ಟರ್ ಇದೆ. ಅದೊಂದು ಆರ್ಡರ್ ಶೀಟ್ ಬರ್ಕೊಂಡೋದು. ಓಕೆ. ಇದನ್ನ ಇದು ಇದ್ರೊಳಗಡೆ ಹೋಗವಂತ ಅಲ್ಲ ಅದು ಸೀಲ್ಡ್ ಅಲ್ಲ ಅದಲ್ಲ ಅದೇ ಸ್ಟ್ಯಾಂಡ್ ಅದು ಅದ ಅದು ಏರ್ ಫಿಲ್ಟರ್ ಅವ್ರು ತೆಗಿಯಕ್ಕಾಗಲ್ಲ ನತ್ತು ಕೊಡ್ತಿಗೆ ತಿರ್ಗಿ ಹಂಗೆ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು ಫುಲ್ ಸೀಲ್ಡ್ ಅದು ಒಟ್ಟಿಗೆ ಇದೆ ಬ್ಲಾಕ್ ಕಲರ್ ಒಳಗಡೆ ಇಂದ ಅಲ್ಲಿಗೆ ಇರಲ್ಲ ಅದೇ ನತ್ತು ಕೊಡ್ತಿದ್ದ ಫಿಕ್ಸ್ ಮಾಡ್ತಾರೆ ಕೇಳು ಅಲ್ಲ ಅದೇ ಬಿಚ್ಚಕ್ಕಾಗಲ್ಲ ಅಲ್ಲಿ ಒಳಗಡೆ ಹೋಗಿರಲ್ಲ ಅದು ಮೇಲೆ ಹೋಗಿರಲ್ಲ ಅದೇ ಬಿಚ್ಚಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಅದೇ 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 ಇರುತ್ತೆ ಇಲ್ಲ 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 ಅದೇ ನಟ್ಟು ಕೊಟ್ಟು ತೆಗಿಬೇಕು ಅದೇ ಅದೇ ಗೊತ್ತಾಯ್ತು ಈಗ ಬಿಚ್ಚಕ್ಕೆ ನಟ್ಟು ಕೊಟ್ಟು ಬಿಚ್ಚಬಹುದು ಅಲ್ಲ ಅದು ಬಿಚ್ಚಕ್ಕಾಗತ್ತಂತ ಅಷ್ಟೇ ಅಷ್ಟು ಬಿಚ್ಚೆ ಅದ ಅದೇ ಮೇಲ್ಗಡೆ ಅದೇನಿರಲ್ಲ ಅದ್ರೊಳಗಡೆ ಹೋಗಿದ್ರೆ ಅವ್ರನ್ನೇ ಕರ್ಸ್ಬೇಕಾಗುತ್ತೆ ಕಂಪ್ನಿ ಅವ್ರನ್ನ ಅದೇ ನೀರೆಲ್ಲ ಆಫ್ ಮಾಡ್ಕೊಂಡು ಬಿಚ್ಚಬೇಕು ಅವರು ಮೋಟರ್ ಎಲ್ಲ ಆಫ್ ಮಾಡಿ ಮೋಟರ್ ಆಫ್ ಮಾಡಿ ಫಸ್ಟ್ ಮಿಸಸ್ ಕೇಳಿ ಯಾವ ಸ್ವಿಚ್ ಒಂದು ಆಫ್ ಮಾಡ್ತಾರೆ ಹಾ ಸ್ವಿಚ್ ಆಫ್ ಮಾಡ್ಲಿ ಮಾಡ ಎಲ್ಲ ಆಫ್ ಮಾಡ್ಬಿಡಿ ಮೂರನ್ನು ಆಫ್ ಮಾಡ ಆಮೇಲೆ ಆನ್ ಮಾಡೋಣ ಅದೇ ನಟ್ಫುಲ್ ಸ್ವಿಚ್ ವಾಟರ್ದು ಸ್ಟ್ರೈಟ್ ಇದೆಯಲ್ಲ ಆಫ್ ಮಾಡ್ಕೊಂಡು ರೆಡ್ ಕಲರ್ ಇರುತ್ತೆ ಎರಡೇನ ಸತ್ತಿದ್ದು ದೊಡ್ಡ ಸಿಗ್ಲಿಲ್ಲ ಇನ್ನೊಂದು ಓಕೆ ಓಕೆ ನೋಡಿ ಇದು ಒಂದು ರೆಡ್ ಕಲರ್ ಎಡ್ ಇದೆಯಲ್ಲ ಅಂತ ರೆಡ್ ಕಲರ್ದು ಹಿಂಗೆ ಸ್ಟ್ರೈಟ್ ಇರೋದು ಆಫ್ ಮಾಡಕ್ ಹೇಳು ಅಲ್ಲಿ ಕೆಳಿ ಇಲ್ಲಿ ರೆಡ್ ಕಲರ್ ನೀರಿನ ಪೈಪ್ಗಳು ಎಲ್ಲ ಆಫ್ ಮಾಡಿ ಅದನ್ನ ಎರಡನ್ನೂ ಆಫ್ ಮಾಡಿ. ಇನ್ನೊಂದು ಐತಲ್ಲ ಇಲ್ಲಿ ಅದ್ರ ಪಕ್ಕದ ಕೈಯಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿದೆಯೋ ಅಲ್ಲಿ ಆಫ್ ಮಾಡ್ಕೊಳಕ್ ಹೇಳು ಫಸ್ಟ್. ಎರಡಿದೆ ಆಫ್ ಮಾಡಕ್ ಹೇಳಿ. ಅದೇ ಆಫ್ ಮಾಡಿ ಆಮೇಲೆ ಆನ್ ಮಾಡ್ತಾನೆ. ಅದೇನ್ ಪರವಾಗಿಲ್ಲ, ಅದು ಆಫ್ ಮಾಡಿದ್ದೆ ಅಷ್ಟೇ. ಅದೊಂದು ಈಗ ಥ್ರೆಡ್ ಇದೆ ನೋಡಿ, ಅದ್ರ ಕೆಳಗಡೆ ಒಂದು ಥ್ರೆಡ್ ತರ ಇದೆ ನೋಡಿ ಪೈಪಲ್ಲಿ, ವೈಟ್ ಪೈಪಲ್ಲಿ ಅದಲ್ಲ ಸರ್. ಅದನ್ನ ನೀವು ಲೂಸ್ ಮಾಡಿದ್ರೆ ಇದನ್ನ ಏನಾರ ಬಿಚ್ಚಿದ್ರು ಎತ್ಕೊಬಹುದು. ಫಸ್ಟ್ ಅದನ್ನ ಬಿಚ್ಚಕ್ ಟ್ರೈ ಮಾಡಿ ಅದನ್ನ, ಅಷ್ಟೇ ಸಿಂಪಲ್ ಅದು. ಅವ್ರ ಟೂಲ್ ಇಲ್ವಾ? 15 12 ಹಾಕಿದ್ರು.
List 3 ಇದೆ.
15 ಅಲ್ಲ, 15 12 ಅದು ಮಾತ್ರ.
List 3 ಯಾವುದು?
ಇದು ಮೇಡಮ್ ರಿಪೀಟ್ ಮಾಡಿದ್ದೀನಿ ಇವೆರಡು, ನಾಳೆ ತಗೊಂಡ್ಬರ್ಬೇಕು.
15 12
List 3 ಅಂತ